Yes. When was it filed? When was it filed?
Which court number?
It will come. It will come. Yes. What are you doing from the last 1 month? Then, so please see, it's not possible for the court to take all the matters at the back end of the vacation. Please give it to the court officer. As for the court's convenience, it will be taken. Yes. Huh? Huh? It is a fresh matter. Why? Please don't make a mention about the fresh matters. They'll come. Yes, no mentioning for the fresh matters. Fresh matter or a pending? If it, why it has not come, please find out from the registrar. Yes.
This is an interim maintenance project only, it's a fresh matter.
ಯಾವ
Observation has been raised by the office. With regard to page number of the preamble, I have made a submission, but what is stated is that if there are office objections, it wouldn't be put up before the court is what is mentioned. But that office objection, what they have raised is that it cannot be complied at all.
What is office objection?
We have put the page number of continuation, page number 2, Roger. They are stating that the first page is not produced, but that itself is the first page of the preamble page. But that is the first in the in the assets and liabilities, Roger. In the last page, there are 2 dots and continuation page number 2. That is the next page. But they are stating that because of that, they are stating that the first page is not available. So they are asking to produce the first page of their assets and liabilities.
Look at it. Yes.
There is a DRT matter.
Please don't come from there. Yes.
There's a DRT fresh matter that outstanding balance is 8 lakhs.
It will come.
Already paid.
It will come. Yes. It will come. Yes.
This is not fresh matter pertaining to the interim custody of the girl child. I appear for the petitioner wife, my lord. I am seeking the interim custody during this December vacation. Girl child, she is.
I think the court should stop entertaining these visitation matters at the fag end of the vacation. That's what they are doing. Why can't it be moved much earlier?
My lord, actually.
Because like some order or the other, they can get away with.
It was referred to the mediation, my lord. It is paid.
Look, take that. We will see fresh matters. Just find out why they are not coming. Yes.
My lord, order has been passed into section 14, my lord, of the Surfacey. I had moved this matter, my lord, on Friday. My lord directed me, my lord, to comply with the office objection, which I have done. The registry, my lord, has not posted the matter for the reason, my lord, that there is no memo moved. My lord, may kindly take it up at 2:30, my lord. There is an urgency.
Why? What is this? When we are giving them, no, not asking. When we are giving them specific directions to post, why they asking the advocates to make a memo and waste the court's time?
Morning only I instructed that section officer why you are telling like this when there is a standard instruction from the branch.
Ask all those that MFA, DRT and this FC matters, why it is happening, ask the registrar judicial.
Yeah.
Yes.
Publish.
Request is for amount 230 the urgency is I have an arbitration award in my favor.
Whatever it is, no lunch motions. That much I am clear.
Then tomorrow request.
It will come. It will come. If the office objections are complied with.
I'll request for tomorrow for based on this urgency, the auction. After I obtained the arbitration award, I requested the bank that I will pay the
In your auction notice is issued.
My lord, it has been, the auction is completed, my lords. Now they're trying to conclude the sale.
When was it concluded? When was the
Friday, my
auction?
lords, Friday was the auction, my
We'll
lords.
see. We'll see.
My lords, I have nothing else to recover other than this property, my lords. And if they are trying to conclude the sale with the auction purchaser today or tomorrow, my lord, that's why, my lords.
Take it. Yes.
My lords, tomorrow.
Yes. Next. Decide.
1818 is listed before.
Take it. All fresh matters. Give it to the court officer. We'll find out. But I will not. I'll not give any date.
Subvention matter.
Can you, my lord?
It's coming up 1712.
My lord, in this. Sir, fresh matter.
It has to be tracked along.
Fresh matter.
With my lord's kind permission.
My lord, in
This matter that is coming up with the batch Tagged along with the badge, the one which is giving.
Yes, ma'am.
This also.
Permission.
Yes.
But in this, in family court matter, my lord, I filed a petition for, regarding maintenance of the petition under 125 because it's a major daughter. But then, your lordship had posted it to, and summons was issued to the advocate on the in the lower court. Subsequent to, we have already served and the matter has not been listed for the last 3 months. I've been moving memos, but it is not coming up. The matter is
When
posted.
did you move the memos?
I moved 2 times. I have moved the
When
memo.
did you move?
I've already moved, but it is not coming up before the
That's
court.
what I'm asking. When did you move the 2 memos?
10, 11, I moved once, and last week also I moved one more memo, but it is not coming up. my lord.
What is urgency for that now?
Lower court has posted the matter for orders on the IA on 17th. That may be listed up tomorrow.
Why it is not listed, find out. Yes.
But this matter was dealt in the chambers, was taken up in the chambers, it could not get settled. There was no urgency, however, the other side, I'm told, has moved a memo and it has been posted to 18th. I'm not available from 17th evening because I'm traveling a lot. Can I request this to be taken up
How can
tomorrow?
it be, all the, they move one memo,
Really sorry.
when the matter comes up, we will see, how can,
But I'm
for
not
that,
there, I'm not
that day you
able to
tell your
take
colleague to seek for an adjournment, and what is their urgency, we don't know.
Look, if your lordship recollect, they had alleged POXO and they are taking a stay where family court has granted overnight visitation.
That's what, now, like, one memo on that, another memo, that we can't entertain, when the matter comes, I'll see, yes.
One request, at least on 17th, I'll be able to somehow attend Millards. Because 18th it is posted, so.
Now, at this point of time, I can't accommodate any of the matters like that, yes.
Pending matter, my lord. To address the argument on IA number 1, my lord. The trial court has posted the matter on 19/12 for judgment.
What is that?
My lord, family court matter, my lord.
Which year it is, which year writ petition?
My lord, 25.
When did you file that writ petition?
My lord,
Because the difficulty is, how do you expect these many matters to be taken up by the court? There should be some valid reason for making mentions. Yes,
I'm a farmer, my lords. My agricultural crops failed, hence I failed to repay back the bank amount, my lords. And now what has happened, the bank is taking the actual possession of my property, my lords. Hence, being aggrieved of the same, the auction is likely to be held tomorrow or day after, my lords. Hence, the matter may be posted tomorrow, my lords.
We'll
I'm
see.
ready to pay the amount, my lords.
we'll
No
see
doubt.
once the auction notice is issued, whether it is conducted, not conducted, everything is one and the same. We can put the clock back if it is, there are legal grounds, yes.
My lords, I'm only constrained to file this and move this memo because there is a possibility of a court-assisted abduction of my child. So the issue here is on the
The
10th,
court assisted abduction.
my lords, on the 11th, there is a direction of the Honorable Family Court by way of which the party is restricted from taking the child outside of the country. On the subsequent day, they file an application seeking permission to obtain a US visa. My lords, that interview is scheduled. My lords, the intervention of this Honorable Court is paramount.
Order passed,
Order was passed on Friday, my lords, Friday evening.
this tomorrow.
Please, grateful, my lords.
Lords, we have completed the terms of the OTS, Lords. Lords, paid the entire money. Lords, instead of returning the, Lords, the documents,
With a fresh matter.
Lords, the notice is issued, my Lords. They have not, they have filed.
Let's see, what is that?
Lords, no, they have, yesterday they have issued 13 to notice, my Lord. Without not taking into note of the OTS payment made by me, Lord.
You should have told them that.
I told them, Lords,
No.
I have not,
No,
what
please
happened,
wait.
Lords, I have.
Once the 13 to notice is issued, you will get enough time.
Lords, I will get enough time, Lords.
Reply.
Lords, how can they issue, Lords, once they have taken the
No,
money?
that is not a ground to come to the court.
Lords, once they
That
have
is not a ground to come to the court. Tell them that you can't take what you want to tell to the court. Tell them, tell the same thing.
Lords, this is the time.
We will not take in this, before this side of the vacation, no
After
urgency.
notice, Lords, after notice.
Might be, no coercive steps as of now. 13-2 is just a demand notice. You can respond to that.
13-2, Lords, they are claiming the entire money, Lords, in spite of taking the OTS, Lords, accept it. Lords, let them return my OTS, Lords, I will apply to
That
the-
is now, it is a
13-2,
premature writ petition.
No, Lords, petition was filed earlier for just, Lords.
As far as 13-2 is concerned, please reply to them.
Lords, I'm not on 13-2, Lords. Lords, let them, Lords, give me documents, Lords.
Now the court, unless and until it is urgent, court will not take up the matter. There is no urgency
Lords,
according to the
urgency,
court.
Lords, kindly say 13-2 is issued.
Yes,
Lords,
next,
without taking-
next.
Lords, this is, Lords, Lords, they are- petitioner, no, she's lady, my lord, she is 80 years old lady.
I think I have
Lord,
rejected your
Lord,
request.
she has to be thrown out of the, my lord,
I have
premises, my lord.
rejected your, how it will be thrown out, tell me, under 13(2)?
Lord, after 13, my lord, they will go to, my lord,
What is the time limit between, what is the time between 13(2)? What is the time for your reply? What is the time for their
Ensuing
reply?
vacation is also there, my lord, not my.
That's why you
my
calculate the
apprehension
time
is
and
this, my
tell.
lord.
I'll not take
Apprehension,
it.
my lord.
Yes, next.
But,
Lord.
my lord, this cannot be, my lord, the threshold cannot be, my lord. Kindly hear me, my lord, one minute, my lord. I will ask-
File it. I will not grant any memo. If it is listed, it will come. Then I will hear.
Lord, this is after notice, my lord, even after 1 year, it is not listed, my lord.
So now it is urgency. After
Urgency, 13-2 is the urgency.
Yes.
Lord, the matter is regarding,
Lord,
I will
kindly
not.
think, Lord.
If it is, if you file it, it will come. Yes.
Lord, the matter regarding visitation rates, my lord. Lordship interacted with the kids in the chamber. Thereafter, the girl child was asked to go before the mediation center. And mediator was asked to submit a report. A report is submitted. The matter was ordered to be listed on 2011. Matter was listed. Lordship was not sitting on that day. Therefore, no order is passed.
Yes, someday this week.
Please.
Yes, call the list.
Page wise adjournment.
Huh?
Page
Huh?
wise adjournment, I will be calling at that time. Page wise adjournment, some adjournment is seeking.
Yes.
Page number 4, list number 1, serial number 4, page number 4, 12 and 13, page number 5, 14 to 23, page number 6, 24 to 30.
20? What do you want?
Just adjournment, because I don't have proper instructions, because party was.
This is matter after vacation. At the request of non-counsel petitioner.
Page number 7, serial number 31, 32. Page number 8, serial number 33 to 36.
They have no objection. At the request of non-counsel petitioner, is this matter after vacation?
Lordship, serial number 33.
It is submitted that. it's
I
already informed
oppose
to the-
33, I oppose your lords.
Lordship, petitioner advocate is expert.
Please, your lords, what has happened was,
Petitioner advocate is expert. Notice has to be filed.
please, your lords, what has happened? OTS was granted to them.
No, please understand, petition advocate is no more.
Lords, it is not, it was, he died much prior to it. Now the fourth time this matter is coming up. Lords
We
Mahanti,
will see when the matter reaches.
Please,
Yes,
Your
next.
Page number 9, serial number 37 to 38. Page number 10, serial number 39 to 45. Page number 11, 46 to 56. Page number 12, 57 to 64. Page number 13, 65 to 72. Page number 18, serial number 73 to 76.
Lordship 76. We have informed the other side advocate.
Yes, after vacation, at the request of non-counsel petitioner.
Grateful, Your
Submitted
Lordship.
that they have informed to the other side. Yes,
Serial number 75, my lord.
70?
75, my lord.
Hmm.
1 week.
Shankar
responding.
Reddy, C.
Have you informed, you're representing Mr. Shankar Reddy?
Shankar Reddy, my senior. Senior, man.
No, you're representing him.
Shankar
Have you
Reddy.
informed the other side?
I inform.
Yes, after vacation.
Page number 15, serial number 77, 78.
Lord, serial number 78, the parties have entered into compromise, my lords. It may kindly be taken up at 2:30 to record the same.
2:30.
Grateful.
Page number 17, serial number 80. Page 1, for being spoken to, serial number 1, Gurdev Prasad Keti, for appellant, N. Krishna Swamy.
On the same issue, division bench of this honorable court has heard the matter and again it is posted to 17/12 on the same point with regard to the driving license. New act is not applicable so far as this case is concerned because the policy was issued
No,
under.
it's not about policy, it's about the accident.
No, even under the act itself.
Let's see.
That is why on the same, Krishna Swamy was arguing on behalf of the respondent, he only took time till 17. The 47, 147(4) clause 4.
Hmm.
Notwithstanding anything contained in this act, a policy of insurance issued before the commencement of the Motor Vehicles Act Amendment Act 2019 shall be continued on the existing terms under the contract, and the provisions of this act shall apply as if this act had not been amended by the said act.
Hmm.
Therefore, the policy was issued on 11/2/2021.
Where is Mr. Krishna Swami?
That is why same,
After-
on the same issue, the division bench has
Anyhow, what is the interpretation on this? Act is very clear. Let
Yes.
him submit. Pass on. Yes, next.
Sale number 2. Sale number 2.
I have filed an affidavit undertaking affidavit before this honorable court. Based on my undertaking affidavit, this honorable court has disposed the petition with the direction to hand over the possession. Well, till today, they have not handed over the possession.
Order copy was not available, my lord, and
Have you paid the amount? You are representing before the court. Is it not? When is the final order passed?
10th, my lord, on 10th, the order was passed.
How do you expect the court to, by this time to even to upload and that order should come to you? Then what is the purpose of representing before the court? Isn't it? When the advocate is represented, you should communicate it as if your client is before the court. Has he paid the amount as per the settlement or not? Then what your bank says?
they upload a certified form.
Unless until that they will not do it. Ask your officers to come to the court.
Kindly pass out.
Let your officers behave like, don't behave like this. Tell them, if as per the order, you were there, you know what is the order, subject to payment of so and so, this court has directed that the document should, you should put back to the position, or what is that? The position to deliver the,
Deliver the possession.
yes, it should be done by afternoon, or else you tell the officers that I'll take a suo motu contempt on this. Yes.
Page serial number 3 for dismissal. Shailesh Kumar R.
Yes.
Corporate for respondent, my lord.
My lord, they seek adjournment series stating that they will withdraw the case. Today they are.
This matter came up on 4/12/2025. There was no representation on behalf of the matter. Directed the matter to be listed on 9/12/2025. On 9/12/2025, again a request was made on behalf of the petitioner. Hence, this court has directed the matter to be listed at the same caption. On today also, there is no representation. Hence, dismissed for non-prosecution.
Serial number 4.
Appellant, my lord, bearing for entire amount
David,
deposited.
respondent, my lord. Now is served the appeal memo, my lord.
Copies served and
Yes.
copies served and the entire amount deposited.
Respondent.
After deducting the TDS. Hence, it may kindly be stay, may kindly be
My lord, now is served the appeal memo, my lord.
They know very well what is in the case. Liability and quantum both challenged.
No. At the time of, at this stage, I don't think we need to hear you.
Yes, ma'am.
It is their appeal. For granting stay, we don't have to hear you.
My lord, is only previous ground, my lord, that is.
What is this? What is the amount that is granted?
12 lakhs, my lord. 16,60,000, my lord.
16 lakhs?
60,000.
It's a case of death or injury.
Injury.
67% is disability.
Disability, there's no,
What
there
is,
was
what
no doctor's evidence.
1 minute. What is the disputed amount?
Disputed amount is 12 lakhs, my lord. Only injuries, there is no doctor evidence at all.
Let's,
67% they have taken.
let's, you have not examined the doctor?
It's not the treated doctor, my lord.
Not necessary. That's a settled law.
Expert doctor.
Not necessary.
PW4, my lord.
No, I'll pass out this matter.
Only
Please-
grievous injuries they are.
Please tell the court, calculate what is the admitted amount. On that, I'll grant. You please calculate and tell the court. Afternoon. Yes, next.
Serial number 5. Mahendra G.
Petitioner in this case.
It's an interlocutory order.
Please, Minutes, I may be permitted to convert to the writ petition.
RPFC is filed against an interlocutory order, and the office has raised an objection with regard to the maintainability under section 19(4) of the Family Courts Act. Land counsel for the petitioner seeks, you want to withdraw or convert?
Convert, my lords.
Land counsel for the petitioner submits that. He'll convert this to a writ petition. Accordingly, RPFC is disposed of giving liberty to the petitioner to convert this RPFC into a writ petition. Yes.
Much of it.
Since it is disposed. Yes, 6.
Yes, they are ready to settle within 3 months' time now.
Affidavit.
I'll file it.
46 lakh of the outstanding balance not. From 3 years, they are enjoying the interim order. Till now, they are representing the bank and they are not even after interim order.
Why should we continue this?
Yeah, I spoke to the petitioner. He said he'll settle the matter with 3 months' time. Bank, he has spoken to the bank. Also.
Settling the matter. What is settling? Why will they come?
They have told that they are going to waive off the interest and all. They have told.
Is it so?
He spoke to the concerned officer.
I will list this matter on Thursday. By that time, there should be an undertaking before the court. Whatever, if you want to approach the bank, please approach. If on that day the affidavit is not filed, stating when are you going to pay the amount, I'll vacate the stay and dismiss the petition. Land counsel appearing for the respondent, bank submits that. The outstanding is 30? 30? 36 lakhs as on today. As on today. And the petition is enjoying the interim order from the last 3 years. It is submitted with the land counsel appearing with the petitioner. Petitioner has already approached the bank and the bank is ready to waive off the interest.
Instruction that
Instruction that the bank is ready to waive off the interest. Next one, the petitioner shall file an affidavit before this court by Thursday when he is going to pay the amount. If the affidavit is not filed by Thursday, this court will dismiss the writ petition on that ground, as this court do not see any legal grounds in this writ petition. Yes, to entertain this writ petition. The 7th. Thursday. Yes, next.
Cell number 7. Rakesh B. Bhatt.
Appearing for the petitioner, my lord. Filing the memo for withdrawal shall be dismissed based on this.
So enjoying the interim order from 8/4/2024. Have you complied with the interim order?
Lord, I plead my ignorance, my lord. I'm a freshly appointed counsel.
And happily that is extended from time to time without even complying with the interim order. Why you want to withdraw now? Yes, the memo is fetching to withdraw the writ petition. Dismissed as withdrawn.
Cell number 8.
Memo is taken on record. Yes.
I seek to assist on behalf of the petitioner in this matter. My lord, lordships will recall to lordship's memory, my lord, this is a matter where floating rate of interest was one of the terms of the loan and fixed rate of interest was what was imposed by the bank. And my lord, the submission was made, my lords, from the bar that we shall explore, my lords, possibility of settlement. There has been, my lord, substantial round of negotiations between the petitioners and the bank. The only difference, my lords, is with respect to 30 lakh and odd rupees, my lords, out of the 5 crores that, my lords, the petitioner is liable to pay, which, my lords, though the original loan amount was 3 crores, the computation of the bank says, my lords, the interest is added and they have, my lords, now summed it up to about 5 crores. Lordships may kindly have it, my lords, by the end of this week, my lords, we shall report settlement.
Have it after vacation.
Very good.
Yes, this is matter after vacation.
Interim order may kindly be ordered. Interim order has been complied.
Interim order is extended till the next date of hearing.
Please, I'm deeply obliged.
Cell number 9. SV Bhatt. 9 SV Bhatt.
Lordship, I'm for the
Success
appellant.
respondent.
My lord, there was an amendment that has to be done. My lord, it has been left out by us by mistake, my lord. We will do it within the day.
What is this matter about?
This matter, my lord, the auction was conducted.
I'll just place this on record.
5-3, my lord, before the auction, they filed the writ petition. 7-3 was the auction. The court was where refused to grant any interim order. Then, my lord, on 19/3/2025, and they paid the entire amount accordingly with the sale certificate. My lord, again, my lord, they paid for the interim order before this honorable court, before court refused to grant the interim order. And my lord, the last order, I will permit you to read the last order, 3/4/2025. Seventh writ petition. The last order. My lord, the learned counsel for the Siddharth Kumar filed a pleading application seeking the learned counsel would submit the pursuant to the sale which was held on 7/3/2025. The sale is confirmed in favor of the auction purchaser, and the sale certificate is also issued in favor of the auction purchaser. And the auction purchaser has paid the entire amount of 20 crores 12,50,000. All that remains is registration of the sale certificate before the jurisdiction of the registrar. The learned counsel for the
So nothing is there. There is no order.
Nothing.
There is no order.
Yes, this is smart.
Your Lordship,
They have to file such being the case approved by the measures initiated. My lord,
Where is your senior?
my Lordship, he is not able to come to court today, Your Lordship.
The alternative remedy is
It may be taken up after
May I make
vacation,
one
Your Lordship.
submission, my
Kindly
lord? I am
take
the
it up
impleading applicant, which my application was allowed. Sale certificate is registered pursuant to directions of this honorable court. There are two orders.
Nothing is stalled. You're right.
Nothing is told, my lord. As of now, because their prayer is infructuous, they have challenged the sale notification. It's not a sale notice itself. The
Lordship,
prayer
kindly
is
take it up
infructuous.
after vacation, Your Lordship. My senior will come.
My lords, may kindly see the prayer. That's the only thing, my lord. I'll just point my lords.
To come tomorrow. This is matter tomorrow.
Yes, Your
Please.
At the request of non-council petition.
No, there's also one more matter, 14004 pertaining to the very same issue. That was not
So and so.
14004.
Write on paper and give.
Yes, I'll do that.
Yes,
I'll do
Ken.
that.
Sale number 10.
Lords, I appear for the petitioner in this case, my lord. I am the father, my lords. And before your lordship, my lords, the impugned order, page,
Advocate name for whom served is not shown in the memo.
my lords, it is Satvik, my lords. He has written his name along with the KR number, everything, my lords. I have produced
Then we'll hear once we list the name of what is the.
Satvik, my lords. On
It is
1911 I have
submitted that
filed.
as per the order of this court, hand summons were taken by the petitioner and served on the advocate appearing for the respondent and filed a memo to that effect. Registry is directed to put in the name of Mr. Satvik as a counsel for the respondent. Is this matter day after?
Sale number 11.
Obliged.
Sale number 11. K. Chandana Tarika.
Petitioner, my lords, seek for a passover, my lords.
What is this counsel?
My lords, council submission, my lords, is that annexure D, my lords, it's an account statement. The officer raised an objection saying that the council submission may be, the account statement may be typed. It is only,
R2 details not forthcoming at cause.
my lords, and R2, my lords, the father name is not shown in the demand notice also. For that reason, my lords, the respondent number 2, father name is not known. And we are not claiming any relief as against respondent number 2. Only respondent number 1, my lords, we are claiming relief because demand notice is being challenged.
This password.
Grateful, ma'am.
Yes, 12.
Sale number 12. Hearing on interlocutory applications.
I was praying for recall of the order, dismissal for non-compliance. In a week's time, I will comply with the.
Why you are not compliant?
Well, on the particular day, I was engaged in other courts.
So that day, it is not dismissed for default.
No, it's dismissed for non-compliance.
The time must have been given.
It is given, my lords, but just 2 objections were missed.
No
I will comply with the
representation on
same.
appellant side on call. As per office endorsement, office are not compliant. The appeal was filed on until no office objection. Why are you not complying the office objections of
No, I had complied, only 2 was left out by.
pending consideration of fine number 1/25? The petition, the appellant shall comply with the office objections. List is matter after vacation.
Obliged, my lords.
Sale number
Yes, second.
13. Harish MG. Vachan Gowda.
Yes.
Here for the appellant, madam. Delay notice to be issued.
Notice.
Sale number 14.
Self-fall from two-wheeler, my lord. No other vehicles, self-fall. It's a case of self-fall. Police have filed a charge sheet, abetted charge sheet against the deceased. 5,75,000 has been.
Then counsel appearing for the insurance company submits that is a self-fall, and in fact, the charge sheet is filed against the deceased himself. Still, the insurance company is held liable to pay the compensation considering the submission. Stay 50%, 4 weeks. Notice to the respondent.
Sale number 15.
Limitation, my lord.
No, just now Mr. Gurudev Prasad was showing, as per the act, it says, it is referring to the policy. not to the accident.
I know, my lord, but it is not issued policy prior to the accident.
When is this, when is the
Please.
policy?
My lord,
But generally,
18.5.
everybody is referring to the accident.
No, no.
But the act is
I am
about the
not filing
policy.
that. I am not filing.
Not you, but generally everybody is saying an accident has taken place.
My lord, 18/5/2023.
Is the policy.
Policy issued 8/2023 only, my lord, prior to this.
Now it is a case of no driving license.
No, my lord. Barred by limitation. That issue is pending before the.
How many, after how many
Please,
days
my
it
lord.
is passed?
Please, my lord. 25/6/2024 they have filed, my lord. 18/5/2023 is accident.
18/23. After nearly 1 year.
After lapse of 1 year, my lord.
Land counsel appearing for the appellant submits that the complaint is filed nearly after 1 year from the date of accident. It is barred by limitation, and in spite of the same, the court had granted it. And it is submitted that the policy is issued after the amendment. And still the insurance company is held liable to pay the compensation. Same 50%, 4 weeks notice.
Cell number 16,
Notice,
cell number 17,
notice,
cell number 18,
notice,
cell number 19,
notice.
cell number 20.
Notice may be dispensed for R1.
Memo is filed second dispensation of notice to R1.
Matter has been settled, may be referred to local. This matter has been referred to, may be referred to local.
At request, but who appears for the respondent?
Sivanagowda.
Huh?
Sivanagowda.
Mr. Sivanagowda is directed to take notice on behalf of the respondent. Number 2.
Please.
One is dispensed with. List this matter before the Lok Adalat. Next 20.
20,
I sought for dispensation of notice.
20.
I sought for dispensation, it has not been notice as
notice to whom,
To
sir?
whom?
respondent number 2, the
As
dispensation
R2,
for R1.
R2 memo is filed second dispensation of notice to R2. Dispensed with. I thought she's the one regularly coming, so I was telling the regular orders.
Previously, she's coming.
Oh, yes. 20, dispensed with to R2, R1. R1, notice to R2. Next 21.
Cell number 20,
Notice.
you don't.
22,
Notice,
notice,
cell number 23,
notice,
cell number 24, 24,
no representation after vacation.
cell number 25,
We have 192 days.
Notice to the respondent,
No, let it.
notice to the respondent. Yes,
cell number
27.
26, 25,
26, sir.
26 addendum after.
Yes, 27.
Cell number
For the
27,
petition in this matter, Your Lordship, I'm also pressing for my stay in this matter.
Notice.
Admittedly, the petitioner was placed ex parte because she admits in her petition that I was not residing there and this
Notice to the
is.
respondent.
cell number
The
28,
date may be fixed
Lord,
after
let me
sir.
appear actually for the petitioner, Lord. I'll take out notice,
Yes,
28,
28. Yes,
delay of 120 days. I'll take out notice, Lord.
notice,
Obliged.
notice,
cell number
notice.
29,
29, my lord, sir. There is emergency attachment has been issued. In this case, my lord, 9,000 is awarded. And the respondent, my lord, was
What
praised.
is your salary?
Salary, my lord, they claim that I am working as a coolie.
Not claiming, what about you?
40,000, my lord. I am a coolie, my lord. Per day, my lord, 500 to 600 rupees I will earn, my lord. They claim that, my lord, 40,000 rupees, my lord, and there is no
Why
document.
did you not contest?
My lords, I have filed wakalat, my lord, due to some miscommunication between the advocate and the my lord's party. They could not file the objections.
Also,
my
the
lord.
petitioner submits that the court had granted 9,000 as maintenance, whereas the petitioner's income is 500 per,
He's working as a coolie and agriculture.
working as a coolie, and it's per day. His income is 500, paying an amount of 9,000. Difficult for the petitioner, considering the same. They shall receive of all further proceedings on the condition that the petitioner shall pay 5,000 the 5th of every succeeding month, and arrears at 5,000 within a period of 12 weeks.
Please.
Notice to the respondent.
cell number
30,
30, Akesh,
845 days, notice.
Please.
cell number 31,
Yes, 31.
31. Rudra copy,
Who moved the memo? Look at it.
this SN Keshava Bhatt.
Hmm?
SN respondent moved.
You appear in this matter. 31.
31, sir. SN Keshava Bhatt for respondent.
Yes, no representation after vacation.
Sale number 32.
Wherever
Hello.
this no representation matters, don't extend the
Yeah.
intermodal, just after mediation. Where it is
32, my lord.
represented,
Sale number
I am
32.
filing objections today, my lord, to the two IAs filed by the respondent.
Writ petition is not matter.
that we will see.
The thing is, you have challenged the appeal allowed by the ART before DRA. You have appealed before Chennai.
We'll see that.
RA 56 of 2024.
We'll look at it.
Can you see the prayer method?
Yes.
Sir, ಯಾವ್ದ್ರಲ್ಲಿ 32.1?
32.1, 12,570. 12,570.
My, this is pertaining to 32.1, my lord. I'm for the counsel for the petitioner in 30.
So let me look at what is the relief you are seeking. Quashing now only para 35(4) of the order of the DRT dated 29/2/2024.
One paragraph they wanted to.
So, no. This order dated 29/2/2024 is assigned by you before the DRT.
Yes, ma'am. RA 56 of 2024.
He contested that matter.
Yes, ma'am.
Then.
Between them, I'm for the.
Mm.
That is the 12.72.
Yes.
And the petitioner. The main point to be considered is wherever there is a point of enforcement of fundamental rights and violation of principle of natural justice, proceedings are only without jurisdiction. All these points are raised. We have raised in the writ petition. Why? Because long back the loan is already paid. In fact, the OA itself filed by the bank cannot be sustainable because before the filing of the OA itself, loan was paid. So loan was paid long back. Non-existent debt, the OA is filed.
Why that DRT can't understand that?
My lord, these
Oh,
are,
he has already availed the remedy by filing an appeal to the DRT.
Agreed.
You are contesting the matter. Why should this court in between deal with all this?
Because exhausting the remedy cannot be the ground to non-suit the petitioner. Because for this reason, there are several judgments of the Honorable Supreme Court where it says whenever there is an enforcement of fundamental rights or infringement of violation of natural justice, and wherever there is no authority to initiate the proceedings at all these points are raised in the writ petition. This court is having a very much jurisdiction to try the matter, notwithstanding the alternative remedy. Because there are several points which are agitated in the writ petition, which clearly go to show that the bank itself was not proper in filing the OA at all. For this reason, that long back, before the filing of the OA itself, the loan was paid. In fact, account statements are there, which are admitted by the bank to show that loan was paid. Non-existent debt, the application was filed before the DR.
The OA was allowed on 39/2013.
39?
2013.
2013.
13. Subsequently, he filed writ petition.
That is WP?
WP 273 of 2024.
273
of 2015. Wherein he sought direction from the court to consider OTS. When he says in the 2012 itself the loan is closed, where is the question of filing writ petition 2015? Not only that, he'll do it.
What was the order in that writ petition of 2015?
Order it was dismissed, my lord. He did not pay the 25 lakhs as a
interim order.
He did not.
Then after that, what happened?
After that, they filed jointly sale notice, my lord.
No.
2015 only they are challenged.
No, this impugned order is dated 29/2/2024.
Which one, my lord?
This impugned order is 29/2/2024.
That is in an essay filed by them only.
2015.
No, that's what I'm asking you, the chronology of events. You say OA is disposed of on 39/2013. Writ petition is filed. That writ petition is dismissed. After that, essay is filed.
Essay in between. When the writ petition was there at that time, he moved before the DRT, and I told the same thing. Kindly see the order, my lord. I filed along with my objections. The order passed by this court.
Not for the assistance in the court. Chronology of
Page
events
number
is
30,
there.
my lord.
Take that.
It may be helpful.
Page number 30, my lord.
List of events
Next, R1.
in my writ petition. The 12th petition.
They have withdrawn the petition.
Give this. ಕೊಟ್ಟಿದ್ದೀರಾ ಇದನ್ನ? Cause list ಕೊಡಿ.
Where is this order in the writ petition? Have you filed a petition copy in the writ petition?
No, my lord. I have not.
Lord, sir, can I just?
The court permits.
Whatever transpired prior to the date of the sale feeds into insignificance because the sale itself came to be challenged before the DRT. DRT sets aside the sale, however, gives liberty because DRT, the sale was challenged principally on the ground that as on the date when the sale notice was issued, there were no dues.
That's where it is.
Yes.
No, the writ petition was filed in the year 2015. According to the petition, he has paid everything before 11 and 12 itself.
Yes.
According to him, in this, in the writ petition that is filed, he was seeking for a OTS. If the amount is paid, question of asking for OTS will
Lords,
not have.
that is the reason why I said, if your lords would just take that list of events which I have given, lords, everything revolves around this. Lords, one thing which can never go wrong is arithmetics. Accounts will never go wrong. 2 plus 2 has to be 4 only. Now, if they say that 10 lakhs was due, if I have paid 9 lakhs, there will be 1 lakh rupees due. Or if that 1 lakh rupees, if 10 lakhs is 9 lakhs is adjusted towards partially interest, there will be some principal amount due and there will be an interest accrued. Very simple. Notice now, once they had issued the notice saying that a particular amount is due, and by that date, we paid actually that amount. So if at all something was remaining, it would have been the remainder of that money by adjusting towards the interest principal, whatever. Serial number 5, your lordships may kindly see. Notice after serial number, I'll just take your lordships to serial number 3 and I'll just read it from the beginning.
I read it.
Notice now the basis on which they got this, we are absolutely unaware because we were never served with the notice in the OA. We are not aware of it. Other than OA, they have never ever, even till date, they have never given us the accounts. How you are claiming this money?
Let the petitioner place the writ petition copy.
Very well, lords. Lords may have this matter on day after tomorrow. I'll place it.
This is marked after.
My lord, in 9129, there is an interim order. I am an option purchaser. I am not
Lord, sir.
concerned inter se with their dispute. My
Lord,
only
sir.
point is DRT should have protected my interest because I have purchased the property under the aegis of the court procedure. I have paid the money.
In all these DRT matters, why when the auction sale is conducted without notice to the auction purchaser, without making him a party to the proceedings?
Lords, auction purchaser has participated in the proceedings.
No, but majority of the
Yes.
cases, that's what the court is observing. They're not even, neither the bank sales.
No,
or
no,
they're
the
necessary
auction,
parties.
lords, there is no way. I can understand. Once the sale is confirmed, then auction purchaser gets a vested right.
25% of the amount is paid, you'll get a right.
Lords, 25%, even if it is paid, if it's not confirmed, then even then there will be no vested right. 25% payment enable him to get a confirmation. If he gets a confirmation, then it's the end of the matter. Then it is out of the hands of the bank. Then it is the vested right in the purchaser, subject to him paying the remaining amount within 15 days or up to 90 days as may be extended by the bank. This is the procedure. Now, if he doesn't do that, then again he will lose his right. But mere payment of 25% is not a vested right, because that is the enabling right for him to claim confirmation of the
No, for
sale.
example, he must have paid the amount in 2019. The matter pending will be pending before the DRT. till 2025. And for these many years.
Yes.
His amount of 25 lakhs is lying with the bank. When the bank, when the DRT says you return the amount. you
What
return
this
the
honorable
amount.
court has done in, even the Supreme Court, what it has done in similar circumstances, it has given them, compensation in terms of either 10%, 12% of the interest they have, the compensation has been awarded by the courts itself whenever such things has happened. It is something like this, if the court finds that the sale is vitiated for some reason, has not left the auction purchaser high and dry, then the duty is imposed either on the bank. If it is a default on the part of the bank, then bank is required to compensate. If the default is on the part of the borrower for some reason, then the default is on the part of the bank.
Necessary party, auction purchaser.
Definitely,
His
my lords.
presence-
Auction purchaser,
his presence
after-
would not make any adverse effect on
I know,
the.
my lords, certainly, my lords, because principle, whoever is likely to be affected, principles of natural justice is not for the person who is to be affected, but who is likely to be affected.
Well, as I said, you give an example in 2019, the sale is questioned. If he is before the court, he would say, I don't want to be in between all this. I want to, like give back my money. I want to get out of this.
Very rarely we come across such instances for this reason.
No,
because
but that's what
I-
it is. Like if they
because
feel
now
that-
what has happened in this matter is there is an order of status quo, which is passed, pursuant to the writ petition filed by the auction purchaser. After the status quo is passed, he is let out the property under registered lease deed.
No, in this, you're saying
It's a
that.
status
where
quo
is that
qua the
order?
nature, my lord.
Where is that order in the writ petition? You are referring to that?
Page number 30, ma'am.
Page number?
30 of my objection.
But why did you ask for OTS if I already paid the entire dues?
What is asked?
What is the earlier writ
What it
petition?
says?
25273.
Lords, your lords may have this matter day after tomorrow, my lords. I'll place that because
May I
to
request
that
for after
extent,
the vacation, please,
lords,
my lord.
let it be on day after tomorrow, my lords. I've got now. It cannot be that if I have, it is something like this, my lords. If I was due by 100 crores, I'm sorry, 100 lakhs or 1 crore. If I paid them 90 lakhs, let us assume, my lords, can I auction my property and they'll hold me to ransom like this?
Only to the limited extent, if it is your, if in the writ petition, it is your case that you are ready for a OTS, now all these things will be decided by the DRA. Yes.
My lord,
The
may kindly
petitioner-
list it after the
petition
vacation.
shall-
Day after
petitioner
tomorrow, lords.
Shall place before the court the
Previous
the
writ
writ petition that is filed in the year 2015.
Please.
And the order is already there. The writ
But
petition.
2015, because
According to you, you have paid it by 11 and 12. So whatever you say in 2015 is, that's what. If it is OTS proposal, I'll straight away dismiss the writ petition. There is no second thought on that. The list is matter day after tomorrow.
My lord,
By the time the writ petition shall be placed in 32.1 interim order earlier granted is extended.
32, my lord. In 32, interim order is granted. I am the auction purchaser.
32 interim order extended till the next date of hearing. 32.1, this order
There
is
is
on
no interim
32.1.
order.
Yes, next.
Cell number
I will rejoin.
33,
We'll see on the Wednesday.
First of the NAKI.
cell number 33,
So whether required, then you can do it on that day.
I understand, my
vacation,
lord.
Yeah,
please,
file
my
an
lord.
application to amend the arrears, my lord.
Which one?
32.1.
Lords, as your
We'll
lords
see
have
on the next
suggested,
day.
day after tomorrow, if 2014 he has given a one-time settlement proposal, in the teeth of the stand he is taking now in 2011-12 itself, he has cleared it. Conflicting stands will be there, and then as your lordship said, my lords, I think.
I'll place
Yes.
it.
cell number 33, Yogendra
My lord,
Acharya
I
from-
represent the respondent.
Yogindra is expired here on 9/11/25, petition advocate.
9/11?
25.
My lord, I represent the respondent bank, my lord.
The counsel for the petitioner is no more. We can't, unless, we'll issue the notice, court notice to the respondent and list this after vacation. It is submitted that the counsel appearing for the petitioner died on 9/11/2025. Registry is directed to issue notice.
Stay may be extended.
To the
If I can seek for a
respondent.
date to be fixed, my lord. If I can seek for a
This
date to be
matter
fixed.
on January, what is the date? What is 20th of
Anytime in the
January?
first week, if my lords could accommodate.
7/1.
Not 7/1. 20th of January is what? Day, which day is it?
20.
Tuesday, yes. Registry is directed to issue notice to the party, to the petitioner.
Court notice. Cell number 34, Sri Rajashekar.
Made a statement that I'll be withdrawing this writ petition, my lords. I'll not go beyond my statement with just one indulgence. Lords, it so happened that one of the money which we had sourced, it's a demand draft which we got from a bank, which we have presented on Friday. Lords, today we'll get it encashed, tomorrow we'll give them. I'm only saying this, Lords, today I'll withdraw this writ petition. Lords, this may extend this interim protection by a period of 2 weeks. That's the only stand, Lords.
Sale not taken.
Only sale notice.
Sale
Lords,
may not sale
no, no.
before this on court. Sale not,
Lords,
confirmation of sale.
to sell this particular property, let this be extended by 2 weeks. I am already in consultation with the bank, my lords. We are already in a dialogue with the bank. We are ensuring that,
What is the outstanding amount?
lords, outstanding amount is about 20 crores and odd. Lords, considering the valuation which they have arrived, we are giving them a one-time settlement proposal. 1 crore was the condition which was imposed by this honorable court while granting the interim order which we have deposited. Now, I would have given the proposal by Thursday. Now, the whole difficulty was that I could not get the demand draft which was issued by another bank in my hands. Only for 2 weeks it may be extended, my lords. Otherwise, I will.
Please come. The writ petition is filed, seeking the following prayer. On the last occasion that 2025, when the matter came up, the council appearing for the petitioner submitted the petition approaching the respondent bank for contract settlement, and the petitioner will be withdrawing the petition on 15/12/2025. Today, the matter came up, then council for the then senior council submits that they're making all efforts to settle the settle the same with the bank by paying the entire amount, and senior permitted to withdraw the writ petition. However, but when you're withdrawing the writ petition, this 2
Lords,
weeks.
I'm only
of,
saying, my lords, that in this interim direction, because I'm approaching the bank,
No, please
I'm not saying
understand.
till such time they consider. I understand, my lords, this the technicality once I'm withdrawing it. Interim protection is only to facilitate the closure of the loan account, not for anything else. It's only to facilitate, my lords, the closure of the loan accounts.
That order is somewhat.
Lords,
Doesn't
your
sound,
lordships, I
right.
understand, my lords, but the coordinate benches have passed similar orders
I can't
wherever we
pass
are.
such an order. I can adjourn this matter by after vacation.
Matter may
That
be
it-
disposed of. Sale not taken place. My lord, if 1 week, my lord, it may be taken by undertaking, my lord, will not do anything if they're approaching the one-time settlement offer.
It may be
and
about 2 weeks
recorded with all
because to
fairness, we'll
consider it will
I
take
will
some
record your
time.
undertaking.
Please.
For 2 weeks, it may be.
1 week.
Yes. 2 March. 2 weeks, because we want to closure, my lords. I want to save the properties.
It is submitted, they're going to repay the entire amount and they're.
Lords, your lordships may say entire amount through OTS, otherwise
through entire amount through OTS.
OTS.
If they submit the proposal, with all fairness, we'll consider. It
Land
may-
That
council
statement,
appearing
yes,
for the
it may be
respondents
recorded. Lordships.
So this is how I'll dispose of this writ petition.
Yes, my lords.
That's what-
With the
Some
mutual
some
statements.
Land council appearing for the respondent bank submits that. If the petitioners come up with a proposal, they'll consider the same in accordance with law.
No.
It is submitted that it is undertaken by the land council.
I'll undertaking better. Within 1 week, let them submit the proposal. Thereafter, 1 week,
That
we'll
if they come up with a proposal within 1 week, within 2 weeks.
within 1 week thereafter,
Within
The-
1 week
from
from
the
the
date-
date of the proposal,
we'll consider.
they'll consider and pass, they'll consider. And it is also submitted that till the 2 weeks.
Period of 2 weeks.
From today, they will not take any coercive
Precipitative action.
In respect of the present property, in respect of the present property, there are one more property, there is no stay.
in respect of when we
The
are
property
referring
in
to the
question.
petition only.
Yes.
That's only one property.
One property.
Accordingly disposed of.
Grateful, lords.
Sale number 35, urgent, 36. Sale number 36,
Yes.
Ajit PB.
Thing for the petitioner, your lordship, Wednesday we'll file the affidavit. The petitioner is out, is not from Bangalore.
Do that.
Last time it was
Then
there.
council, the petitioner submits the petition ready to clear the entire outstanding amount. They'll file an affidavit. There is no representation on behalf of the respondent.
We are also trying to
Shankara
contact,
A. Why is he not representing?
we are also trying to
Which bank is
contact
this?
Kotak Mahindra.
Kotak Mahindra.
Has he filed wakalat?
Yes,
I don't think he has filed.
it has filed.
See?
Shivashankar.
There is no representation on behalf of the respondent bank. There is an interim order in this.
Please, Your-
There is no representation on behalf of the bank on the last occasion as well as today. This matter after vacation, the interim order earlier granted is extended till then.
Sale number 37. 37.
I appeal for the respondent bank minutes.
In all the matters, wherever there are office objection, they shall all be complied with by the next date of hearing. Look at the cost item.
No.
Cause
Let's have one submission. Wantonly, the present writ petition is filed in serial 37.
Hmm.
Award is, my lords, is award passed in OA is called in question in serial number 37, my lord.
Hmm.
If the petitioners are aggrieved, proper remedy for them is to, my lords, file an appeal in terms of section 18. Our writ petition could
Appeal
be
before
filed. Appeal before the DRAT, my lord.
Where
Award
is
is
that,
called.
any interim order?
No interim order.
She's submitting something.
Madam Anupama Agarwal, your voice is not audible to the court, ma'am.
Pass over. Next 38.
Cell number 38. Nagesh Vinay.
I'm the petitioner in 14353 and respondent in 3012.
I'm telling you, you have to, whatever you want to say, you should say within 5 minutes.
Absolutely, my
And
lordship.
no, I will not give you 1 minute more.
Absolutely, my
It is
lordship.
11:37.
My lordship, I would like to, yes, pass over this memo of citations and I would like to make
I do
very
not
brief
want to look at
points
any law.
on
Please
why.
tell the facts what you want.
Yes, my lordship. Why Niman's evaluation is necessary, my lordship. I want to argue on that because, my lordship, one thing, if you decide only based on mere oral submissions or contested material that we give based on WhatsApp
That we
chats,
will
other
see,
thing,
that we will
it is
see.
not going to, there is
That
a,
we
there is
will
a,
see after the vacation. Now you please tell the court what is the immediate necessity and what is that you are seeking
my
from
lordship,
the court.
before vacations, my lordship, there is a stay on the winter vacation. Let that stay be vacated, my
Where is
lordship,
that?
because
Where is that
it is,
order?
it is on the vacation bench, my lordship. It was on 10th, I think. It was on 3/10/25. There was a stay placed.
In which writ petition it is?
It is 3012.
3012 of 25.
Give that. This is not that. Which date is the order?
3/10/25, my lordship. 3rd of October.
Is what do you say? No, in the vacation, why can't you have access on every day for some time?
But we'll permit to exercise visitation and every day it is difficult, my lord, because mother also has to indulge the child during vacation, my lord.
My
It
lordship,
has become.
I already have daily
Let me
visitation. The
let me
family
complete,
court
my
has
lord.
given me overnight visitation during the vacation custody, my
My lord,
lordship.
let me complete my submission.
Kindly
Let
uphold
him
it
have a
because
chance.
they are the ones who are refusing to go to Niman's. This stay is there only because the pending Niman's evaluation, my lordship. I am ready to go even today. They have been dragging it.
There is a procedure in the court. When the counsel is
Sure.
asking, you have to wait for your turn.
Sorry.
Yes.
But my respectful submission is that, my lord, when we exercise visitation on every day, my lord, it has become very difficult for the mother to take the child anywhere else, my lord, because every day from 7 to 9 he is exercising visitation, my lord. During daytime, he is going to this child is going to the school. During weekend, my lord, that is Saturday and Sunday, from 2 p.m. to 6 p.m. he is getting visitation, my lord. Now, mother is unable to take the child anywhere else out of
What will
Bangalore.
happen if she doesn't take?
Madam?
What will happen if she doesn't take him also?
Lord, the thing is, my lord, every time she has also has to travel, my lord, because she has also about to take the child to somewhere in nearby places, my lord.
Mother shouldn't feel that it is her property that she is helping the father.
Not
or
at all,
giving
my
it
lord.
to him.
Not at all, my lord. Let the interim arrangement be made, my lord, during vacation, winter vacation, my lord. Let him exercise 2 or 3 days, my lord. Remaining 2 or 3 days, I'll get visitation, my lord.
And then
Because
it is
every day now he's exercising visitation.
Complete. In the if it is 50% of the vacation, in the 50%, from the entire day, let him have.
My
Please,
lordship,
my lord,
my
from morning-
two vacations have been already lapsed, my lordship.
From morning,
Deepavali
from
and
morning to
Dasara
evening,
is
let him
gone already
exercise, my lord.
because there was a valid order from the family court. She said, I will challenge it in High Court.
Forget about what has happened. Now you can't put the clock back. We are now on the winter vacation.
Okay.
When the winter vacation starts?
20th, my lordship. This Friday onwards it starts.
23rd, my lord.
20?
23rd December
This
to
weekend is
January
also
2nd.
included, my lordship.
Yes, yes. So, 20.
Lordship, the
3rd
family court
December.
gives me 50% vacation.
Please wait,
Yes,
sister.
ma'am. Sorry.
So, the holiday starts from?
23rd.
20th to 2nd of January, my lordship. 3rd and 4th will be Saturday, Sunday, so until 4th.
20th to 4. So, how many days? Total 16 days.
60 days, my lord.
16 days.
Please, my lord.
So, which part of it you want to have? Which part of it he'll have?
I'll take second part, my lord.
Huh?
Second.
You will
From
take the second half.
Second half.
So, from 20th to 20.
28th.
Huh?
28th.
Because last 2-3 days, my lord, child has to get into the school, my lord, because 2 or 3 days
lord,
when
he's
he
a
travels from other
3-year-old.
side, my lord, it is become very difficult for him to get into acclimatized to school, my lord.
20th to 27. That is 7 days.
Please, my lord.
20th.
I have informed that
One
vacation
minute. 1, 2,
vacation
3,
starts from 23rd. I informed, my lord.
7 till 26th. From 20th to 26th, he'll have.
Please.
Yes.
My lordship, 2 more days, my lordship, because my both
Third.
vacations, so many days it has lapsed, my lordship. But there is no fault of mine.
Like you were behaving as if that the world is going to end by this January. That after that you will not have any visitation of the child. That's how you shouldn't behave.
Okay.
The
My lord, my another submission, my lord.
Hmm.
During everyday visitation, my lord, from 7 to 9, it is causing too much of
not 7 to 9. This time when he's going to have the visitation, the entire he'll have from morning to evening.
Please, my lord, that is well and good.
Please wait, Mr. Yes.
My lord, apart from that, my lord, every day is getting visitation from evening 7 to 9, my lord. It is causing huge difficulty on the mother as well as the child, my lord.
Who accepted that? If you remember that.
My lord, we accepted based on how the visitation, my lord, kindly see the order 23-9, my lord.
What is the
Based
difficulty
on,
that's caused?
my lord, may I submit this, my lord? Now, from 7 to 9, the dinner time of the child is totally affecting, my
We
lord.
will change it to
I am giving the dinner, my
Evening,
lordship.
earlier time, my lord, at least from 5 to 7, my lord, because now the very cold, my lord. Now when he brings back the child from his residence to my residence, my lord, these not getting taking the child from the car, my lord, is making walk from his
this is
place
all,
to my
my
place,
lordship, mere
and also the
allegations,
dinner
my
time.
lordship.
Now
This is why I say let's go to Nimans, because these are the neutral third party experts.
let me submit.
Any order?
Sorry, my lordship.
Yes.
These are simple allegations, my lord. There is
Let me
nothing.
submit.
See after the Nimans report comes.
But then let them go to Nimans, my
We'll see
lordship.
after vacation.
No, my lordship. They are not coming, my lordship. Let them go to Nimans, because
And
this
when
is
the
about.
court is when the
My
court
lordship.
is in your favor, if you don't understand, if you want to argue, I can't help you.
One very small point, my lordship. My lordship, when the question of evaluation is open, any orders
So
that
I
are
will
passed.
modify that order now. This court only passed that order of Nimans. I will modify that it is not required. Yes.
My lord, at least to be made from 5 to 7, my lord, because the dinner time of the child is greatly affecting, my lord. Nowadays, when mother feeds the child, my lord, is
7 will come into play after the vacation.
please, my lord,
Isn't it?
please. Now up until 20th, my lord, he is getting visitation on a daily basis, my lord.
Why will he get now? From 20th when he's getting a daily visitation, that will go on till that 50% of the vacation, he will not have any visitation.
Please, my lord,
That I have to clarify. Till
please, my lord.
4th, when is that? Till 4th of January,
Please, my lord.
he'll not get any visitation.
Please,
From 20th to 26th, he'll have the visitation.
please, my lord.
From 27th till 4th, he will not have the visitation.
Oblige, my lord.
The earlier order will again reinforce from 5th of January.
Please, my lord, the earlier order, my lord, which I am seeking certain modifications in that order, my lord. Because from 7 to 9, these are all the difficulties which the child and mother is facing, my lord.
Yes, give
So
the
that
order
interim
sheet.
arrangement may kindly be made from 5 p.m. to or 7 p.m. my lord.
This court on
23/9/2025.
on, when is that order? That
23,
demands order?
23/9.
23/9. Where do you get that order, 23/9 order?
14503.
That is in a different writ petition. It has nothing to do with.
14503. 14503. It was disposed of, my lord. Again, the party in person filed an application to recall the order, my lord. In that, your lordships has held a chamber counseling and made some interim arrangement based on how this visitation goes. It is a basis for this court to pass certain orders, my lord.
Earlier, when WP number
14503.
14503 of 2025 was disposed of by this court. The party in person, father has filed a review in that. This court had interacted with the parties on 23/9/2025 and passed an order that the party shall appear before the doctors at Nimhans on 16/10/2025 and the doctor shall evaluate them. In the meantime, from Monday to Friday, the father can pick up the child from the mother's place at 7 p.m. and drop him back by 9 p.m. And the Saturday, Sunday adjustment can be, arrangement can be adjusted as per the convenience of the parties. When the doctors at Nimhans have advised that they should be admitted as an inpatient for a month, mother has expressed a difficulty to join as an inpatient. It is submitted that they can go before they can appear before the doctors as an outpatient.
My lordship, that also they refuse. I want to bring it to your notice. Both they are refusing, my lordship.
You don't even go as outpatient.
But outpatient, I'll get instruction. After vacation, let this matter.
This has
be
already
heard.
been
I'll make
completed, my
myself-
lordship. They are
Because, my lord,
refused.
They have said that they will not.
They last hearing only, my lordship. Before 20th, they have said they cannot do either
lord.
inpatient. I have the recording, my lordship. They have said both inpatient, outpatient.
Outpatient also you said so.
My lord, no,
If
my
that
lord.
is so, then we will compel her to go.
No, my lord. The outpatient report, my lord, your lordship had asked from Nimans to get a report, my lord. In that, they have clearly, enhanced
The
that.
report, whether you are did you say that your client is not ready to
Not
go?
at all, my lord.
Yes, that
Lordship,
she
then
is
let
ready,
this be ordered, my lordship.
ready to go as a outpatient. In the meantime, the family court has passed an order granting 50% of the visitation to the father on all the vacations. That was assailed before this court by filing WP
30128, my lordship.
30128
128 of 25.
No, that's not 30128.
Please, my lord. 30128 is. Operative question is at page number 37.
30128 of 20. Do not to club like this, all the order sheets. Remove it and keep it to each file. It's very difficult. 30128 of 2025. In that, an order is passed on 3/10/2025, where the order of the family court is stayed, and the arrangement was made as per the earlier order passed by this court in the before that one number in the earlier number, as passed in the said writ petition. The party in person submits that now the winter vacation is approaching, and unless and until this order is vacated, it would cause a lot of prejudice to the petitioner. It is stated that the vacation of the child is from 20th of December to 4th of December and 4th of January 2026. The Learned Counsel appearing for the mother submits that this court has granted the visitation between 7 to 9.
9, please.
7 to
Every
9.
day.
The age of the child is
3 years.
Years, 4 months.
3 years, 4 months, and it is causing a lot of difficulty to the mother. So to his sleep time and other activities are affected. Hence, there may be a modification of the same. Next slide. Considering the submission of both the councils. This is now WP 30128 of 2025. And the other is that review order
14503 of 20.
503.
503. In both the cases, this court is passing the following order. the father is entitled for the interim custody of the child from 20th of December to 26th of December. On those days, the father can pick up the child at morning 9 o'clock.
10 o'clock, my lord. 10, because the child has to wake up at least 10 to 4, my lord.
No, for 10, she'll get up at 10 o'clock. She'll have the custody from 10 to 7.
My lordship, I don't agree to this. I have a family court order which gives me overnights during the thing. There is a stay only because of the Niman's evaluation. They are not accepting it, my lordship. And already 2 vacations have been
Question
passed.
this
My
order
lordship.
that's going to be passed by me between 10 to 7. 10 to 7. From 20th to 26th. Then coming to the order that is passed in the review petition, that is entitled between 7 to 9. The same is modified to 5 to 7. The father will not have this visitation of 5 to 7 when the mother is having when the 50% of the vacation, that is from 27th to 4th, he will not have the visitation between 5 to 7. This order will again, he can exercise the visitation basing on this order from 5th of January. This is
My lordship, let it be recorded that the mother is refusing to go to Niman's evaluation because, my lordship, any subsequent orders passed, if there is a pending question on the fitness of the parents, both parties will come to challenge and the child will suffer because of this.
Recorded in this order itself.
Yes, my lordship, so it will be, and also at least one trial, 1 weekend, 1 day overnight, my lordship, just this weekend at least.
3 years, why?
My lordship, he is very comfortable, my lordship. He is asking whatever they submitted is actually not correct, my lordship.
The vacation we'll see, because we stay nearby, we'll consider
Lordship,
them.
just one night, my lordship. It's a child's wish, my lordship. The child is telling, Papa, I don't want to go. He's like acting. My teddy bears will sleep here. I will sleep here. You will sleep here. My lordship, I can show you one video, 30-second video, my lordship, that will help you understand what is happening with the child. We are talking about child, my lordship. We are not talking about the orders here. The child is asking for this, my lordship. And I've been very patient, my lordship. I've been doing visitation for last 2.5 years. There is a long history. The child has natural expectations from his father, my lordship, and he's not asking for anything illegal. He just wants to stay for some more time and spend time, sleep next to his dad, cuddle with him. That's all he is asking, my lordship. And that is why I say Niman's is essential, because it's a neutral third party. If you go based on mere oral submissions, I submit something, he submits something else.
On 20th, 21st, and 22nd, 20th, 21st, and 22nd, father can have the overnight visitation.
My lord, may I please, my
On
lord?
23rd, 24th, 25th, and 26th, the father shall have the visitation between 10 o'clock and 7 o'clock.
Much
My
obliged, my
lord,
lordship.
my lord, it is, my lord, not at all, my lord. May I submit, my lord?
Yes.
My lord, the child is just 3 years, my lord. There are so many allegations by father, my lord. I want to place it all those things on record, my lord. Due to paucity of time, it is not possible for, my lord. Kindly, my lord, from 10 to 7, my lord, I'll address my arguments on length, my lord, after vacation. Let
Much
this
obliged.
interim arrangement be made, my lord.
Let it be, yes, next.
My lord, may I be liberty to move before vacation bench, my lord?
Why? We will
My lord,
not.
because it is not possible for mother to give overnight custody, my lord. My lord,
Order that is passed now by this court, you will move before the vacation court. What is
my lord,
that?
modify, my lord.
How can the court pass an order? Land counsel for the petition seeks a permission to move the vacation court. When an order is passed for the vacation, question of moving the vacation court will not arise.
My lord, overnight
Much
custody,
obliged, my lord.
it is very difficult, my lord,
What
for a
is the
mother.
Supreme Court now? Yes, next.
Appearing for the petitioner, my lords. My lords, this is a matter where the section 30
Nice, Swami.
demand notice was
I appeal for the
challenged, my lords. My lords may kindly.
Is this?
Please,
Number
my-
39.
39, my lords. Whereas the matter was heard in detail, in fact. My lords may kindly see annexure D, my lords, which is the
Order that the father is exercising the visitation from a long time. And even in when the court has the interaction, the boy is having,
This is that.
the boy is very comfortable with the father. Yes. Yes.
39.
My lords, annexure D, my lords, the impugned order.
Page number?
Page number 39, my lords, the demand notice under section 13(2). My lords, this matter was heard in detail because the respondent bank had not given a categorical or a reasonable reply under section 13(3)(a), my lords, as mandated under the.
What is your reply?
Please,
Where
my
is
lords,
your
may
reply?
kindly see the reply at annexure E, page number 44, my lords. My lords, I have specifically denied, my lords, the dispute over classification of the NPA as 90 days, my lords, period had not lapsed. My lords, may kindly see the demand notice, my lords, says that the
I've seen it. Where is that reply by them?
My lords, their reply is next page, my lords, at page number 47, annexure F. My lords, in the annexure F, now in the objection, please, my lords.
Who appears to the bank, you appear.
I appear for the
They have taken a stand that it is an MSME.
Yes, Your
For
Honor.
declaring any account of an MSME as NPA, there is a procedure
Yes,
by the
my
Reserve
lord.
Bank of India
Yes,
and
my
in the
lord.
settled law. What is your response to that 13(2) notice?
Yes, my lord. Actually, this writ petition itself is not maintainable because it is a challenge of the 13(2) notice, which is not challengeable at all because it is not a measure under Surfacey Act. I'll come to that later. Now, your lordship has asked for the
For
MSME
that, I'll
point.
tell you. Now, when under 13(2), when they have taken such a stand, you don't answer to that. Where should they go? Why should these proceedings be taken?
No, I'll
further?
answer that only, Your Honor. First,
That you have
I'll
to
answer the
that you have
MSME
to
point
answer
only.
from your reply at page number
49.
47.
Yes, my
please
lord.
come to that.
Yes, my lord. They have, it's at their page number 49, they have produced our reply. Whatever they have said, the bank affirms that whatever demand notice has been issued is in order. And in the end, your lordship may come to the last paragraph here for the reasons at the page number 49 only of the bank's reply. For the reasons stated above, you are requested to comply the demands made by the subject demand notice and to avoid further legal consequences. Lastly, the allegations made in your notice dated 4/9/2025 are categorically denied as you have already given a similar request for renewal of FBWC limit with reduction and release of security, which was not considered favorably by the competent authority, and the same has been communicated to you via our letter. Your lordship may kindly come to my objections, page number.
No.
One second, your lordship, just allow me to submit.
No. First, you can't supplement your arguments by your objections.
Okay,
What
fine.
is the purpose of giving a reply?
Your lordship, actually what has happened is basic requirement under the MSME Act, as per the notification and as per the Swami Samat's recent Honorable Apex Court judgment also, it is just not that they come out with a reply. They have to give verifiable documents with authorized,
Where did you say so?
authorized, sworn to by an authorized officer, an affidavit has to be filed. In this case, there is no affidavit that is filed.
Where did you say all this? What is the purpose of this reply?
No, at least allow me to take you to the, take this court to the Swami Samat's judgment, only 2 paragraphs, only
I have
5
already
lines.
read
No,
the
no,
judgment.
only 5 lines, your lordship, only 5 lines. At page number 50. However, upon receipt of the demand notice, if such borrower in its response, page number 50 in the last, upon receipt of the demand notice, if such borrower in its response under section 13(3) of the Surfacey Act asserts that it is a MSME and claims the benefit of the Surfacey securitization, reconstruction of the financial assets and enforcement of the Security Interest Act, citing reasons supported by an affidavit. Citing reasons supported by an affidavit, then the lending bank, secured creditor would then be mandatorily bound to look into such claim. Even to look into such claim, we need an affidavit sworn by an authorized
Are you not
officer.
supposed to say that in your reply?
No, because our reply is already being, in our reply, we have already referred to a letter dated 22/2025. Our letter, in our reply, we have already referred to the letter dated 22/2025. That is the reason I am requesting this court to just come to my objections and that
Only
letter, your
concerned with
lordship.
this demand notice, I am not convinced I will satisfy this. Please come.
My lords, my one humble submission, lords.
There
After
is
this,
a
my lords, section 13(4) notice was issued. My lords, that also I had produced before this honorable court. My lords had.
Special
Their
proceedings.
grounds
Yes,
are
my lords.
also
My
not
lords,
with
now,
regard to MS.
now sale notice has been issued. They are coming to the premises of the personal guarantor of the borrower threatening police threat, my lords, call them to the police station. All
That
of
is
these
all-
illegal actions have been taken,
Anyhow,
please, my lords.
whatever it is.
But
no,
your lordship, my
once the
kindly
13-2 goes,
Goes,
whatever other
please,
consequential action
consequential
has to
action.
go.
Grateful.
But your lordship, that if they haven't given an verifying
Why did you say so? Please, counsel, you have to answer to the specific query of the court. I said, when
exactly
when it
when
is the case,
when
when
the-
did you say so?
No, when the demand notice, when the reply itself says that we have categorically answered everything in the letter dated 22/2025, your lordship may kindly just come to that letter 1 second. Our reply letter, which has been given to them on 20th of February
Problem is you're not
2025.
understanding
I
my
get your,
answer.
no, I thoroughly get it, that MSME,
Query, no, understand. If you understand my query and answer to that, I don't have to go to the objections.
I thoroughly get it. If
But
they
you have
had
to
said
answer
that
to that.
MSME, we should have said that we are not taking it because
The
we
light
have
of the
not
judgment
given.
of the Honorable Apex Court so and so, you have not come up with any affidavit. We are not considering your case under the MSME.
That is the only reason that was not
That is
done
the
was.
reason why I'm setting aside this.
No,
Please
no,
come.
that was not done because there were a couple of letters given which were already answered by the bank. And that is the
Please,
reason they have taken it like
The
that.
present writ petition is filed.
They can agitate the same thing in the essay that is filed before
Not
DRT
required.
also.
You also have certain obligations and responsibilities.
Your lordship, my
The-
humble request
I'm-
is,
Yes,
we
fine.
will answer, if your lordship is so, this thing to, that we have not answered, we'll withdraw the possession notice, we'll answer it, and then issue a fresh possession notice. Let the demand notice be there. Let the demand notice is already issued. We'll
Then I will
withdraw
set aside
only
your
the
response.
possession notice,
Your response.
and we'll issue a fresh
It will
response.
start from the day of 13-2. That is from their reply.
No,
Now,
from-
whatever that has to be, that has no 13-2 notice is given.
Within 15 days from
That
today,
now-
we'll answer.
From now, I'll give you an opportunity to give a representation, to give your reply as mandated by the Honorable Apex Court in that judgment, and let them take further steps.
Please, my lords. My lords, also, my lords, the facts have changed. In fact, in the last 1 month, my lords, around 50 lakhs to 1 crore has already been repaid.
Whatever it is, that is not part
My
of
lords, I
this.
may be permitted also
That's
to
why
file.
from whatever notice, give a fresh notice under 13.
Issue a
So
fresh
what will
notice,
go,
my
because
lords,
now
that
they
will
have
be,
paid certain amount.
certain amount has been paid.
That
So the
anyhow,
demand
whatever
has,
is the name, it will again take back to the entire measures have to be started again.
But
Your
now
Honor.
also that's one side set aside. No,
No, the thing is,
the other things can't follow.
there has been misutilization of the funds. There are so many things that they have done. That is the reason I said 20-hour reply, and at least whatever is the mind of the court, I'll bow down to that. But just the reply that has been given by the bank, let just be just heard by me, by your lordship. At page number
Yes.
seven of my objections. Page number 7, annexure R1.
Yes.
Now, when on the date when it was given, the account was already in SMA 2. SMA 3 makes it an NPA. So it was already under SMA 2. There are overdues in the account, and currently account is under SMA status. Further, there are overdues as per the CICCs of the company and directors. I'll only take your lordship to the important points.
No, one more thing, you please clarify. You have given the loan, considering it as MSME or not.
Yes.
The first point is, when it is an MSME, which is in the notice of the bank, why do you say that they should do that and this? When it is an MSME, to declare it as an NPA, there is a procedure contemplated as per the guidelines.
We have already considered everything, your lordship, and MSME, just because it's an MSME, that is what has been recently clarified by the Supreme Court. It is just not that the bank, they have to come with a verifiable document saying that they are MSME. They have to come to the bank with a verifiable
Judgment.
affidavit of their incipient
That
stress.
judgment which you are relying on.
No, incipient stress.
No,
It
no.
does not say only
No,
MSME.
that judgment which you're relying on, where they kept quiet till everything has happened, and at a later point of time, please let court complete. At a later point of time, they said that they are MSME and this procedure is bad. Then the court said, at the earliest, when 13-2 is given, you have to come with all this, the procedure that you are saying has been absorbed by the court. That is at a later point of time. It will not apply to this case.
No, your lordship. Even in paragraph number 5,
yes.
it very clearly says, and here it just
I'll record that. The present writ petition is filed, seeking the following prayer.
She's not.
The
There has been
brief facts of the
misutilization
case.
of the funds
I'll
also.
record your objections also. The case, the brief facts of the case are, the petitioner is a private company and a registered micro, small and medium enterprises, which is in the business of retail trade and is engaged in various other professional, scientific and technical activities. Petitioner has availed a MSME OD facility from the respondent in the year 2019. And thereafter, in the year 2020 and 2021, two separate guaranteed credit facilities were availed by the petitioner. All these credit facilities, loans were secured by mortgaging the property's guarantees. Since the petitioners underwent huge losses posed during the COVID pandemic and suffered financially due to economic downturn, the turnover of the company declined from rupees 42 crores in 2018-19 to rupees 5.5 crores in 2024-25. And this led to delay in EMI payments. It is stated that though the petitioner was in a difficult position, he ensured that it made repayments towards the loan EMI. In this context, the petitioner on multiple occasions met the respondent bank and sought for loan restructuring by submitting various proposals. And in this regard, he has also sought repeatedly for a conditional no objection certificate to sell its assets and reduce its liabilities, and also sought for restructuring of the loan, as the petitioner is a MSME and falling within the RBI's framework and for revival and rehabilitation of the MSMEs. It is stated that since June 2023, from the time a formal request to help in reducing the OD limit was made to the respondent bank, a total repayment of rupees 3 crores 3 lakhs 9,094 has been made by the petitioner to the respondent bank towards the interest, principal, penalty and other charges. It is the case of the petitioner that the bank has deliberately and maliciously delayed the renewal of the OD facilities since June 2023. The respondent bank kept delaying the renewal on one or the other pretext. Petition has gave a restructuring proposal on 21/6/2025. While this being the case, the bank has issued a 13-2 notice on 7/7/2025, stating that the petitioner's account has become irregular from 3/4/2025 and stands classified as a NPA since 2/7/2025. It is a case of the petitioner that they have paid the latest payment on 29/5/2025, and there is absolutely no basis for considering the account of the petitioner as irregular or classify it as NPA. Then the petitioner has immediately replied to the 13-2 notice dated 7/7/2025 on 4/9/2025. Seeking a statement and clarify on how the account has been classified as NPA without the proper classification as NPA. The Surfacey proceedings could not be maintained. And further, it is the case that their company is an MSME and without following the guidelines, RBI guidelines, they cannot be declared as NPA. For that, they have given a response dated 16/9/2025, stating that the classification of NPA is correct and the petitioner has to act in accordance with the demand notice. Questioning the same, the petitioners are before this court. Learned counsel appearing for the petitioner submits that the action of the respondents is in contravention of the RBI circular and guidelines of the respondent bank as well. It is the case that there has been no default beyond 90 days in payment of the part of on the part of the petitioner to declare the account as an NPA. It is stated that now the petitioners, now the respondents are it is submitted that now the respondents have issued a notice under 13.4, and also order under section 14 is passed.
Not, my lord.
13.4, and they are taking steps to approach the magistrate seeking orders under section 14
Sale notice dated, sale notice has been issued, my lords.
without taking possession.
As is very strict in the bank.
They have issued the sale notification on
1911, my lords.
19/11/2025, and the auction is scheduled to be held on
24/12/2025.
24/11/25.
24/12.
26. 24/1/26.
24/12.
12/25.
That's under challenge before the
Huh?
That same notice is under challenge before the
And they have
One of the personal guarantors, my lords, not by the company.
It is submitted that the whole purpose of issuing a reply to the 13.2 notices, bringing to the notice of the bank, any of the notice of the bank, all the factual aspects. In this case, the petitioner's company is a MSME, and as per the RBI guidelines, like any other account, they cannot declare the same as NPA in a normal process. Hence, they have given the reply which was not considered, and mechanically a reply is given by the bank under section 13. It is submitted that all the proceedings that are initiated by the bank is contrary to the guidelines issued by the RBI. As such, the same needs to be set aside. Land counsel appearing for the bank has filed its objections. The bank has filed its objections, and the land counsel as per in the objections it is stated that the High Court of Telangana had dismissed a writ petition in case of S3 Developers and State Bank of India 2022 SCC Online TS 1357, that at the stage of issuance of notice under section 13(2) of the Surfacey Act, no interference is called for. And they have also relied on a judgment of the Karnataka High Court in Sarasamma versus KSFC and others, and submitted that a writ petition is not maintainable against the notice under section 13(2). It is stated that the writ petitioner has raised vague pleadings with regard to the contention that the petitioner's unit as an MSME and are entitled to the notification framework issued by the Government of India for restructuring the loans. It is stated that in the reply dated 22/2025, the bank has clarified all the issues, and they have given a befitting reply to the reply issued by the petitioners under section 13(2) of the Surfacey Act. It is stated that in reply to the demand notice issued by the petitioner, though contains a point of they being MSME are entitled to the benefits of restructuring, they have not produced any verifiable documents supported by an affidavit citing reasons for their right to restructure, rehabilitate, which is a legal requirement as per the very notification of the MSME of 2015. It is stated that the reply that is given is beyond the period of, he has given the reply just before the expiry of 60 days period, speaks volumes of his seriousness in claiming any benefit of restructure repaying the loans. The land counsel appearing for the bank submits that the Honorable Apex Court in Proceedings versus Board of Directors of Canara Bank, reported in 2024 SCC Online SC 1864, has categorically held that the benefit of the framework for revival and rehabilitation has to be initiated before the account turns non-performing asset. It is incumbent on the part of the concerned micro, small and medium enterprises to be vigilant to follow the process laid down under the said framework and bring to the notice of the concerned bank by producing authenticated and verifiable documents, materials to show eligibility to get benefits of the said framework, but after not doing now, pleading all these grounds, subsequent to initiation of Surfacey proceedings, is belated. Then the council has also relied on Swami Samath Construction and Finance and others versus Board of Directors of NKGSP Cooperative Bank Limited 2025, which is reported in 2025 SCC online, SC 1566. In this judgment, the Honorable Apex Court has clearly justified and has explained how the borrower has to approach the bank and seek the benefit of the MSME. It is stated that the petitioner has not filed, it is submitted that the petitioner has not filed any single document to establish that they falls under the criteria for availing the benefit of the said MSME. The bank in its reply has also clarified that the accounts are classified as NPA as per the RBI guidelines and also referred to their reply letter dated 22/20/25. It is stated that the writ petition is not maintainable before this court as section 13(2) is not at all a measure under the Surfacey Act and the writ petition is not maintainable. Next paragraph. Having heard the learned counsel appearing on either side, peruse the entire material on record. When once the account is declared as NPA, the bank will issue a notice under section 13(2) of the Surfacey Act. For that, there is a provision where the party has to give his reply, if any, to the bank, and on that, the bank will respond to the same. The whole purpose and the purport of giving an opportunity to the borrower and also an obligation on the bank to respond to the same is not a mere formality. But generally, the banks are giving a very formal replies to the said notices without even giving a specific without giving the specific reply to each and every averment that is given by the borrower. In this case, admittedly, the company is a MSME, registered as MSME. As on the date the loan is given by the bank, and then the bank is aware of the same. If it is considering the argument of the learned counsel appearing for the bank and relying on the judgments of the apex courts in Pronitz, Refer Supra and C. Sarasama, they have to come up with verifiable documents. If that is the case of the bank, that they are not able to consider the case of the petitioner, a reply of the petitioner to the 13(2) notice, the bank would have stated so in their reply. Verifiable documents with an affidavit. If that is the case of the bank, that the petitioner has done and they are proceeding, they are not considered, and they have given the reply, it would have found place in the said reply. A perusal of the reply that's given by the bank makes it clear that the bank has not replied anything pertaining to the MSME. She is relying on the judgments in Pronitz versus Board of Directors. In this case, The petitioner, therein the borrower, the court has observed at paragraph 7 that the borrower therein does not seem to have ever claimed the benefit of the terms of the framework after the demand notice under section 13(2) of the under the Surfacey Act was issued. It is at the stage of compliance with an order passed by the magistrate under section 14 of the Surfacey Act. The writ petition has been filed before the court, claiming benefit of the framework to restrain the bank and its officers from proceeding further under the securitization and reconstruction of financial under the Surfacey Act. This is in Swami Samarth construction, not Pronits, so and so. The court has held that, as in this case, he has approached the bank at a later stage under section 14. The court has held that the same is not applicable and that he cannot, he ought to have taken the stand at the time of when a 13(2) notice is issued. In Pronit's case, which paragraph you're relying on? In Pronit's case?
Let's have also placed the ITC Limited versus Blue Coast judgment on record, my lords, which talks about the importance of section 13(3) reply notice by the Supreme Court. The two.
I'll record.
Please.
That
Yes.
landmark judgment very well clearly says, though it's a landmark judgment for 13(3)(a), it very clearly says that if it is only for settlement or deferring the recovery measures, even if the bank doesn't reply, the act of the conduct of the parties itself is sufficient enough. That very landmark judgment reports that. And in this case also, Swami Samarth, either ways, whether it is before 13(2) or after 13(2), makes it very clear that it has to be supported by an affidavit by with verifiable documents.
Yes. No, there is no dispute on that point. Only dispute is what the bank is doing. And is it a mere eyewash giving a reply, or it has to contain, there is a sanctity to that? This is the only question. So please come to this judgment in Pronits. Which paragraph you are? 20?
Paragraph 21, page number 46.
In paragraph number 22, the Honorable Apex Court has observed that the banks are not obligated to adopt the restructuring process on its own, or that the framework contained in the notification dated 29/5/2015, as revised from time to time, could not be said to be mandatory in nature, are highly erroneous and cannot be countenanced. And accordingly, set aside the order passed by the High Court. The learned counsel in her submissions, where is the judgment? In her submissions, learned counsel has relied on the judgment of the Apex Court in ITC versus Blue Coast Hotels Limited, 2018 SCC double line. She relied on paragraph number 20 and 27 or 20 to
20
27?
to 27, my lords.
20 to 27, extract that. When the whole purpose of the issuance of the RBI guidelines, time to time, and keeping in place a framework for the revival of these MSMEs. Is to ensure timely and smooth flow of credit to such enterprises, minimize the incidence of sickness among and enhance the competitiveness of such enterprises. The respondent bank is bound by the guidelines issued by the RBI in this regard from time to time. If the objections are not raised at 13.2, in the light of the judgment in some other constructions, that is not available to the borrower at a later point of time. The argument of the land counsel for the bank that they should have come up with an affidavit with the verifiable documents is unless and until an affidavit and with the verifiable document are not placed, that is, if that itself is a ground for not considering the case of the MSME, it would have reflected in the reply that is given by the bank. Now the counsel submits that the court will look at the objections that are filed. By looking at the objections, the bank cannot supplement its view as per that is passed in the what is stated in the reply. There is a sanctity to the provisions of the Act, and particularly to Rule 13(3)(a). In these circumstances, this court is of the view that the entire before that, land counsel for the petitioner submits that after the 13.2 notice is issued, they have paid certain amounts to the bank. And in that view of the matter, this court is of the view that the 13.2 itself has to be set aside, as they have to give a fresh demand notice on what is the outstanding amount that has to be paid by the bank. In view of the same, this court is passing the following order. The notice dated 13.2, dated so and so, issued by the bank is set aside. If any consequential proceedings that are taken up by the bank also has to go. Number two, the bank is at liberty to give a notice, notice anytime. And once the notice is given by the bank, the borrower is at liberty to come before to reply to the same or approach the bank as per the procedure, as per the framework that is in place, as per the circulars that are issued by the Reserve Bank of India from time to time. Accordingly, the writ petition is allowed.
It's one submission, my lords.
My lords. 13, whatever amount they have paid, if they would pay, either regularizes the account, not takes it from the account from being NPA. So we will withdraw the possession notice. Let the demand notice be there. Let them answer the reply to that.
All the subsequent proceedings after 13.2 or set aside as the reply that is given under 13.3(a), the bank is defective and the same is set aside. Now the bank, within 10 days from today, the respondent shall give the reply under section 13.3(a) to the reply dated 13.2, and if they want to if they are seeking the benefits under the MSME in the light of the settled law, whatever the steps that are to be taken, the borrower is at liberty.
My lords, one
Cell
submit.
number 40.
13.2, their reply, and then they issue the 13.4 notice afresh, Your Lordship.
So now the issue is 13.2 is there. 13.2 is there. That reply is set aside. They will give, and from there you can proceed.
Now, after the reply to them,
My lords, I have taken a specific stand on NPA classification as well. Anyway,
No, whatever it is,
whatever
you give the
is-
reply. No, that's all on the basis of the MSME and all you're seeking. If they don't give, then again, the same will repeat.
My lords, my submission, my lords, the demand notice and thereafter the reply has been issued to Rewards Resourcing Private Limited. There is a mistake, my lords, because the company's name is Rewards Sourcing Private Limited. However, the registered office address and the PAN
Then
details
council
are all
submits that.
there. It
It
may
is
be
a
just,
typographical mistake.
it's a typographical error, my lords,
Mentioning
none of
the
them.
name of the company.
Company's
name is?
Rewards Sourcing Private Limited, but it has been written as Rewards Resourcing Private Limited.
Rewards Sourcing
It is
a company,
company's
but it
name
is in the demand notice.
Demand
it's
notice,
Rewards
Rewards
Resourcing
Resourcing.
Company. And also for the bank submits that, they will rectify the same mistake in London. Yes.
40, Lakshmi Konske, petitioner.
For petition, 1 lakh paid, my lord, arrears of rent including. 8 weeks time I will be granted.
I have 1 of 25. No, we'll hear the writ petition.
Apart from the maintenance, 1,50,000 is awarded by the trial court for the wife to undergo surgery. She needs urgent surgery for laparoscopic hysterectomy. That is not said by
Come
this
to the
court.
order, we will decide this writ petition, sir.
Tomorrow also 50,000 will paid, madam. We'll pay.
Oh, it's a interlocutory order. Why should we keep it pending? Writ
Senior is
petition?
not there. Day after tomorrow. I will pay.
Day after tomorrow. Yes, next.
Interim order may be extended.
41,
Interim order granted is extended till then.
41, Jagdish, JR for
I'm
petitioner.
filing the affidavit and I'm paying.
Gave him a copy?
I have given them. And I'm being.
Huh?
Same mirror challenge before this Honorable Court. This Honorable Court mirror asked me whether it can be regularized. In fact, I said mirror, it can be mirror substitute to that mirror I will.
Take it.
For the regularization mirror, they have to pay mirror 43 lakhs 72,665 for regularization.
What is that?
That's it. What's that?
Presentation.
What do you say? He wants to pay everything by 28th February.
Instruction alert as on 8/12/2025 alert, not entirely. He's talking about alert, the old, not the outstanding, total outstanding.
Not outstanding.
Instruction alert at the earliest alert, they said alert on 8/12/2025 it is outstanding. By this month, they insisted in however I need to resume this on report. It can be extended for, the entire 47 lakhs 5,000 rupees, because I will buy it ready on that day, alert, I made a submission before the on report and we deferred it.
February is
I
not
understand.
long. Will grant it.
Because some substantial, not 2 lakh in this.
The 2 lakh, now I am paying 15 lakhs I am paying by.
1 minute, 1 minute. 31st December is paying 15 lakhs.
15 lakhs.
In the month of December
By
itself.
31st of January, will not be able to close it, whatever. Not paying it, because of the on report.
Your bank will keep it for 2 years and keeping the writ petition pending is fine. But for 1 month you will bargain.
This matter, please contact the bank. I would have sold it, I report it, 2 crore odd. This honorable directly, we not precipitate, we have deferred the sale, even the buyer.
February 28th is not a long time. It's not a long time. Please come. The writ petition is filed. Even the first installment of 50 lakhs is not paid, they will proceed further without further reference to the court.
I will do that.
Give that, take that number, give it to him.
That has been mentioned in.
It's there.
It's
That's
mentioned.
all. Keep it, it's mentioned, it's in.
Mention.
The writ petition is filed, seeking the following prayer. When the writ petition came up on 8/12/2025, this court has passed an order recording the submission of the petitioner that he had approached the bank for regularizing the account and the bank is not coming forward. Further, it is also recorded that land counsel for the respondent bank submits for regularizing the account that the amount that needs to be paid is an amount of rupees 47 lakh 5,000. And the bank has also filed a suit and also initiated proceedings under the Surfacey Act. Then this court has passed an order directing the petitioner to file an affidavit before this court when he will be paying an amount of rupees 47,05,000. The first installment shall be in the month of December 2025. The second installment shall be in January 2026, and the third installment shall be in February 2026. In the third installment, the incidental expenses, if any, that are incurred by the bank shall be paid by the petitioner.
Towards the suit filing expenses and.
Whatever it is that you can tell him that time. Even anytime you can tell him, he will pay it in the last installment, which is in the month of February. I'm disposing of. Today, when the matter came up, Len counsel for the petitioner submits that. As per the order dated 8/12/2025, he has filed the affidavit. As per the affidavit, he is ready to pay an amount of rupees, he is paying an amount of rupees 2 lakhs through the DD bearing number 628168 dated 12/12/2025, drawn on State Bank of India, Gauri Bidanur branch, and the same is handed over to the counsel appearing for the bank before this court. It is also stated that it is also undertaken that he is ready to make further payment of rupees 15 lakhs by on or before 31st December 2025, rupees 15 lakhs on or before January 2026, and the remaining amount with incidental charges by on or before 28th February 2026. The Land counsel appearing for the bank submits that the petitioner may be directed to pay the entire amount by January, but not till February. Next para, having heard the counsels on either side and taking into consideration the affidavit that is filed before this court dated 15/12/2025, this court is passing the following order.
Not January, but December itself.
In the month of December itself, the entire amount may be paid. Accordingly, the writ petition is allowed. The setting aside the order dated 11/11/2024, passed in criminal investigation number 53 of 2024. And all other.
Instead of allowed for it to be disposed of the reasons, kind of consent order. Disposed of the following directions and.
Accordingly, the petitioner shall pay an amount of rupees 15,000 on or before 31st December, 15 lakhs, another 15 lakhs on or before 31st of January, and the remaining amount with incidental charges, if any, by 28th February 2026. Next, number 2, if the petitioner fails to pay even the first installment, that any of the installment, the respondent bank is at liberty to proceed further without further reference to the court. Accordingly, the petition is disposed of.
They may be directed to hand over the possession, madam.
On payment of the first installment of 15 lakhs.
No. Now itself.
Huh?
No. Lord, without running the factory, we cannot pay, madam. That is the main.
December end is coming on the. On payment of the first installment of 15 lakhs, the possession shall be redelivered to the petitioner. If he fails to pay the second installment, the bank is at liberty to take steps and take the possession of the property. Yes.
Much obliged.
Yes, 42.
42, HS Prashant.
Yes.
Now, there are two loan accounts.
42,
Lordship, may kindly take note the interim order dated 5th December 2025, my lord. There was a direction to me not to deposit 2 lakh within, my lord, Monday, and balance, my lord, amount of rupees, my
There shall
lord.
be stay of all further proceeding pursuant to so and so on the condition the petitioner shall pay an amount of rupees 2 lakh by 8/12/2025.
Please.
The remaining amount shall be paid by 12/12/2025.
My Lordship, may kindly remember that in respect of my loan account, my lord, there was no due. My lord, may kindly turn to annexure, my lord, That's the bank statement, page 50, my lord, 3.
Oh, this is a matter.
Now, in respect of the other loan account, the petitioner, my lord, has already approached this honorable court, my lord, in writ petition, my lord, 9598. And there is a stay, my lord, that also, my lord, he has complied. In that view of the matter, I may not be directed, my lord, to make payment in respect of the other account. In respect of my account, though it is regular, just to comply the orders, my lord, I have already paid, my lord, 2 lakhs. Another sum of rupees 5 lakhs, my lord, I am ready, but they should hand over possession to me, my lord.
What is the outstanding in the other account?
8 lakh, my lord, 53,000 rupees.
There is a separate property, my lord, mortgage. They can take any action.
Very same petitioner wherein, my lord, the property is alienated. We don't have a locus to compete for this honorable court. In fact, my lord, that day, my lord, I considered saying that, in fact, he undertook before this
No,
honorable
let
court.
me
saying that the entire
understand,
fee is
let me understand the facts, Mr.
But I just
Vignesh.
pointed out, my lord, there are 2 loans. One is in Vinod Nagara, one is, my lord, the present branch.
Yes.
One loan, which is, my lord, small loan around 8,53,000 rupees. The petition, my lord, is a mortgagor. Wherein, my lord, he alienated the property, there is a fraud, declared as a fraud.
No.
Even the present loan is.
One minute, I understand, I know the facts, sir. So as far as a loan that the petition is referring to, and this writ petition is, there is no outstanding.
There is no.
But you cannot regularize the account because the other account is declared as NPA. For that, he has filed a writ petition before this court. Just along with so-and-so after vacation.
1 minute. And there is the 1 minute. He undertook before this honorable court while taking an interim order, saying that I am going to pay the entire money in respect of the fraud taken place in the other loan, which is alienated.
That property is sold.
That property, he sold it, my lord.
That's what I'm saying. Mr. Vignesh Shetty, without me understanding the facts, however aggressive you are, I can't do anything.
7,959,2025, maybe.
So in respect of the other writ petition, that property, that secured property he has sold.
Sold. So that is the reason. This account cannot be standard. So that now he can't come and approbate and reprobate, saying that, my lord, that even though I will not pay, only this money I will pay.
In respect of the other loan, in respect of, my lord, the other loan, he has already approached.
You are the borrower in respect of that also.
No.
You are the borrower and he sold the property.
No, borrower, my lord, what he does, he executes, my lord, 2 different GPS, my lord, in favor of the petitioner herein, and in favor of the petitioner, my lord, in the other writ petition. Thereby, my lord, virtually, my lord, he has sold the properties to both of us. Now, in respect of the other, my lord, property, the purchaser, my lord, he has approached this honorable court, my lord, by he has deposited 10% as directed.
This tomorrow, along with that.
7959.
Yes, list along with that tomorrow. It's next matter.
The interim order may kindly be extended.
Interim order earlier granted is extended till then.
Number 43, Parashuram A.
Lordship, a subsequent petition has been filed, which is pending before your lordship. This matter also may be tagged along with that matter.
What is this writ petition? What is that writ petition?
Your lordship, this writ petition was filed pending the proceedings before the DRT, and the subsequent petition was filed after the final order was decided.
So like all writ petitions only, you will not go anywhere. What is that writ petition? Is there any interim order in this?
No, your lordship.
Appear for respondent 1 and 3, my lord. There is no prayer against 1 and 3, my lord.
Huh?
There is no prayer against 1 and.
Yes.
Maybe
No interim
deleted-
order in this?
No interim order.
List this along with so and so, give the number, write it on a paper.
Please.
After vacation. Yes, next 44.
44,
Great, lordship.
Krishnamurthy N. 44,
Which is the bank?
Seeking mandamus, your lordship, to direct the court below to pass
Oh,
the
it's
order.
FC.
Kindly, your lordship.
Hmm.
If MC petition filed on 2/1/2023, I have filed on 18/11/2023, Annexure C, page 43, your lordship.
What happened to this? There is an order on.
Till the
18.
date, they have not passed any order.
No, 1 minute. These are judicial director to call for report from the third additional principal judge, family court. Where is that? She has sent it, but where is the report? What is the office note on this? No, office note on this. Pass over.
Kindly, your lordship.
Tell, send it right now to the registered judicial.
Yes, ma'am.
Yes, 45.
Cell number 45. Cell number 45,
No representation after vacation. Notice to the respondent. Yes, 46.
cell number 46. Cell number 46.
Here for the petitioners.
Archit N.
Lords, there's an application where mutual consent waiver application was rejected by the court, my lords. Impugned orders at page 18, stating that there are no, page 18, my lord. It states that no grounds made out to waive off the said period. Therefore, appear before the court after the completion of statutory period. So mutual consent petition, my lords.
Which court is this?
Second additional family court, my lord.
Please come to that order.
Yes, my lords, petitioners and their counsels are absent, kept by an orders. Both petitioners are absent.
No, I'm asking you page number.
Page 18, my lords. Page 18, middle, the application is accompanied by joint affidavit. It is the case of the petitioners that so and so it is, their marriage is solemnized on 18/5/2024. After the marriage, they lived cordially only for a few months. They could not resolve their differences. Subsequently, page 19, the bottom portion, therefore, in the circumstance, it appears that it is not proper to dispense with the mandate of the cooling off period of 6 months. Hence, the court proceeds to pass the following order.
Why should the cooling off period should be waived?
Lords, because there is no,
In every case, that is what it is.
yes, my lords, but in this case, the parties themselves have decided what they have.
Everybody will decide, like, that's not the reason for waiving. You married on 18/5/2024.
Yes, my lord.
The petition is agreed by the order dated 14/8/2025, passed by the Second Additional Principal Judge, Family Court, Bangalore, whereby I number 3 filed by the petitioners under Section 13B of the Hindu Marriage Act, reduced Section 10 of the Family Court Act, is dismissed, and directed the parties to call and directed the matter to be called on the expiry of statutory cooling period of 6 months by 10/2/2026. When counsel appearing for the petitioner submits that the court, without any basis, without considering the case of the petitioner and the application that is filed, has passed this order, and the court ought to have allowed I number 3. This court, having heard the learned counsel, the petitioner perused the order impugned. The court has observed that even for the sake of argument, if the application is considered under Section 10A2, then also, as noticed above, it is a case of the petitioner themselves that their marriage was solemnized on 18/5/2024, and in the wedlock they have a female child who is born on 2/4/2025. But it is not their contention that they are residing separately for more than a year, which cannot be accepted in view of the pleading of the petitioners themselves. Therefore, in the circumstances of the case, it appeared that it is not proper to dispense with the mandate cooling period of 6 months. Hence, the order is passed. The order that is passed by the court, this court do not find any reasons to interfere with the order passed by the court. Court had rightly considered and passed orders accordingly. Dismissed.
Cell number 47. Swaroop pays for petitioner.
Yes.
I appear for petition.
I'll take notice.
Well, let's may make submission. I'll serve a copy first. Loan amount is about 6 crores, my lords.
Let
There's
them
a
get
stay
it.
that is required, my lords. I'll just explain.
Tomorrow.
Tomorrow.
The papers. Mr.
Suresh.
Suresh? Suresh V is directed to take notice. This is the matter tomorrow.
Grateful.
Then counsel for the respondent shall get instructions. 48.
48. Cell number 48.
Appearing for the petition, my lord. My lord, due to some inconvenience, missing a place for the time, my lord.
After vacation.
Cell number 49. Cell number 49.
Here for the petitioner.
Who appears for the federal bank? Counsel? Any counsel?
I'm not aware.
Federal
Just-
Bank. No. No list is provided for us.
Take out hand summons.
Please, madam.
File a memo, then it will be listed.
Please, madam.
Petition is permitted to take out hand summons on the respondent bank. Once a memo is filed, list this matter. 50.
50.
Much.
Cell number 50.
This matter for the petitioner.
Jagadishwar.
Yes. What is the intent order?
That is maintenance application was filed by the respondent before the third additional family court. There was order to pay 15,000 per month.
What is the income of the husband?
21,000, my lord. He is as a become graduate, he is working as a
Only
account.
wife or
Wife and one child, my lord.
wife and one child.
He is having, petitioner is having old grandmother and mother. For him also, you want to maintain, he can't able to pay 15,000, my lord. So we have also filed earlier section 9 of conjugal rights on 8(2), but come and conjugate with me,
What happened
but
to that? What
that
happened?
still it is pending, my
Please
lord.
come. The petition is agreed with the order, interim order, where the court had granted 15,000 as maintenance. It is submitted that his income is 21,000 and he is not in a position to pay 15,000 as he has to take care of himself and his parents.
On submission,
Thanks.
right now I am ready to take my child and wife, ma'am, but she is not agreed for that.
What is that the court can do? Like notice for considering the submission of the council.
Till then stay may be granted.
They shall be stay on the condition that he shall pay 10,000 by 5th of every succeeding month and the arrears also at the same within 12 weeks. Note, take out hand summons on the council appearing for the respondent and shall file a memo to that effect by, what is 17th of January? 15th of January. If the memo is not filed by that time, the stay granted by this court stands vacated. Yes, next
Cell number 51. Savita N, petitioner.
Yes.
My lord, section 14 order is challenged, my lord. For the school building development, 93 lakhs loan is taken by the borrower. The borrower died on 6/7/2020, my lord. Later on 2021, bank has issued demand notice, and in the year 2023, it has issued possession notice.
When the borrower died?
6/7/2020.
When the Surfacey proceedings initiated?
Demand notice on 26/10/2021. Possession notice on 2/3/2023. This possession notice has been challenged in DRT, my lord. From that time, it is posted for objection. From last 2 years, it is posted for objection only. Hearing objection, till today, bank has not filed any objections. And section 14 order is also challenged and it is also pending.
No. How can you again question the 14 order before this court? When you already questioned before the DRT, why did you question again? Yes.
Lord, because we are not able to pay that amount, my lord, and we are identified the person who can handle this school and all, my lord. For that, I require 3 months time, my lord. Since
it's not that.
children.
Please listen, you approach the DRT, questioning section 14, an interim order is passed. Now, how can you come before this court questioning the very same relief? Whatever are the reasons. Court has entertained, DRT has entertained your essay.
Please, my lord. Because it's a running school, my lord, and 600 children are there, my lord. And if the bank has taken the possession, school children's life will be under question, my lord.
But you please understand, we can't interfere like this. Please come. The writ petition is filed seeking the following prayer. The bank had issued the 13-2 notice on 26/10/2021, the possession notice on 4/3/2023. Questioning the possession notice dated 4/3/2023, the petitioner has approached the DRT by filing essay number
147, my lord. 147 of 2023.
147 of 2023. In that court has granted stay on the condition that he shall pay.
So it was granted on essay number 530 of 2025.
Huh?
530 of 2025. Stay was granted.
No, questioning the two essays. So no, just questioning the notice under 13(4), essay number so and so is filed.
Yeah.
And questioning the sale notice.
Yes, possession notice. It was series orders has been passed. Series has been filed in the essay number 530.
They question the 14 order in another essay. They have filed essay number
530 of 2025.
530 of 2025, questioning the order passed by the magistrate under section 14 of the Surface Act. In the said essay, the court has granted stay on the condition that they shall pay how much? Pass on that.
41,51,000. Page number 30. The petition only is there available, my lord. Page number 35.
Rupees 41,50,667 within 2 months in 2 equal installments. The first installment of 20,75,833 shall be paid on or before 1/12/2025, and the second installment of rupees 20,75,834 shall be payable on or before 31/12/2025. This order is passed on 31st October 2025. Now the writ petition is filed seeking to quash the section 14 order passed by the principal senior civil judge and the chief judicial magistrate in criminal miscellaneous number 330 of 2025, dated 3/10/2025, and also seeking a direction to the respondent bank not to take the physical portion without following the due process of law. When counsel for the petitioner submits that the petitioners are not in a position to pay the amount, as such, some reasonable time may be granted to the petitioner. The writ petition as filed before this court is not maintainable. The order that is passed under section 14 by the magistrate is assigned before the DRT by filing essay number so and so. In that already an interim order is passed where the time is till end of December. The petitioner has not questioned an order that is passed by the DRT, but questioning the section 14 proceedings itself, having availed the remedy before the DRT and pending consultation before the DRT, the writ petition is not maintainable. Accordingly, dismissed as not maintainable.
Number 52.
Yes.
52.
For the petitioner, my lord.
Yes.
My lord, this is a case of parental abduction of a 3-year-old boy child. I am for the father. There's a JNWC that is filed by the mother. I had filed a section 9 application stating the court here in Bangalore has no jurisdiction. That came to be rejected, my lord, on the sole ground that mother's employment visa is expiring in June 2025, which is why the child is not ordinarily resident. My lord, it is a settled law that ordinarily resident under section 9 will not be determined based on the mother's residence. It's been a year, my lord. I have not seen my child. I had filed for habeas corpus as well before the divisional bench.
According to you, where is the child ordinarily residing?
It is ordinarily resident in the UK, my lord, because the child was born, it was raised there, and it was admitted to nursery also there. And there is a foreign court order also. The High Court of Justice has passed an order stating that child is a ward of the UK court.
What is the age of the child?
3 years, my lord. This December it has turned 3. It is a boy child. The High Court of Justice there.
The mother staying.
Pardon, my lord?
Where is the mother?
Mother at present is in Bangalore.
Presently in Bangalore, my lord.
See, it is my lord, let me submit. This is like, the court has come across many cases like this. It is, in this instance, the mother, a kind of parental abduction, very cleverly.
No. Before that, I want the facts. When
Yes.
did the child brought to India?
Please, my lord. In December 2020, me and my wife, both we were staying in the United Kingdom since 2019. Since 2019, we were staying there. In December 2024, it was our joint decision that only I, with the child, will come to Bangalore to show it to my grandparents. Me and my wife, we had booked the return tickets also together, my lord. That means of mine and the child. So she was well aware that I will come back after a month. But what happened, just few days after I came here, 17th of December, my lord, she, to my surprise, turned up at my residence here in Bangalore. And she said, I will take the child for 2 days and return the child back to you. I said, fine, that's okay. But what she has done, on 18th, she has filed GNWC. And on 19th, when I went to her house was locked. I have sent her email, WhatsApp messages, everything, no reply. No reply, my lord. Panicked as a father, I have lodged a child missing complaint with the Ramurthy Nagar police station as well. but nothing happened. It was only after 10 days, somewhere around on 28th December, my lord, she said she's in Chennai. She's in Chennai. If you want to see the child, you come there, she said. I, as a father, the same day I went to Chennai, but then there she showed me the child in a hotel. Hardly I could interact with the child. Later, the child was taken away by persons who are not known to me. After that, my lord, since the return tickets were booked and I'm working in UK, starting of January, I immediately left alone to the UK there. So then I received a notice from the family court stating that she has filed for JNWC. That's how the events have transpired, my lord.
What has happened in UK?
UK, an interim order was passed for the return.
When was those proceedings initiated?
Please, ma'am.
Yes, yes. Prior to this. I'll just see. Next picture. Here.
On 6th of February, my lord. 6th of February.
6th of February 2025.
Fine, please.
After this.
Yes, after this. I received the family court here, Bangalore notice on 6th of January. 6th of January, GNWC notice I received.
What is the order passed by the family court?
They are telling, that's what, my lord. I filed my wakalat and I filed my IA also, section 9 IA, stating the court here has no jurisdiction. But then the family court has told that since the mother's employment visa is expiring in 2025, so the child is also ordinarily resident in Bangalore only, the court has jurisdiction is what. That's the only ground, my lord, no other reason.
No, you please tell the court. How will the mother go to your UK now?
My lord, since 2019.
I'm just asking you a question. Please. Boy is aged about 3 years.
Please.
Now we'll say the courts at UK have jurisdiction.
Please.
If there is a way that she can also go to UK, you fight all your litigation there. That's a different aspect.
Please.
But she cannot go to UK because there is no visa to her. What is to be done now?
No, but that doesn't define the jurisdiction of the court.
But at the same time, we have to, while exercising the parent patriarch jurisdiction, we have to look at the welfare of the
Nothing is
child.
mentioned in the order, my lord. It's a blonde order.
And no divorce is filed yet, my lord. No divorce is filed by either parties. I'm willing to take her back also.
It is a typical case of.
Please make arrangements for her visa, then we will see.
Certainly, my lord, if she accepts. Now, in the meantime, since I have not seen my child since more than 1 year plus, and before this court for visitation rights, I have not seen my child.
From when?
More than 1 year.
Since January 2025, I have not seen.
Please take out hand summons on the counsel for the respondent. I'll take up on day after tomorrow.
Day after.
Petition is permitted to take out hand summons on the counsel appearing for the respondent. This is matter day after tomorrow.
Cell number 53, 53, Nagarajam, H. Nagaraj, petitioner.
Yes. What is the relief you are seeking?
Relief I am seeking for, I read the reasonable time, Your Honor, to pay, to clear the dues, Your Honor. The bank has suddenly shut down, Your Honor, the branch which was located in the Mysore.
How much is outstanding as on today?
As on today, 25 lakhs, Your Honor.
When will you go, when are you going to pay?
I need reasonable time, Your Honor, for that.
That you will tell or I have to tell?
Let this honorable court decide, Your Honor.
I'll say you pay by December 31st.
I need 2 months, Your Honor, 2 months.
That's what I'm asking.
Yes, 2 months time.
Who appears to the respondent, which is the bank?
Hero Housing Finance, Your Honor.
Against everything, writ petitions. Hero Housing Finance Limited. What is this? Manager Muthu Kumar, National Housing. It's at New Delhi. Notice to the respondents. We can't pass any orders now.
Cell number 54.
Much obliged.
Sharad
Yes, sir,
Kumar
54.
Shetty, for petitioner.
I am the borrower. Myself and my husband as the borrower. They have taken the loan of rupees 13 lakh. Your Lordship, in the year 2020, my husband has passed away, and there is a insurance coverage, but till the date they are not stating that there is a insurance or not. Your Lordship, last
No, your husband has borrowed the money.
no, myself and both are the borrower and the co-borrower. So at
How
that
much was borrowed?
so 13 lakhs.
What is outstanding now?
Outstanding is 13 lakh 70,000. Your Lordship, I am
What is
regularized the
for-
account. If at all there is
What is your prayer before this court?
to set aside the notice in
What notice?
vacating notice, Your Lordship, which is Annexure C, page 25.
Which is the bank?
Which Mysuru Mattu Cooperative Bank.
Yes, petition is permitted to take out hand summons on the respondent bank and file a memo. Once a memo is filed, it's the matter.
Your Lordship, there is a threat, Your Lordship, I'll pay some amount, because Your Lordship, Friday also I have paid 50,000 rupees, and my husband, I mean, my father also is hospitalized because. And
That's not the way the court will
Your
interfere
Lordship,
in such a matter.
because Your
First
Lordship.
of all,
If at all there is no. Sorry, Your Lordship.
Why should the court interfere? What are the legal reasons for this?
Your Lordship, what happened, Your Lordship? I have made a request before the bank to give the statement of account till the date, except the 14 order, Your Lordship. I don't have any document. And the bank is threatening, Your Lordship, because it's a residential house. I'm ready to pay certain amount if at all, Your Lordship.
This certain amount, 1 crore loan.
No, 13 lakh.
Paying 10 lakhs or peanuts. Why should this court interfere? What is the jurisdiction
Because
of
Your
this
Lordship,
court? That I'm not able to understand.
it's a mercy petition. Because Your Lordship, Your Lordship, the NPA has declared after the demise of my husband. So, Your Lordship, I ready to regularize the account, or in the span of the time, Your Lordship, I'll close the account, Your Lordship, because it's a residential house.
How much you will pay?
2 lakh I will pay, Your Lordship, within.
Outstanding of 36 lakhs, you will pay.
13 lakhs, 13 lakhs 70,000. Kindly, Your Lordship, page 13 lakhs. It's not a 30. Kindly, Your Lordship.
If you're ready to pay half of the amount, then I'll pass an interim order. Or else no.
Half of the amount is very difficult. Your Lordship. Your Lordship, 25% within 4 weeks, Your Lordship. Kindly, Your Lordship, page.
Concept has come.
Page 17, Your Lordship.
First of all, there should be you have not even raised one legal ground. Why I should interfere with this? When there is no legal ground, where should there is a question of granting interim order?
In this matter, what happened?
What will happen is
except the affixture, I don't have any
Now
documents.
you will pay 2 lakhs. This writ petition will be pending for the next till 2026.
No, Your Lordship.
That's what's
I'll file
happening.
affidavit, Your Lordship, I'll regularize the account if at all the bank is ready.
First of all, for that you have to issue notice to the bank.
And if at all they take the position, Your Lordship, I will be in road, Your Lordship.
If you are ready, if you can take out hand summons, I'll hear it even on Friday also.
So it's a
Not
Mysore,
problem.
Your Lordship. It's Mysore. The bank is in Mysore.
I can't help it.
Your Lordship, 25% within 4 weeks, I will, Your Lordship. Immediately the matter may be posted, Your Lordship. If at all the bank is not ready for the regularize, I'll clear the amount within 6 months, Your
I
Lordship.
have not passed that kind of orders. If I pass in your case, everybody will insist for that. There should be some
Some
uniform.
cases, Your Lordship, it's a must because my husband has died due to heart attack, and my father also is hospitalized right now. If at all, I'll produce the documents, Your Lordship. Exceptional case, Your Lordship, because
File an undertaking, come before the court with an undertaking.
I'll file up.
You can't take out hand summons, file an undertaking.
I'll file up.
This is matter on Friday.
Tomorrow day after, because otherwise, Your Lordship,
This is matter tomorrow at the request of non-consular petition.
Kindly.
Yes. And by the time if the undertaking is not filed, the court will not go into, will not consider the merits of the matter. And on that ground, it will be dismissed.
In the meantime, Your Lordship, because
No meantime.
yesterday also they have, Saturday I have paid 50,000, Your Lordship. For that reason, Your Lordship, bank is not, today, if at all they came, Your Lordship.
I can't help it, Mr. Counsel. Yes.
Cell number
This tomorrow.
Kindly.
56, Raja Ramesh. 56.
I'm the 55. I'm for the petitioner, my lord. My lord, serial number 55, my lord.
55. Manjunath.
For the petitioner, my lord. Please, my lord.
This 55 or 56, no call.
55.
55. Yes.
My lord, this is a petition for early disposal of maintenance application, my lord.
What happened to the maintenance application?
My lord, an application was filed on June 2024, my lord. It is still pending for consideration, my lord. Though an objection was filed, and my lord, due to the fault of the
Which court is this?
went to December 2025, and no order has been passed, my lord.
Which court
My
is
lord,
this?
fifth additional principal family court, my lord. Fifth additional family court, Bangalore, my lord.
Which month it is filed?
My lord, on June 2024.
June 2024. When the objections were filed?
My lord,
The present petition is filed, seeking a mandamus, directing the fifth additional family court Bangalore to dispose of I number 3. I number 3 is filed seeking interim maintenance. This was filed in the month of June 2024, and it is submitted with the counsel appearing to the petitioner that already objections were filed by the respondent husband. In spite of the same, the matter is pending. This court time and again has issued several directions to the family courts to dispose of the IA for maintenance and visitation within 1 month. Why this matter is pending from 2024? The registrar judiciary is there to call for a report from the. You said fifth additional. This is matter day after tomorrow. Yes.
Cell number 56. Rajaram, yes, for petitioner.
I am the borrower of this case,
Yes.
my lord. My lord, earlier we have acquired, they gave their loan as 18 lakh on
Canara Bank,
2015.
where is Mr. Who appears for Canara Bank?
Canara Bank, Divya Purandar.
And
Canara Bank. Karnataka Bank, Union Bank, no.
give that list, keep that list here one.
Canara Bank, Vignesh Shetty, and one more advocate has given yesterday. Nandish Patila. Nobro Kotala. Vinay Bhatt. Vinay Bhatt, one more advocate is there.
So and so is directed to take notice on behalf of the respondent bank, serve the bank. Yes, they have to.
Yeah, much of that.
Cell number, admission matter, cell number 57.
My lord, I am for appellant claimant's appeal, my lord. Dispensation and notice.
A memo is filed seeking dispensation of notice to R1 dispensed with notice to the other respondent 58.
Cell number
Notice.
58.
Notice.
Dispensation.
59. Dispensation to whom?
R1 and R2.
Memo is filed seeking dispensation of R1 and R2. Dispense with notice to the other respondent. Next, yes, Mr. Sharanagoda.
BC
This case,
Shivanagoda.
insurance company is challenging the liability on the ground that driver is not having a driving license to drive the vehicle after the amendment. And
No, when is the policy?
policy is admitted, my lord. Driving license
That's what I'm saying. Policy is prior to the amendment or before amendment?
prior to the amendment to 23 months.
Then
The there is no driving license.
that will, what was applied by the courts prior to amendment is what we have to say.
Correct, my lord. Even under the World Act also, pay and recovery has to be passed. But there is no pay and recovery in that order.
So that is the only thing you are asking.
And no,
What is the amount?
not only that, my lord, there is another fact, my lord, of the disease there are 4 cases, connected cases. In a motorcycle, 4 persons were traveling in the motorcycle, came and hit the uninsured tractor. Trailer was insured. Without considering that, not the liability was passed against
So
us.
how it will be considered? What is the amount?
The 12,81,000. My lord, in a connected matter, by the division bench, my lord, the stay was granted subject to deposit of 50%, and it is ordered to kept in the FD.
Subject to deposit?
50% of the award amount, and it is ordered to kept in FD.
How much was directed to be deposited?
Pardon?
50% of this amount.
12,81,800 is the award in this case, my lord.
In that
In
case,
that 36 lakh and 32 lakhs.
the land counsel for the appellant submits that there were 4 people were riding on the vehicle. There was no driving license. The court has not passed an order of pay and recover and held the insurance company alone liable to pay the compensation. Considering the same, there shall be stay of all further proceedings on the condition that the petitioner shall pay and shall deposit an amount of rupees 8 lakhs. On such deposit, the respondents are at liberty to withdraw as
No.
per the condition imposed by the tribunal.
My lord, that is not permissible.
Why? Because pay and recovery you will get.
Negligence is also there, my lord. Therefore, my lord, considering that fact, my lord, there are other 2 connected matter before the division bench, in which, my lord, this the Disamba court has granted the stay subject to deposit 50, and it may be kept in FD. I am ready to deposit entire amount also till the disposal.
Death, in a case of that, death claimants require money, isn't it?
My lord, There are 4 people in a 2 motorcycle, man. There are 4 persons who are
What would
traveling. in
happen, at best, what would happen? We would
Well,
say some contributory
Not only that,
negligence.
Milan, but the uninsured tractor was dashed against my trailer was insured with insurance company. Tractor was dashed against my. There is no role on. Therefore, not considering all these facts, Milan, I am ready to deposit. It may be kept in the bank. It will earn money, Milan. Owner of the motor, in order to consider the contributory negligence, deceased himself was driving the vehicle. That vehicle owner is not made a party to
There
the
are 4 people. Is this the one riding the vehicle?
No, she is the minor.
Then pillion rider. Question of-
Composite negligence can
No,
be taken
in
into
case of-
consideration.
In case of a pillion rider, question of contributory negligence will not arise.
No, composite negligence, Malad, because she would knowing fully well,
That case also.
knowing fully well,
Even in
Malad,
that case also, they have a right either to file seeking compensation against you and like both the vehicles. Then you will recover from the, from the
from
owner
whom,
of
Malad,
that
I have to record because it is an uninsured vehicle. We is not a party to the proceeding. Where I have to recover the amount from the Malad, tractor was uninsured, trailer was insured with me. Without a tractor, Malad, the vehicle cannot. He is not, the owner is not a party to the proceeding. Therefore, Malad, there is a substantial question of law. I am ready to deposit medal. It may be kept in the FD.
entire amount
Please.
within a period of 4 weeks, and the same shall be kept in the fixed deposit. Notice to the respondent. In this also notice.
Stay.
60.
Stay.
Please.
Yes. 60 notice.
For the appellant.
Cell number
Which case?
61.
60, my lord.
Notice to the respondent.
Not.
61.
61.
Serial number 61, my lords, the parties have settled the matter and they have filed a 13B petition before the family court, my lords, before the trial court. Now, my lords, once that is disposed of, they will report the settlement before this court. Let it be taken up after vacation. That's only the question.
When
13B, there are certain conditions, my lord, that amount has to be paid and all. My lords. That process is going on. For that purpose, I am requesting.
we'll say that in case if there are.
Please, please, I have the memo ready, my lords, subject to what my learned friend says.
Okay.
Please. Produce the order sheet of the family court as well as the 13B petition, please, my lords.
Give him a copy. You have a copy.
I have given him, my lords. On the last date itself. A total amount of
It is
25 lakhs it is
submitted
settled, please.
in the mediation, parties of the dispute between the parties is settled, and they have filed a petition before the court seeking mutual consent, divorce. As such, a memo is filed seeking to set aside the order passed by the Principal Judge Family Court Chikmagalur in criminal miscellaneous number 34 of 2020. The memo is taken on record, and the order impugned dated 12/10/2022 is set aside. The liberty is given to the if in case for any reason, if they're not able to settle the disputes, the order automatically stands restored and the petition is at liberty to renew this petition.
Please, please. So great.
Cell number 62.
For the petition in this case, your lordships. My lords, in this matter, a petition under section 125 of the CRPC has been dismissed against the petitioner. The petitioner had sought 25,000
Yes,
rupees.
notice to the respondent.
Much obliged.
Notice to the respondent.
Much
Cell number
obliged.
63.
Husband petition
Which understood?
against the grant of maintenance. In an earlier occasion, before this honorable court, a 10,000 has been awarded. There is an interim order of stay by this court, granting subject to payment of 5,000 rupees per month. This is the interim order granted.
How much it was granted now?
10,000 now. 10,000.
So what is the earlier order? I am not able to.
Earlier order has been paid. There is an interim order in the same proceedings.
No, this matter is coming up first time.
Please, earlier an interim order was passed by the family court. I come up before this honorable court in a writ petition.
That's an interlocutory order.
That is an interlocutory. Very same order has been passed now. I am paying the 5,000 rupees per month for every day. Up to date I have paid.
What is your income?
I am a a helper to a deed writer, 500 rupees per day. That is the salary I am getting.
Why, how it is considered by the court? Let us.
The trial court proceeded on the basis, you lost my kindly take. Page 36, para 30.
Please read.
Therefore, under these said circumstances, now it is the question remains with regard to the quantum of maintenance to be paid by the respondent. It is point to be noted out the objection statement, the respondent has not denied the payment of arrears of maintenance to the petitioner. It is earlier order passed by this court. Even though he has made several allegations on thereby the respondent has admitted, consented to pay monthly maintenance at the amount of rupees to the petitioner, but he has not admitted to the extent of the claim of the petitioner. The respondent has stated that he is ready to pay monthly maintenance rupees 3,000 to the petitioner by considering the economical finance status. So the respondent is not denied discharge is liability to pay liability and the responsibility to pay the maintenance to the petitioner. Therefore, under these circumstances, the only question remains with regard to the quantum of maintenance amount to be paid by the respondent. The petitioner has stated the respondent having monthly income of 1 lakh through the bookstall, and thereby she is claiming 50,000 monthly maintenance from her. The respondent is not admitted income capacity as stated by the petitioner. The respondent is stated he is not having any bookstall. He is working as an employee in a bookstall. It is also stated that he is working as a deed writer at Malavalli. Therefore, the respondent having a monthly income of rupees 8,000 to 10,000, which is not sufficient to lead his life and to pay maintenance to the petitioner. So the respondent is not admitted about his income. Therefore, here in this case, the petition will consider quantum of income. This is the only reason on which the amount has been awarded.
Yes, let counsel reason submitted the petition's income is 10,000, 15,000, and the court has granted an amount of 10,000, 5,000 by 5th of February. If arrears, if any,
please,
within 8 weeks. Please. Notice the respondent. Yes, next.
Bill number 64, preliminary hearing. Arun Govindraj for petitioner.
Your Lordship, this is a matter wherein
Reshma Petty.
the interim order granted by this honorable court reduced it from 1 lakh to 50,000, 25 for the mother, 25 for the daughter. This was a conditional order to be paid even with arrears within 3 months. That order has been violated. Therefore, since it was a conditional order, it goes. Subsequently, your Lordship passed an order saying not to precipitate. Your Lordship had even met the parties in this matter. This is a matter wherein he claims that he's not able to pay. This is a 350 crore to 500 crore company which they run. He's in the merchant navy. He runs several other companies.
Order that not to precipitate.
Please, Your Lordship. 31/7/2025, Your Lordship.
Thirty-one 7/2025.
28/8, no.
No.
Where is her order?
There is an order on 29/7.
Your Lordship, on 31/7, it
31/7
says 31/7.
Petitions. Which
Then
petitions?
RPFC only, Your Lordship. Your Lordship, the other two matters would be inconsequential.
RPFC number.
Connected
matter. 176 of 2024.
Give that one.
Thirty-one 7/2025, Your Lordship.
No, something is wrong. This starts with 28/8/2024. You're saying about 25 order.
Please, Your Lordship.
31/7/25, my lords.
This is matter on 4/8/2025.
Please, till such time,
respondent shall not
take coercive steps. If your lordship just goes back to the interim order granted, which is a conditional order, which is on 9/4, 9/4/2025. Your lordship may kindly see. However, for the time being, the court deems it appropriate to take up IA 4/2024 for stay of consideration. There shall be a stay of the impugned order dated 20/10/2023, passed in so and so, so and so, subject to the condition that the petitioner pays/deposits a sum of 50,000 per month as maintenance to the respondents 1 and 2, as against 1 lakh ordered by the learned judge of the family court, and the petitioner shall also pay the arrears of maintenance at the rate of 50,000 per month within a period of 3 months from today. Therefore, your lordship, even if it is not 1 lakh and it is 50,000, within 3 months he was supposed to clear all the dues from the date of payment. It was a conditional order. This was not complied with. Came up before your lordship, and very conveniently mentions your lordship, and then your lordship says that there shall be no coercive steps. Subsequent to this, how their interpretation is whatever
That day, there is no representation on your behalf?
His father was supposed to come, he was not able to come, my lord. He had come for one interaction before your lordship.
No. When this order is passed,
Yes.
there is no representation on behalf of the.
There was.
We were not counsel on record, your lordship. We came in subsequently.
Counsel was there.
Yes.
That time when the order is passed, counsel.
Council was there, of course, council was.
No. This is not your lordship. This not to take coercive steps was since your lordship wanted to see if this matter could be settled. After that, your lordship has heard the parties. In fact, your lordship even mentioned, let him not come with this chappal and all of that. I'm not too impressed, your lordship. So that was an act that your lordship was able to see through. Lordship, what has happened is they are not willing to settle. Then he says father was not able to come. Then one day it went off on that.
I think we asked father to come.
Correct. Please, your lordship.
On the day he came, Lord, there was no, my lord was not sitting in the afternoon in the chamber. So the next day it was listed, but on that day he said he couldn't come and he wanted another date. At which time they said, let the matter go back to court and let the matter be heard on merits.
Your lordship, because it didn't look like it would even work out. Now all we say is, your lordship, this is an order as against the maintenance in RPFC. Learned counsel had this argument that there was another order passed in the divorce matter. Those are the 2 writ petitions that are pending. I'm stating I will file a memo to this effect right now that I'm going to withdraw that. I will not press on that. So there goes both those writ petitions. We are only on the factor whether he can pay 1 lakh per month or not. She has a 19-year-old daughter. She has borne her expenses from date of birth up to now. She's given a list of how much she has spent all along for her education, and she's only 19. She has to study further. He's not spent a penny. Last time, if your lordship recollects, I had produced a video where he claimed he couldn't speak, had accident, and he's having a gala time with his supposed second wife, and he doesn't even have without even a divorce. He also seems to adopt some random child and says this is for my daughter, and has the most extravagant birthday parties for that girl. He seems to have 2 women. One is your lordship, one Miss Nair, and another lady also, Dimple, whom now he claims is his supposed second wife. Now he is not willing to take care of his own daughter. All we say is right now, your lordship, if the final orders could be passed in this matter, or if the interim order could be vacated, your lordship, she can proceed at least with her execution. She doesn't have a penny. She's still living off her father. Her father had retired as senior most IPS officer, most decorated, honest person. He has borne all her expenses till date. This man has had a most lavish lifestyle. He has, your lordship, for just an example, he has something called a studio recording where all underwater, deep water recordings in any movie is done in his studio. He also has the international level deep diving pools where people from all over the country can come only there to try, because it's a 30-foot deep pool which you don't get anywhere. All the underwater incredibly difficult scenes which normally people have to go abroad to do are all done by them here. So even the fanciest of the topmost film stars are all at his place to record. Besides that, since he's from the Merchant Navy, he's opened training classes for Merchant Navy and all other allied ship-related institutions that he has started. And now he claims before your lordship, I don't have a penny. I'm not in good terms with my parents. I have all the details I've produced with my... he he is a director in all those companies, and it is not his parents or his brothers who run it. It's he who runs it in their names, Your Lordship. So he owns nearly a 500 crore company, and he's not able to pay to his daughter 25,000 rupees. And they want to fight over that, Your Lordship.
Yes, Mr.
Lord, I think what the Learned Senior Counsel is submitting before the court, none of it is on record. I don't know where this information
Yes,
comes
I'll
from.
right away pass it on.
Lord, it's not on record before the court. We are in revision. Lord, revision is to be decided on the basis of exhibits and evidence.
Always
Yeah, Lord,
any RPF.
50,000. Lord, 50,000 is what I have been paying. I've been paying every month. Lord,
We'll do one thing.
yes.
This, whatever that not to take coercive steps, that order I
Pay-
vacate.
Lord, I will have to make my submission on that. Lord, 50.
That is granted only for the purpose, limited purpose, that the court wants to interact.
Yes.
That has not fructified. So let that order go. Whatever the earlier order of stay is concerned, that has to be complied with.
Lord.
Without that, we can't have a blanket order in RPFC.
Lord, 50,000 rupees per month I'm complying with.
No,
I'm paying, except
last
for 2
3
months.
months they've not
2
paid.
months. 2 months.
No, last 3 months they've not paid. They're
November-
trying to interpret the not to take coercive steps as they won't pay, and
Not
I
so.
can't proceed to file execution. It was very convenient.
Lord, but
So
I must
even
be allowed to
50,000
make
has
my
not come.
submissions. My learned friend, Lord, the client has been instructed that 50,000 rupees has to be paid no matter what. But so far as the arrears are concerned, not 15 years, Lord, I have to pay.
Then at least you have to, then how the husband is thinking that the wife and the child will, daughter will sustain without without payment of any amount.
Lord, 50,000 per month, I'm continuing to pay. I will continue to pay.
Happen to the earlier amount. If at best what you can seek is the arrears, you can say that I'll pay in this time bound manner, but you cannot say that there can't be any.
Absolutely not. That's not the stand I want to take. So 25,000 rupees was the interim order that was passed by the family court, which I complied with for 15 years.
So if that's the case,
that
the amount what remains is 25,000.
We have deducted and
They're
then
asking
asked.
for 1 lakh is what is awarded now, not 4 times more than what I was
As
paying.
per the interim order.
Yes.
We will not interfere with the interim order. Now, according to you, you have paid 25,000.
Yes.
The remaining amount is 25,000. So for these many years, how much the amount
I've
is coming?
calculated. I've calculated. Might I pass it on?
Just a reference.
Not more than 45 lakhs
At 25.
at 25,000.
Give.
Because per year is 3 lakhs, 15 years.
Just give it there. Your Lordship, this is total from 11/3/2010 to 10/12/2025, 189 months. Amount is 1 lakh into 189, that comes to 1 crore 89 lakhs, Your Lordship. Total paid with final maintenance also, we've deducted. Balance amount to be paid as of today is 146. If he wants to take half of it also, as per his interim order, he should have cleared half of 146. And Your Lordship, the next
How it comes to, how much it comes to 146?
half of sub around 76, Your Lordship.
73.
140 would be 173. 73 lakhs.
Seems he's already paid, he has been paying 25,000. So again, it should be half.
I've deducted all of that, Your Lordship. I've made all those deductions.
Total months from 11/3/2020 to 10/11, 189 months. Amount per month.
But half would
Total
be
paid interim maintenance.
189, half would be 94.5 lakhs, out of which 42 lakhs is already paid.
Your Lordship, may kindly see total amount paid interim maintenance and
according
plus
to you.
final, all of that deducted.
1,89,000, 1 crore
89
89
lakhs.
lakhs.
Please.
1 crore 89 lakhs is the amount.
Till date, 42 has been paid.
It comes to 94 lakh 50,000. If it is 50% of the amount.
Please.
In that you say that he has paid minus 42,000.
42 lakhs.
70,000. It comes to 51 lakh 80,000. Is the half of the amount. At 50,000 as ordered by the coordinator.
Please.
Yes.
Please.
May I make some payment to show my bona fides? I understand we are at the eve of vacation. The court may not have time to hear us on merits on the main matter. May I make, my colleague is just finding out how much he can deposit. We will make some payment. The intent is not to pay anything at all.
Your Lordship, that itself was half the amount. In that 3 months granted, and last 3 months, even that amount is not paid, arrears not paid. And these are not people that even need a minute. They have crores in their pockets and
No,
they want to
that's-
behave this way, Your Lordship.
No, he was.
And taking care of the child, it's not about her. The child has been completely, and some other child is having these.
What is she doing?
The daughter, Your Lordship,
She's in the
she's
college.
finishing degree.
Second year BBA.
Second year BBA.
The first time I went to see her face, not when she was 2.5 years old, after I separated, a criminal case was filed.
What about that? Why the father is not
3
able to
criminal
see the
cases.
child?
We want him to be with his daughter any time, Your Lordship.
Then we will pass that order.
Very well.
Please,
Lord.
please.
Lord, the first time I came to, the criminal case started with me going there to visit my daughter.
There is an order in family court visitation.
Huh.
It's been granted.
What she said?
Visitation orders granted in the family court.
Yes.
2020 onwards, he has a visitation.
No, no, no.
He has visited the child and he has threatened the child in the court also. So,
Threaten the child.
yes.
Saying what?
If you are eating my food, you are this one. And he started scolding the child. And she was a bit apprehensive. Last he saw the child.
Yes, Mr. Arun Govindran.
Lord, I've come on record in the High Court.
He's capable of saying all that. I've seen him in the chambers the other day.
Highly unlikely, not his own daughter, someone, not who's been
No,
craving to see
his
for the last
own
18
daughter,
years.
no, even random daughters. She's never had a birthday party till date. And the most fancy.
That you have shown me on the
Please,
last
please.
occasion I saw.
And Your Lordship, to just get this matter listed before Your Lordship, his colleague has to wait till 8:30 here, Your Lordship, because 3 matters conveniently they connect. They ensure that each file is in a different place. And for us to just get it listed, Your Lordship, it is very difficult. I've been saying, please learn from them, I was telling. Just to get it listed is hell, Your Lordship.
Lord, may I make this request, Lord? There are 2 months arrears for November and December, 50,000 each. That 1 lakh I'll pay by tomorrow, my Lord. Another 5 lakhs I'll deposit within 2 weeks. First week of January, and the matter may be called in the first week of January itself. Lord, Lordship may make it parted and we'll go on with it.
No, not that. 51 lakh 80,000. 5 lakhs is not the payment.
Lord, kindly see, I placed documents on record before the family court. He was a merchant navy captain earning 6 lakhs a month.
What was his answer to all those videos he's doing?
But Lord, those documents have never been placed on record before any court.
The videos, he was there on the last occasion. He was celebrating, he was telling that
But he
I'm
said-
treating so and so and I'm celebrating all that. Where
But he's-
from he's getting the money?
His friend had a birthday party for her daughter, and he was part of the guest list, my Lord.
No, have you filed what is the account statement of that company?
Yes.
What is the income of that?
Lord, I filed for 10 years. It has never cost more than 1 lakh per annum.
That company which they're referring to?
Yes.
Not the company. He's trying to show he doesn't earn more than about
No,
companies.
company. All the details I've produced along with filing. And Your
Companies,
Lordship,
I filed
most
not from-
important, his IT returns, what he files here, and 2 documents in the family court, they are themselves forged. And I can show it. He's in for a lot of trouble, Your Lordship, if he's going to go.
If
Even
that's
the
the case, of
IT
course, my Lord.
documents itself are.
So why don't you, I mean, put in writing in that? and
I
give a
filed my
copy to
detailed
him?
objections. I've served them also, Your Lordship. All I plead, Your Lordship, nothing much is going to happen if the interim order is vacated. I only have to file execution, which is a long way to go. Lordship might even hear it tomorrow, day after. I'm fine. Or even final matter. All matters, Your Lordship, in a flash, Your Lordship is able to hear.
But a warrant was issued, my Lord. A non-bailable warrant was issued.
Senior counsel appearing for the respondent wife submits that as the family court has awarded an amount of rupees 1 lakh as maintenance, 50,000 to the wife and 50,000 to the daughter. And an interim order is passed by a coordinate bench of this court whereby the petition was directed, stay was granted on the condition that he shall pay 50,000, 25,000 each, and arrears also at 50,000. It is submitted that this court has earlier wanted to interacted with the parties. Before interacting with the parties, an order was passed not to take any coercive steps. From the last 2 months, the husband is not paying any amount, nor the wife is in a position to execute the order in view of the interim order passed by this court. Land counsel appearing for the petitioner submits that the petitioner will pay an amount of rupees 2,000 that is outstanding as on
1 lakh.
1 lakh that is outstanding as on today, for the 2 months from the date of the order passed by the court.
5 months due now.
31st was last, July was the last payment.
31st July was the last payment. So there also they're misleading.
3 lakhs was paid at the rate of 50,000 rupees per month from May, my lord. That's until 31st of October. November and December is what's outstanding. And my lord, if there are difficulties, we don't even have the account details. We've asked for the account. They don't give the account details. So all payments are made by DD only in the court.
According to the learned counsel of the petitioner, the outstanding is an amount of rupees
1 lakh.
1 lakh. According to the respondent, the outstanding is
If it is 50,000 for 5 months, 250.
2 lakh
2,50,000.
50,000 is the outstanding. The petitioner and
All details are here.
this court will hear the matter. Finally, this is in the meantime, this court is passing the following order. Number 1, the petitioner shall deposit an amount of rupees 1 lakh by tomorrow. Shall pay an amount of rupees 5 lakh to the respondent by tomorrow.
Account details need to be filed.
The account, you must be having.
We don't have that.
No,
That's the
we'll give it,
difficulty.
we'll
We're
give it.
only paying by
Never,
demand
we
draft.
won't argue on all
The
this.
account
We'll give
details
it.
shall be funded. An amount of rupees 10 lakhs shall be paid towards the outstanding, part of the outstanding at rupees 50,000 within 2 weeks from today. List this matter immediately after the vacation.
So, my lord, 1 lakh tomorrow and 10 lakhs within 2 weeks.
Yes.
Your lordship, it is taken as part heard, your lordship? Because then again, there's going to be another story again.
Sorry, my
Kindly
colleague-
keep it as part heard, your
My
lordship.
colleague, very well, but I have no objection
So
at all.
if you take it as a part heard, then you will be in difficulties. I'll not be there in Bangalore next week.
No, it's my
That's-
pleasure to argue before your lordship. I have no objection.
Your lordship, that would work to his advantage. He'll be able to take time easily.
Part heard.
Part heard,
My
obliged.
lord, it's 1 lakh by tomorrow and 10 lakhs in 2 weeks.
Yes.
Your
Your lordship, 11 lakhs.
huh? Your lordship, it's only 10 so far, your lordship.
Maybe it will come immediately just after vacation.
Please, one date, your lordship.
List this matter on, what is 8th of, list 8th of January.
Obliged, your lordship.
My lord, one submission, my lord.
With your lordship, kindly, my lord. Bank has issued a notice.
Why you are mentioning it this, why you are mentioning now?
My lord, I'm sorry, my lord, I couldn't come in the morning.
No, I'll not, first of all, I'll not accept any mentionings from the list at 1:30.
My lord, serial
Question of
number,
taking all
my
this,
lord, serial
yes.
number 38 may be permitted for hand delivery of the order, my lord. Serial number
I will
38.
see after coming in
My
the
lord,
afternoon.
serial number 37.
Serve the and summons on the respondent. List this matter tomorrow. ಇವತ್ತು ನಾಕೆ ಅದಕ್ಕೆ ಅದು ಕನ್ಫ್ಯೂಷನ್ ಆಗಿದೆ. ಸೇಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಮಾಡೋದು. ಅವರು ಬಿಟ್ಟಿಲ್ಲ. ಸರ್ ಪಾಸ್ ಓವರ್ಸ್ ಇದೆ ಮೇಡಮ್ ಬಂದ್ಮೇಲೆ ಕೇಳ್ಬೇಕು. 2:30 ಇರೋದೆಲ್ಲ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಅದು. ಓನ್ಲಿ ಫಾರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಟು ಗಿವ್ ಎ ಡೇಟ್.
ಸರ್ 55 ಯಾವತ್ತು
ಇದೆ ಪ್ರೊಸೀಡಿಂಗ್ ಸಮನ್ಸ್ ಆದ್ಮೇಲೆ ಬಂದು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬಾರ್ದು. ಮ್ಯಾಥ್ಸ್ ಕಾನ್ಸಂಟ್ರೇಟ್ ಮಾಡೋಣ, ನಿಮ್ಮನ್ನ ಕಾನ್ಸಂಟ್ರೇಟ್ ಹೇಳಿ. ಏನ್ ಇವಾಗ ಫ್ರೆಶ್ ಮ್ಯಾಥ್
Hello?
ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ತೀರಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಜುಡಿಷಿಯಲ್ ಬ್ರಾಂಚಿಗೆ ರೆಫರ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು. ಏನ್ ನಂಬರ್ ಅದು? ರಿಪೋರ್ಟ್ ಕೇಳಿದ್ರು.
ಕೋರ್ಟ್ ಆಫೀಸರ್? ಊಟ ಮುಗಿದ ತಕ್ಷಣ ತಗೊಳ್ತೀರಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಪಾಸ್ ಓವರ್ ಆಗಿರೋದು.
ಮಧ್ಯಾಹ್ನ ತಗೋತೀವಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 71.
ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳಿ.
71 ರೀಚ್ ಆಗಿಲ್ಲ. ತಗೋತೀವಿ ಮಧ್ಯಾಹ್ನ.
ಓಕೆ ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತಾರೆ ಸರ್.
ಹೌದಾ? ಇದೊಂದು ಎಫ್ಆರ್ ನಂಬರ್ ಕೊಡಿ. ಎಫ್ಆರ್ ನಂಬರ್ 3821/25 ಅದು ಸ್ಟೇಟಸ್ ನೋಡಿ ಕಂಪ್ಲೈಂಟ್ ಆಗಿದ್ರೆ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಕಳಿಸ್ತೀವಿ. ಅವ್ರಿಗೆ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಎಫ್ಆರ್ ಅದು ನಾಳೆ ಲಿಸ್ಟ್ ಹಾಕ್ಬೇಕು. ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಇವ್ರು ಕಂಪ್ಲೈ ಮಾಡಿದೀವಿ ಅಂತಾರೆ ಒಂಚೂರು ನನ್ಗೆ ಸ್ಟೇಟಸ್ ಫರ್ನಿಶ್ ಮಾಡಿಪ್ಪ ಮೇಡಮ್ ಮತ್ತೆ ಕೇಳ್ತಾರೆ ನನ್ನನ್ನ ಇವರು ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಆಕ್ಚುಲಿ ಬಂದಿದೆ ನಿಮ್ಗೆ ಆಲ್ರೆಡಿ ಅಲ್ಲಿ ಬಂದಿದೆ ಅನ್ಸುತ್ತೆ ಬಂದಿರುತ್ತೆ ಅಲ್ಲಿ ಇವಾಗ ಅದನ್ನ ಮತ್ತೆ ನಮ್ಗೆ ಸ್ಟೇಟಸ್ ರಿಪೋರ್ಟ್ ಅಪ್ಡೇಟ್ ಮಾಡಿ ಅವ್ರು ಏನೋ ಸೀರಿಯಸ್ ಇವರು ಅಂತ ಏನೋ ಆಕ್ಷನ್ ಇದೆ ಅಂತಲೋ ಏನೋ ಸಬ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡವ್ರೆ ಯಾಕಂದ್ರೆ ಇದೆಲ್ಲ ರಿಜಿಸ್ಟರ್ ಆಗಿ ರೆಫರ್ ಆಗ್ತಾ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ ಒಂದ್ ನಿಮಿಷ ಇಲ್ಲಿ ಹೇಳಿ ಸರ್ FR ನೀವು ಫಸ್ಟ್ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು ಸರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ನಮ್ಮ ಮೇಡಮ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇದೆ ಅದೆಲ್ಲ ನಾವು ಕೊಡಿ ಏನ್ ಎಂಡಾಸ್ಮೆಂಟ್
one respectful submission. This is with respect to serial number 38. My lords were pleased to pass an order. May I request for the hand delivery of the said order, my lord? Dr. Sudarshan and Madhura.
Today it can't happen
My lords,
because I have a meeting at 5 o'clock.
please.
May not be possible today.
At least request for tomorrow, my lords. Hand delivery by tomorrow.
Let's see.
By the time we obtain a certified copy, it will be too late, my lords. That's the only grievance.
Yes, yes.
My lord, mentioning a matter for tomorrow, my lord.
No.
My lord,
Organize.
it is a Dharwad bench pertaining to
Grateful.
Dharwad bench, my lord.
You can't make a mention at, yes.
Please.
That the morning they moved it. In that they have not complied the opposite.
Then what you do is, write it, if somebody mentions, give it to them. Give it to the advocates or keep it outside the
And I
court.
insert the
Let
bank.
everybody take those memos. Why it is not
Wherever
listed.
they complied.
Let them list. And this, write it and hang it outside the, let them take the memos. Why it is not listed, they will know. Yes. Yes. Call the password.
One matter, the reporting settlement of 220.
Call them. Call.
Serial number 78, reporting settlement. Hand delivery.
Okay, for the petitioner. What's
Okay.
the
Second respondent.
The bank and
Respondent number
auction
one
bidder
bank.
have settled the matter with the petitioner, my lords. And the memo is also filed.
Memo is the list.
Memo is the first matter.
File ಮಾಡಿದ್ದೀರಾ?
Memo for retirement is.
Memo for retirement along with the memo for compromise. Reporting compromise.
Earlier council, my lords, it appears that has retired. Therefore, my lords, is a memo of retirement. And my lords, there is a settlement agreed between the petitioner, my lords, and the second respondent.
Is the advocate who retired or who has come?
I think he's the one who's come on record. my lords. He's the-
Council on record.
NOC, Ashwini
NOC.
Kumar.
Yes.
Ashwin Kumar, yes. This is in all the petitions or only one petition?
No,
all the petitions.
7071,
No,
my
not in all
lords, stands settled.
Which one?
My lords, the main petition 7071.
78, serial number 78.
7071.
78.
The others, my lords, consequently will also become infructuous or, my lords, they would.
7071 is filed questioning what?
My lords, that's questioning the DRT's order and, my lords, the sale certificate confirmation issued in my favor, my lords, from the second respondent's favor. The other was, my lords, the earlier sale notices which were challenged.
That becomes infructuous.
Would become infructuous.
In that, my lord, 78.1 and 78.3 is filed by the same petitioner. 78.2 and 78.4 is sister concern company.
Please wait for a minute. 78.1, 78.2, 78.3 and 78.4 all are questioning the sale notices.
No, my lord, my submission is that 78.1 and 78.3 is by the same petitioner, Proceedings Properties Private Limited. And 78.2 and 78.4, it's a Deccan Engineering. It's a sister concern company where account is closed. Nothing survives for consideration.
So what we do is we'll record this compromise
Please.
in 78 alone.
Yes, please, ma'am.
Other matters will dismiss
Please, ma'am.
as infructuous.
Please, please.
And the order passed by the DRT should be set aside.
That's in only 78.
Yes.
78, yes.
78.1 is filed question was seeking the following relief. Thereafter, the auction was conducted by the bank and the same was upheld by the DRT.
Please.
In that view of the matter, the petition has become infructuous, accordingly dismissed. So 78.1.2.3.4, all same order, extracting the respective prayers in the writ petition, this should go. Yes, now 78. In separate orders. Yes, 78.
It's 78, the memo, my lords, is on record.
Memo is on record, my lords.
It is a settlement between the borrower and the auction purchaser.
Auction purchase, my lords, yes. And the bank is agreeable to the settlement. Yes.
So you don't want to have.
Don't want to. I, my lords, relinquish. I have no claims over the property, my lords, because it stands settled. I'll mention. Only one indulgence I seek, my lords, as the auction purchaser is, my lords, when direct that amount to be returned. The bank is agreed, but they'd require.
Let me look at it.
I'm
It's
sorry.
already agreed.
I'm sorry.
Para 3 minutes.
No, the respondent number 2, auction purchaser declares that no amount is due to him either from the petitioner or the respondent number 1 bank. It is said to give you the 25% of the amount.
My lords, that is over and except, my lords, what is mentioned in paragraph number 3, my lords, that once that amount of 5.87 crores which I deposited comes back to my lords, apart from that, I have nothing else to.
The win in that, like apart from the amount of 25%, no other amount.
May just make that change, my lords, if it's.
I think that should clarify.
Please, my lords, I'll just make that change right away, my lords. I'm so sorry.
Where are the parties?
Parties are present.
He is the
petitioner.
he is the auction purchaser. Or where
He's
is
the
he?
auction purchaser.
He's the auction
And next to him is the petitioner.
Oh. Bank is also a signatory.
Bank is also
Bank is
present.
also present.
Authorized officer is also present.
Yes. The present petition is filed. Questioning the order passed by the DRT dated
28/2/2025 minutes.
28/2/2025. Sale numbers agreed with orders passed in SA number 16 of 2025, dated 28/2/2025. The petitioner before this court is the auction purchaser. The petition before this court is the borrower, and the respondent number 1 is the bank, and respondent number 2 is the auction purchaser. A memo is placed before this, a joint memo on behalf of the borrower, bank, and also the auction purchaser is placed before this court. As per the said memo,
I've got it.
as per the said memo, the auction purchaser and the bank has no objection to set aside the order passed in the SA. The bank is ready to has consented to pay to refund an amount of ₹2, 25% of the amount that is deposited by the auction purchaser without any interest. The bank confirms that the entire scheduled debt pertaining to the petitioner company only is satisfied, and the subject loan account being the overdraft account number 1137 001 0012 401 is having credit balance as on the date The petitioner also authorized the bank to deduct applicable service charges, cost incurred towards recovery of the secured debt, including litigation expenses by the respondent number bank before closure of the overdraft above referred account. The bank has agreed to return all the original documents of the secured asset mortgage for securing the credit facility pursuant to the memorandum of the deposit of title deeds dated 22/3/2012 and instrument of construction redeposit of title memorandum of deposit of title deeds dated 21/4/2016 and thereby executes the discharge deeds before the jurisdictional sub-registrar's office evidencing the discharge of the mortgage after closure of the overdraft. This will be done after the closure of the, which is still.
It is closed.
No, it is in credit balance.
No, that's what I'm saying. Overdraft is
closed,
still.
once it is closed, we will
Then
release
you
the
will-
title deeds followed by discharge.
The petitioner number 2 and his wife, who is not a party to the petition, who are the guarantors under the individual capacities to the secured debt availed by the petitioner, have also consented to this compromise. And pursuant to the compromise, no party could claim any rights against each other. The joint memo, all the parties are present before the court, and the joint memo is taken on record. In the light of the joint memo dated 5/12/2025, the order impugned dated so and so is set aside. The joint memo shall be part of this order. Yes.
The loan
My
stands.
lord, one submission, my lord. Let it be confined only to the liabilities of this petitioner company, because petitioner number 2 is having other liabilities also.
This is all, this joint memo is, and this order is restricted to as far as the petitioner's company is concerned.
Loan account stands fully dissolved and satisfied. Loan account stands fully dissolved and satisfied. my lord.
Whatever is there.
Yes.
It's only one indulgence, my lords may direct that, my lords, R1, my lords may release the amount in favor of the second respondent. my lords. It's there in the memo. Because without the court's order, my lords, they may have some.
So and so, the bank shall release, shall refund the amount of 25% within 1 month. Within 1 month from the date
As
of today.
As soon as possible, my lords, will be better, because if they have it,
Some higher limit.
I understand.
When we
Please.
receive certified
Please.
copy, we'll release.
Very well.
Yes,
I'm so grateful.
all pending IS closed.
List number 2
Grateful.
for urgent matter in the month of February 26.
Yes.
2 on February 26.
Yes.
So pass over matters in list number 1, serial number 1.
Where is Mr. Krishna Swami?
Colleague is here.
Senior is not available, my lordship. He's in out of station, and similar kind of matter pending before the division bench, my lordship, on 18th of this month. So kindly post after vacation, my lordship.
What is the,
So-
if you look at the, section is very clear.
Yes.
It is referring to not the accident, but to the policy of insurance. In that case, what is that great
But
debate
accident
that is
occurred
required?
after the amendment of the.
After the amendment, that amendment is, you are concerned with not the accident. You are concerned with the policy. The policy that is issued prior to the amendment, after the amendment, not the, the accident prior to or after. Very simple.
Yes, my lord. Same kind of issue is pending before
So
the
what?
division bench on the 18th of this month. So kindly post it for after vacation, my lordship.
Why, what is, this court can't decide, the petition is also before this court.
On this, my lordship,
But it's a-
there is no
provision is-
DL, my lordship.
Order is passed, I have to set, then I'll set aside that order.
Provision is correct. Clearly shows that.
This court on,
My lordship, senior wants to argue the.
on, what is the date?
6/11.
6/11/2025 has passed an order considering the fact that this accident had taken place
On 19/5.
after the amendment to the act, that is on 27/1/2024. As such, the insurance company is not liable to. Insurance company shall deposit in a period of that the principle of pay and recover will not apply in the and the tribunal had rightly held that the insurance company is not liable to pay the compensation. And on that, this court has passed an order
Lordship, one
enhancing the
submission, my lordship.
compensation from 50 lakhs 50 rupees to 51 lakh 50 rupees. Then on a memo moved by the petitioner, the matter is before this court, appellant before this court. It is submitted that the issue with regard to the applicable, with regard to the amendment, whether it is reference to the accident or that is with reference to the policy, the same is pending before the division bench. That is coming up on 18th of
this month.
18th of this month. In that view of the matter, the order dated 6/11/2025 is set aside. After the issue is decided by the division bench, the petition, the appellant can move the applicable, move the MFA for hearing. Yes.
Oblige, my lordship.
Yes, two.
Serial number 2. Kumar.
My lord, appearing for respondent company, my lord. My respectful submission is that, my lord, on 10th of this month, this honorable court has passed order. We are waiting for only for the copy, my lord. Order copy, even online is also not available, my lord. That's why we are waiting. As soon as we'll get that, we'll comply with that one, my lord.
No, your counsel, no, it was subject to payment of something. It's a question of where they have said that they are dispossessed for the redelivery of the possession. When the counsel is before the court, then that the same thing you have to inform to the bank. Is the bank agreed by this order that they are going to file any appeal against this?
One submission.
If that is the case, if that is the case, it is altogether a different issue.
One submission, my lord. On 3rd of this month, this case is listed on coordinate bench, before coordinate bench, and the coordinate bench has clearly instructed that there is no question of repossession. But our learned advocate, the opposite advocate, has called the company people and directed them to hand out the key. Then only he will deposit that whatever the 10 lakhs DD. There the confusion starts, and online order is something else. So company people are insisting us to get an order, at least online copy, so that they'll act on that.
By today evening, the order will be uploaded. By tomorrow morning, you should redeliver the portion to him.
Before tomorrow evening, we'll deal because it's outstation, my lord. It's this is and one more submission, my lord. No, one more submission, my lord. There is 4 tenants are residing there. No, one more submission, my lord. There are 4 tenants are residing along with the borrower. We are asking their details so that we'll communicate this order, conditional order passed by this honorable court before delivering the possession, my lord. That they are not ready to provide the list of tenants who are residing there. If they provide the list of tenants, we'll communicate this order to them also before handing over the possession. That is all. That's all our submission, my lord.
It will be uploaded by today evening. Call her and tell her today evening, and by tomorrow evening the portion shall be delivered, or else list is matter under the same caption.
We are ready to comply, madam. Only our
day after, I will take up this matter day after tomorrow. By that time, the portion should have been redelivered.
Yes,
this is matter day after tomorrow.
Our request is to provide the tenant list, my lord, so that we'll communicate this order to tenant also before delivering, my lord. That's all our submission.
4. Pass over serial number 4.
Respondent, my lord.
My lord, in page 17, para 19, doctor evidence, he clearly said that has not undergone any surgery and has no implants. But they have taken in 3 hospitals treatment. First and second hospital wound certificate not given.
Injury.
Make a pass over the matter manual regarding the in calculation admitted amount can deposit, it says that.
And the liability is also challenged, my lord.
What
4
is the
days
liability?
late complaint is there,
Huh?
and 5 persons were injured, and 3 persons policy is there for the only 3 persons.
Claimant is only
Because he is telling he is the loader.
Then you have to hear it like a final hearing and then give the, I mean, pass a stay order after vacation.
My lord, already I have deposited entire amount. I will,
They should be permitted to withdraw some amount. And what is it, the question of
Yes.
liability that is in?
and that's what I am telling, 25% he can withdraw.
more than 75%, my lord, he can release.
Evidence is like this, there is no, he has not undergone any surgery, no implants.
That's why I asked you, what is admitted? That you should have given.
And that's what I am
done the
telling, my lord,
calculation.
4 lakhs I told,
4 lakhs is medical bill is there, my lord.
25% of the amount. Deposited
The
amount.
petitioner, the land counsel appearing for the insurance company submits that the court has granted the compensation, which is on the highest side. And the doctor that is examined is not a treated doctor. He has not undergone any operation. Considering the same, he shall be, considering the submission stay 50%. Petition, the respondent is at liberty to withdraw the amount as per the conditions laid down by the tribunal. Yes, next.
Cell number 11. Chandranath Tariga. Page Chandranath Tariga.
Respondent number 1, ma'am.
No representation after vacation. Next.
Serial number 37.
37.
Yes, ma'am.
R2, ma'am.
11 after.
Respondent number 2.
My lord, connected matter is on Wednesday, my lord.
Huh?
Connected matter is on Wednesday, my lord. Kindly adjourn the matter on.
You have an interim order in this?
No, my lord.
Anupam Agarwal, morning.
Hmm?
Morning she was online and
Online ಅಲ್ಲಿ glitch ಆಯ್ತು ಸ್ವಾಮಿ ಇಲ್ಲಾಂದ್ರೆ
that's why.
You appear for whom?
I'm for
Petitioner or respondent?
petitioner, my lord.
Yes, list along with so and so after vacation.
Wednesday, my lord. Connected 4 matters are there.
Connected 4 matters are there.
Yes, sir.
List
It is
along
a-
with all that on Wednesday. Wednesday not possible, Thursday.
Oh, much.
Cell number
Hmm.
Oblige.
44. Cell number 44.
Yes.
Appearing for the petitioner, my lord. Trial for, this court has ordered for the report, my lord. Report.
What happened to this?
44. And again that report is there now.
Yes, I've seen it. This court has called for a report from the third additional principal judge, family court. The learned judge has given certain reasons for why this application is not disposed of. If the parties are not cooperating with cooperating with the court need not wait for the advocates, and in a time-bound manner, the applications have to be dismissed, have to be disposed of by the court. Unfortunately, this application that is filed, I number 4 in the year 2023 is not disposed of till now. When an application is filed for interim maintenance, that should be given the first preference, but the court cannot go ahead with the main matter. That this application shall be disposed of within a month. No further, shall be disposed of by January, by end of January. No further time will be granted. Yes, next.
One small submission, my lord. Interim maintenance may be granted because I have a minor child.
Yes.
Petition is disposed. Cell number 64.
This is serial number?
Yeah, 44.
44, disposal is in the interest of both the parties, hence this court is not proposing to issue notice to respondent. Yes,
Serial number 64. This one, serial number 64.
this is over 64 in the morning. Yes,
54 is over.
yes, 65.
Serial number 65.
In this case, appearing for respondent bank, my lordship.
Challenge is to, my lord, the sale notice and, my lord, auction notice.
Why the memo is moved for a matter of 2023 now?
Respondent might have moved it.
Lordship, from past 3 years, they are enjoying the interim order, my lordship. They are not paying any EMI and nothing has been done, my lordship.
Interim order, what is the interim order?
My lord, to pay, my lord, 25% of the,
To pay.
I have paid, my lord.
What
Interim
is
order is
outstanding?
compliant. Outstanding, my lord, as per the bank, 47 lakhs 92,000, my lord.
You have paid 25.
Please.
My
So
lordship,
when will you pay the remaining?
lordship,
My lord,
lordship, one submission, my lordship.
Yes,
My lordship, on 2/11/2023, on that date, 45 lakh, my lordship. From 2 years till now, it's some amount has changed, my lordship. Kindly, I will make submission, my lordship. I will take
how
instructions
much
from bank, my
is
lordship.
outstanding as of now? How much is the amount now?
Lordship, just by tomorrow, I will get instructions and kindly, I pray, my lordship, tomorrow matters to be posted, my lordship. As I'm just.
Why did you go for this matter without the information with you? Yes.
Apologize, my lordship. I apologize, my lordship.
Till the list is matter after vacation, till such time, the interim order is extended. Yes, next.
Serial number 66. G. Raghu, for petitioner. Rashmi.
Yes. You moved the memo.
I moved the memo, my lord.
What is, it stays there?
There is a stay, no month, no payment.
No representation for the petition. This is matter for dismissal tomorrow. Counsel for the respondent is present.
Serial number 67.
I appear for the petitioner, my lord. Appear on behalf of the respondent. On the last occasion, my lords had posed a question with respect to when the petitioner would go down to meet the child. At the same time, when the respondent will come down and get the child to Bangalore. 24th or 25th, the petitioners are okay to travel to Singrauli, Madhya Pradesh, my lords.
24th?
Or 25th of this month.
Hmm.
In fact, my learned should.
I sought instructions from my clients pursuant to my lord's directions. When I spoke to my client, she mentioned that she has absolutely no problem in accommodating the father and facilitating the visitation between the father and the child. Once the father comes to Madhya Pradesh, she will make all necessary arrangements in order to ensure that it is facilitated, my lord. Insofar as she coming down to Bangalore, she is held up with a specific responsibility with respect to her medical profession, due to which she is not able to come down to Bangalore during this winter session, my lords. So, however, pursuant to my lord's observations,
What's the age of the child?
7 years, my lord.
6.5, 7 years, my lords.
Why, when the father is when he visits Indore or
Singrauli,
Singrauli,
Madhya
my
Pradesh,
wherever
yes.
it is, so then will she give the absolute custody?
Beg your pardon, my lords.
Absolute custody there?
As in, she will facilitate visitation, my lords. My lords, whatever arrangement is prescribed by lords between in the daytime, she will ensure that the same is followed, my lords. There will be no impediment from the mothers.
7 years, what is the difficulty in having the visitation, even at having the custody of overnight also?
My lords, that is not what is in question here. If I may make two submissions, my lords. When this writ petition was filed, we entered appearance, and this writ petition challenges an order wherein they had sought for the change of custody itself. Please, if I may only take 2 minutes of my lord's time. They had sought for change of custody itself under no specific provision, nothing.
You're not having filed a GNWC here, you left to some other place.
No, my lords, that is, the mother is a resident of Singrauli itself. She resides there. She was born there, grew up there. She is working there, and the child is admitted to school there.
GNWC is filed by whom?
GNWC is filed by the father, my lords.
Here on
It is my clear instructions that the mother was residing there, and the strategic timings when the GNWC was filed and orders were obtained was when the respondent's mother was in her deathbed, and the respondent's mother even passed away, my lords. If I may invite my lord's attention to one more aspect, there was a contempt petition that was instituted by the father, which was pending consideration before the division bench when this writ petition was filed, my lords. There was an interim arrangement that was provided by the division bench of this honorable court, wherein every single day the mother has to facilitate contact rights in the form of video call, which has been duly complied with, and we have filed a compliance affidavit before the division bench in the contempt court, and the division bench was pleased to drop the contempt proceedings. When this matter came up before this honorable court, and I made the submission saying that what is sought in this writ petition is also with respect to contact rights, which is already being exercised pursuant to the orders passed by the contempt court, to which my lord said the same arrangement shall continue. Now the contempt has been dropped. Despite that, in the spirit of ensuring that the father and child continue to have that bond, the mother in her goodwill is essentially continuing the same arrangement in order to ensure that there is no alienation. My lords, it is not, my lords. My lords, my lords.
You were in Bangalore as on the day the GNWC is filed. Just like that, you left to.
My lords, that is not my submission. As on the date of GNWC, she was not in Bangalore.
That's wrongful submission, my lords. My lords may kindly peruse ink page number 60. The order sheet itself says that the respondent was residing in Bangalore. Ink page number 60, the third paragraph, my lords.
Yes.
It says, when the case was filed, the child was residing within the jurisdiction of this court. Now the child is the ordinary resident of Madhya Pradesh.
My lords, that is not
They
my
have
submission.
willfully
That is
taken the
not
child
my
out.
case. It is his case that when the GNWC was filed, the child was staying in the jurisdiction.
Where are the objections filed by?
My lords,
Please,
may,
my lords.
my lords
In
may
fact,
find it.
at the earlier stage,
My
the
lords may
learned
find
trial-
it to at Annexure B, page 19. Annexure, a copy of objection to main petition.
Page number?
19, my lords. We have filed a detailed objections, my lord.
That objection was filed after my lords had given the liberty.
Be that as it may, my lords, that should not prejudice.
And there was an observation by my lords as well.
Contempt has only been dropped. My learned friend is.
No, contempt jurisdiction is something else.
My lords, my respectful submission is that despite contempt being dropped, that order is still being carried out. If I may invite my lord's attention to the impugned order for a moment.
Fine, now we will pass, we'll make
My
that
lords,
order.
my only respectful submission, my lords. If I may invite my lords to the impugned order for a moment, my lords. Page number 140, my lords. The operative portion, my lords, can find in page number 143. If I may read, my lords.
What did you say about in this objections, please tell the court.
Please, my lords.
When did you leave Bangalore?
Well, it's para 2, my lords. The government's.
Why are you not making your efforts to transfer this matter to Indore where you are staying?
Well,
My lords, that petition is dismissed before the
We
Honorable
had
Apex
filed a
Court.
petition before the Supreme Court, my lords.
It's dismissed.
Well, we have come to terms with that. The client has engaged the services of a counsel, and the counsel is leading the case before the Honorable Family Court, my lords. We have no issues insofar as that is concerned, my lord. Insofar as this particular arrangement is concerned, which,
It is dismissed by the Apex Court.
if I may seek instructions with respect to that, my lords, I don't have a copy of the Supreme Court's order.
Why it is dismissed?
I don't have that order either, my lords.
We will
But
produce a copy of that order. my
coming
lords.
to the information given by the client, my lords, they say that the case did not have any merits with respect to the transfer. Of course, no doubt with respect to any of the petitions, my lord, but with respect to the transfer petition, they had no merits. Subject to any changes, my lord.
If I may make one respectful submission, my lords, the impugned order at page number 144, if I may invite my lords' attention to page 144. IA number one, it starts at 143, my lords. IA number 2, filed by the petitioner under section 12 of the GNWC Act, is hereby partly allowed. IA number 8, filed by the petitioner without any provision directing the respondent to hand over the custody of the minor child to him and also seeking initiation of criminal proceedings, is hereby dismissed. The petitioner is at liberty to make audio or video call to his minor son Shivansh Yadav once in a week, about 30 minutes, as per the convenience of the child. My lords, we are ready and willing to comply with this order. This says once a week. I will seek instructions from my client, and I will also go ahead to mention that it can be twice a week, my lords.
What you're stating is, no, this GNWC is filed in which year?
2022, my lords.
So until this GMWC is disposed of, he will be only talking to the child over phone.
No, my lords. What I'm proposing is, this is an undertaking that we have given before my lords and the previous round of litigation, even before the trial court, as well as before the contempt court. At any point in time, if the father visits Singrauli, Madhya Pradesh, we will facilitate visitation. And
Sometimes it's your responsibility also.
please, I understand, my lords.
That is what I asked.
On the answering my lord's question, only during this winter vacation she is not able to come down to Bangalore due to her personal commitments, my lords. I will seek instructions.
She's never been to Bangalore, my lords.
She has
She's
been to
never
Bangalore.
been to Bangalore, my lords.
My lords,
My
that
lords,
does-
may kindly peruse the order sheet.
No, my lords, that is
at
not.
Annexure C. Unfortunately, IA number 8 at the first instance, the Honorable Trial Court at ink page number 66, my lords. 65, if I may request my lords to kindly peruse. Because the respondent did not show up before the trial court, the order was passed before the trial court, my lords, by the trial court. In fact, it says 65, my lords. It says, in the interest of justice and equity, since the petitioner is the father of the child, IA number 8 filed by the petitioner for the interim custody. I'm sorry, my lord, just prior to that, 64. Sufficient opportunity is given. Objections to IA number 8 not filed by the respondent. Respondent has also not produced the child before the court in spite of orders of this court. And therefore, they passed the following orders, my lord, allowing IA number 8. That came to be challenged before my lords. And my lord's observation at ink page number 79. Sixth line from the top, my lords. When the trial court has passed the order and directed the respondent mother to appear before the court along with the child, in sheer disobedience of the orders of the court, she has not appeared and has come up before this court challenging the impugned order. When a court passes several orders, she fails to obey them, and again she comes up before this court seeking the relief. This conduct and the attitude of the petitioner/wife cannot be appreciated. The trial court shall not grant unnecessary adjournment in this case. If this kind of attitude and disobedience is exhibited by the wife, the trial court shall look at it seriously and pass appropriate orders. And my lords had granted liberty for the respondent to file objections, my lord.
If I may make
After
one
the
submission.
objections were filed, the trial court dismissed my application on a technicality, my lord, on a technical ground.
It's not
saying
a
that-
technicality, my lord.
So just a second, when you're arguing, I did not interfere. On a technical ground, stating that the provision of law has not been mentioned. That is the only reason given by the Honorable Trial Court, my lords. In fact, I had also produced a memo along with certain documents, which, if I may request my lords to kindly peruse those documents, which are at ink page number 81, the list of documents.
No,
When
if your client is in Bangalore, the usual order would have been every week he'll have the visitation to the child.
Please.
When the JNWC is filed, they should be within the jurisdiction of the court, is it not?
My
And now
lords.
you left. You have your own reasons for going to that place. So there is some responsibility on your part to come to Bangalore so that the father, or it is either ways, like alternatively, once he comes, once you.
My
you
lords,
will
if
come.
I may
So
make.
that's what I asked.
If-
And
please.
this observation of the court that no provision is stated and all, That is, it won't, that cannot be a reason at all.
My lords, not just in so far as that. If I may invite my lord's attention with respect to the rest of the aspects, he has sought for custody of the child. The whole point of GNWC,
He can mount the release. He may ask everything under
my
the
lords,
sun.
under an application, under an interim application, the final prayer of the GNWC is seeking custody. How can he seek so under an interim application, my lords?
Yeah, not, because what to do? He's not having visitation.
My lords,
Nothing is happening.
if I may make one respectful submission, my lords, it is an admitted fact that the father has not paid a single rupee of maintenance up until there was a proceedings that was instituted in Singrauli, and there also on a very irregular basis he is paying 2,000 rupees, my lords.
It's not.
It is an admitted.
For.
My learned friend cannot dispute that aspect, because during the length of these proceedings, he has not paid a single rupee, not to the wife, my lords. It is an admitted fact that the wife is a doctor, she's acquainted well. But for the welfare of the child, not a single rupee, my lords. And he expects visitation after visitation, custody altogether, my lords.
We're ready to take care itself, my lords. On the last occasion, when my lords had posed a question as to what would be the difficulty, this council had already made a submission, my lord, stating that if the custody is granted to the father, he will take care. Otherwise, also we are paying, my lords.
No, my lords.
Definitely.
That is a false
In
submission.
fact, if my lords may kindly consider, pardon, my lords.
What is that you are paying?
My lords, there's no order by this honorable trial court in Bangalore. If I may draw to my lord's attention, there were 3 proceedings filed.
Know about your rights, you should know about
Which we are doing so, my lords. In fact, 3.
How will a person survive?
My lords.
Can a child be taken care of with 2,000?
May I make humble submission, my lords. 2,000 was the application sought for by the respondent in Singrauli, my lords. That has already been exercised and paid. Apart from that, there were 3 other litigations filed against the petitioner, which is all dismissed, my lords, by the Honorable Apex Court.
Forget about what has happened.
Please, my lord.
You want the custody of the child. You have a responsibility towards the child. So before you exercise your rights, you should also know your duties. What is your salary? What is your salary?
My lords, that I'll get the instruction as to what the salaries are.
To the court.
Please, my lord.
Whatever are the expenses of the child, for that no application is required. When you're fighting for the rights, your rights, why you are forgetting your duties?
My lords, the duty has never been forgotten. In fact, the petitioner, if I may make a humble submission, my lords.
I'll have this matter on today's Monday, Thursday. I'll take up this matter.
May I make a humble submission, my lords? 2 aspects to this, my lords. One being, the petitioner is ever ready. He's the one who had put the child before the international school at Bangalore, and he was paying. Secondly, day after tomorrow itself, I'm not in town, madam. My lords can kindly have it tomorrow.
Day after tomorrow. It is after that.
My lords, I'm not going to be in town, my lords. That's the problem.
This is matter tomorrow.
Please, my lords.
By the time the petitioner shall get instructions, what is his contribution towards the child's maintenance? The counsel for the respondent shall get instructions. After the father visits the child in December, and what is going to be the duration of the visitation, how and where that is going to be exercised, and also in the month of January, when is she going to come back? It should be 1 month the father should go, 1 month the mother should come to Bangalore. So please, both the parties shall indicate the dates, how it is feasible. This is matter tomorrow.
My lords, please, in the meantime, if I may make one submission, that order of everyday video call is the child.
Tomorrow it's coming. We can do it tomorrow. Yes.
I'm great.
My lords, on the guise of that, they're trying to close my contact rights, my lord. Please, tomorrow, my lords. Much obliged.
68, Suresh V for petitioner.
For respondent.
Shaman Nayak.
Appearing for petitioners, my lord. My lord, I would like to bring the facts of the case in brief. So there was a
what is the prayer?
The prayer is that we have received a section 14 order on 12/2/25, my lords. But once we proceeded towards the secured asset, we were brought to the knowledge that the property was already seized under the Buds Act in crime number 125 of 2024. Thereby, we are not able to implement the section 14 order, my lord. Thereby, I request, in the identical circumstance,
No. What is that you're speaking? That I should know. Come to the prayer.
that we would want to quash the impugned merger proceedings in the crime number 125 of 2024.
Before this court.
and declare the Surfacey Act to be having an overriding effect with respect to the Buds Act.
They're seeking for quashing of Mahajar, your lordship, which can be done only through 482, your lordship. Here they're seeking that.
Who has, what is that order?
And moreover, the property has been.
Let's see what is that she has submitted. How can we pass this kind of orders? No, if the property is seized, if it is before the special court, you have to go before the special court. You can't come before this court.
Please, my lord, but we had the first right over the sanctioned property.
We decided by the court there. We can't decide it in a writ petition.
As per section
But
18,
here we
clause
can't
2 of
Yeah, list is part of application.
Cell number 69. Nagaraja.
Milords, I appear for the petitioner mother, Milords. Mother has challenged the visitation order, Milords, and thereafter this court on 17/10/2025 passed an order, Milords, and 3/11/2025 we are complying with the order, Milord. Milord, what has happened is everyday visitation from yes, Milord.
Monday to Friday, the father can exercise the visitation from 5:30 to 7 p.m. The petitioner mother is getting late or any other change in the time in advance, she shall intimate. On Saturdays, the father can exercise visitation for 3 hours, subject to the convenience of both the parties. Both the parties shall ensure that the visitation goes on smoothly without giving any kind of inconvenience to the child. Can also meet the child, and the only endeavor shall be to meet the child, develop the bonding, and they shall not discuss anything with regard to the disputes between the parties to the child or anyone around. Yes.
Yes, ma'am. My humble submission is, Milord, everyday visitation is having a little bit problem for the mother, Milord, because she has video call till 7:30. So if my lordship on Saturday, Milord, we are ready to give 6 hours visitation to the father, and even video call in a week, 3 weeks, 3 days in a week, Milord, and even for the grandparents and everywhere. And as place suggested by the petitioner, because I've received the email, because the child is only going to the mall. And because of that thing, he's getting affected and he is not playing with his friends and other things, Milord. So because of the child's interest, Milord, we are agreeing to the respondent's father, the place of whatever the visitation he wants to do. But every day.
That means you mean to say that on that Saturday, he'll have exclusive custody?
Not the exclusive custody, Milord, from 10 to.
That's whatever time.
Yes, Milord.
The father can take him outside and have the exclusive visitation between that time.
The child is 3 years old, Milord.
I'm asking you what is
No,
the
Milord, under the
complaint
supervision
wants?
of the
Huh?
under the supervision of the mother, Milord.
Mother will also go along with the child.
Yes. The visitation is happening, Milord, because the father cannot.
What do you say?
Lord, if I may make submission, as far as we understand that daily physical visitation might be difficult and cause issues at work, because my client is also facing the same issue. However, my lord, to not have any weekday access would not be fair, my lord.
Just saying Saturday.
My lord, Saturday 6 hours, we were anyways getting 3 hours on Saturdays.
See that 3 hours, let it be 6 hours.
My lord, but 1.5 hours every day is the access that we were getting. Adding 3 more hours is not adding up to the amount, and we don't want.
You can enter some arrangement.
Yes, my lord, but the father has relocated to Bangalore, my lord. As of now, he's looking for a house to shift to Bangalore. He came all the way from Ratia only so that he can physically access the child, my lord. 3 days in a week, any place that is comfortable for the child and the mother. 3 days in a week if we get the 1.5 hours, and on Saturdays 6 hours, so that we can take the child to any other place other than a mall. For instance, this Saturday on 21st, Comic Con is happening in Bangalore. It's a place that's where people dress up as cartoon characters and all. It'll be a very good experience for the child. Similarly, next Saturday there is an aquarium paradise event happening. Again, these are all experiences that will require more than 3 hours. So as long as we get at least 3 days, Monday, Wednesday, and Friday.
Monday, Wednesday.
I'm a mother, my lord. I have to take care of my child. I have to prepare 3 hours, and I have to work till 7:30. And I have lost my father March 2025, and I have to take care of my widow mother. All this trauma, and I've the break in marriage, my lord. Because of that, because of this, I request this honorable court only weekend, my lord, because she's facing too much problem in the office, my lord.
Lord, if that is the case, my Lord, we are paying rent in Gurgaon. We moved here. We're living in Airbnbs now, where the payment has to happen in a much quicker cycle. We're looking for a house here. He's been demoted because of the fact that he moved here and his involvement at work has been affected. We've informed that to this honorable court. Both sides are suffering. The idea is not to snatch the child away or make this inconvenient for the child. Right now, every day the child is seeing the father. 3 days a week if the child may be permitted, if the father may be permitted to meet with the child, 1.5 hours, the same.
Or else Saturday and Sunday.
A longer period that will compensate for the hours.
For 8 hours, my lord, I leave to High Court order was 8 hours. 10 to 6, my lord, I leave to your lord.
No. I'm saying because she says that she has to work and she's busy on the weekdays, Saturday, Sunday. No, if the boy is comfortable, why can't she just leave with the father?
He just cries. If he doesn't see me like for 5 minutes, he'll start crying.
We've not denied that, my lord. We've not said.
Let her say.
Sure.
Yes.
And also because I'm also facing I'm only the earning person at my home. So I'm also facing like a lot of escalation from my work. So weekly once is what because I have other things to do, because I also get 2 days for myself. In that one I'll be giving for visitation. Apart from that, I have to do everything of like work hold, housework also. Whatever like arrangement I have to do, like child homework also I get on Friday. So that also I have to make him do on weekend. So apart from that, there's a lot of things that I have to do on weekend. So I'm ready to give 1 day visitation on Saturday. Apart from that, for 2 days in a week, video call I can provide.
Not the video call order from the trial court has attained finality. It's not been challenged. Again, we are also not pushing for everyday video call because we understand. All we are saying is, well, this father has completely uprooted his life, jeopardized his career, all for the chance of meeting his son. And because this honorable court passed daily orders is one of the reasons why he's currently looking for a house. Next week, he'll probably finalize a house. All of these financial liabilities and jeopardizing his entire career, he's come only for the child. If he's not able to meet the child at least for 2-3 days in the week, we will come to your society. We'll do whatever it is that will be convenient for you. We don't want to inconvenience anybody. But this father has.
It's over. I think that's over. That's already dealt with.
Whatever it is, we are willing to do, my lord. All I have to say is the father has also incurred the same difficulties, my lord. He's come right now. He's paying rent at the Airbnb.
Why don't? Because this order is Monday to Friday in PNR Felicity Mall. Now, for that, she has to make all efforts and go out and do all that. Now, except on Saturday, remaining other days, the grandparents will not come. The boy will be playing in the ground floor, like in the play area. That time, let the father have the visitation.
I am ready to provide him 1 weekday and 1 weekend.
So that is not what you want will be the order.
No, what I'm saying,
Because
and also
1 week that is decided. That is decided, as you said, on Saturday he'll have that. So remaining days, because last time when the grandparents came and created some galata in your apartment, you were not interested. That's why we shifted it to outside. What I am suggesting is, from in the week 2 times, apart from the Saturday, let him come to your apartment without the grandparents. Only he will come alone and he will play with the child.
For how many days?
Monday and Wednesday. He will come to the apartment. You can send somebody down so that he'll play with him between 5:30 and 7.
Okay, and how about Saturday then? How many hours?
Saturday?
My lord, we will need a considerable amount of time because if we are not getting that access every day, then we will need a longer period of time. We don't want to inconvenience the child, my lord.
Ma'am, now
At least 8. I'm only stating this because, for instance, what the father has planned for Saturdays is to take the child out to different things, like I explained, the Comic Con or aquarium or zoo. These things, if it's only 3 hours, there's not much to be done.
Saturday it's not 3 hours.
At least 8 to 10 hours if we are getting.
Under the time, like I've also have to go along with the child
10
because
to 5 on Saturday.
it's pretty
We'll
long
see.
hours because
No,
child also
what
doesn't
we do
stay
is-
out.
No,
ma'am.
please listen. We'll see this in this during the vacation. We'll have this matter after vacation. Basing on how it is going on, we can alter the visitation.
Also, ma'am, what submission they have made earlier, his job is at stake and he's only coming to Bangalore for 3 months. But what I've got to know that he's got the promotion also from his job. So whatever information he submitted to the court was absolutely false.
Then where is that information you have? You can place that paper on record. Then
We will submit the email regarding his demotion also on the next.
Yeah,
No,
because
if what he submits before the court is wrong, we will pass orders. There is no difficulty. You can place all those documents before the court. So now what we will do is on Saturday between 10 and 6, and on other days the same 5:30 to 7. That's Monday and Wednesday. He'll come to the apartment. That time the grandparents will not come. On that Saturday, even the grandparents can come along with him.
very tired.
3 years old.
It's only on Saturday, my lord. If we can't get weekday and weekend, then there is no point in moving here, my
To
lord.
just say that until child is comfortable, I'm okay.
That's why what I'm saying now. When he says today we are where the next Saturday, only 3 Saturdays will come in between. So just explore that how it is working out. Huh?
So what?
That's what I said. 10 to 5 only I said.
Okay.
Lord, if we may kindly be indulged as just 3 days, my lord. If the father is coming to the society, may he at least be permitted to play with the child for just 3 days in a week.
What is inconvenience to you? You don't have to come. You can
He
send
will come.
somebody, your maid and
So
all.
he's coming for 2 days, Saturday, almost like the entire day we are giving.
No, it is not any. Now, if you have to take him to the mall, it is inconvenience to you. And if grandparents are coming, it's inconvenience to you. But he is coming. Well, what you are doing, he will take care of the child between that when he was in the play area. He will play. That's not an inconvenience to you, according to the court.
Can we look for for 3 weeks, like you said? Can he exercise it for 2 days a week and the
Lord,
weekend?
3 days a week, my lord. It's a humble submission. He's going to go from 5 days a week of seeing his child to only 2 days a week for
Please
seeing
come.
his child.
This court has passed an order on 3/11/2025, where the father is permitted to exercise visitation from Monday to Friday between 5:30 to 7 p.m. in PNR Felicity Mall. On Saturdays, the father can exercise the visitation for 3 hours, subject to the inconvenience of the both parties. When counsel appearing for the petitioner, mother submits that she is having work till 7 o'clock every day and taking the child from 5:30 to 7 to the PNR Felicity Mall is difficult to the mother, and then there may be a direction. The order may be modified and the father may be permitted to exercise the visitation only on Saturday. When counsel appearing for the respondent father submits that the father has moved to Bangalore only to have the access to the child, and now he's making all his best efforts to secure an accommodation so that he can completely move to Bangalore. It is submitted that if the visitation, the earlier order is modified, it would cause a lot of hardship to the respondent. Balancing the interests of both the parties, this court deems it appropriate to pass the following order. The father on Monday,
Wednesday and Fridays.
Wednesday,
Fridays also, my lord.
Because you're having on Saturday again.
Lord, I understand, my lord, but the time, total time that the father gets to spend with the
Monday,
child is get
Tuesday
and
Like
Thursday.
I would like to make a submission that I want that because my like son's friends are also going for dance classes in the evening time, so he also would want to join them. So there is some apartment only, there are some classes, learning activities going on, like evening timings
He will
only.
take.
Yes, the father is
So-
willing to.
Father will take whatever the activities.
Is it during
In
the
the
same time?
apartment, whatever are the
If it
activities. he
is
will take.
any activities that are going on, yeah, during that visitation time, if any activities are there, father is more than willing to accompany the child. Lord, may I seek this?
Monday, Tuesday,
Tuesday.
Wednesday. Give a break on Thursday.
Sure.
Monday, Tuesday, Wednesday, the father can have the visitation between 5:30 to 7 p.m. in the premise, in the apartments where the mother is residing.
Yes.
On these, to the apartment, the father, the grandparents are not permitted. The father can exercise, if any activities are there where the boy is participating, the father should, in the set time, the father can take the child. Then on Saturday, the father can have the visitation between 10 to 5 outside the apartment.
We will communicate the details and everything.
The
prior.
father in advance shall communicate the details to the mother. This is matter.
Lord,
on,
if I may make one humble submission, my
the
lord.
date 8th is what?
My lord, may it
Just
please
one
be.
minute, let's just matter on 8th of Friday, 8th of.
My lord, there is a slight inconvenience, my lord. I will not be available on the 8th, any date after Jan 9th, after 9th.
Jan 9th.
After 9th, till 9th, I'm engaged.
12th, let's just matter.
We will not. We'll only,
Maybe
my lord, may I also
Please
seek the
wait.
indulgence of this
On
honorable
12th
court.
of January,
Obliged.
January
Lord.
20, let's just matter. In the conditions, the father shall, the father shall make it, it is, the father shall not interact with any of the apartment persons, particularly pertaining, or shall discuss
With respect
anything
to the
pertaining
case.
to their marital relationship.
My lord, if I may kindly make one submission, we would just like to seek the indulgence of this court. The child has, we've been informed that the child has been sick a couple of times. The father may please be allowed to also join them to go visit the doctor if required, and during the visitations.
I think we are extending the scope of the petition. Yes,
My
Mr.
lord,
Mata,
it's just a humble submission.
No, no.
Obliged.
70.
Kalyanar,
For the petitioner.
Yes.
My lord, Kanik Raj has filed the wakalat for the petitioner, NOC wakalat, my lord. His name is not reflected. I request the name of Kanik Raj to be reflected and the matter will be listed any date the convenience of the court.
On the last occasion, my lord, the child is not exercising the visitation rights because mother with the child, my lord, mother was instigated the child. Child was not cooperated with the exercising our visitation.
Tomorrow, my lord. Today the council was
Because-
not aware regarding the matter being listed. I was in-
Bangalore Mediation Center on every Saturday,
Yes, Your Honor.
grandparents can exercise the visitation between 4 p.m. to 6 p.m. At the time of visitation, the mother is permitted to be with the child and shall see that there shall be proper visitation given to the grandparents. Except grandparents, no other person shall be present from the respondent side. The report shall be placed before this court as to how the mediation and what had taken place by the director, visitation
But when our
took place by the director. Where is the report?
report already sent it, my lord.
Is to be corrected. The copy of this report shall be given to both the councils. Does this matter after vacation?
Name of
Delete the name of Mr. Kalyan R. Print the name of
Kanikraj.
Kanakaraj.
Now the condition number 2 may can be modified, my lord, because mother with the.
No, that order will not be, I have not passed any order now.
Because my visitation, exercising my visitation rights, child's mother was.
That is what the report is. Please, if you look at the report, you will not ask for it. Look at the report of the.
Because only their mother only to misguide the child, my lord. That is the reason. When we are.
Please have a copy of the report and read it. That's an expert opinion. The councillor's opinion. Please read that. Then I'm sorry if you don't understand. Yes, next.
Copy provide me the direction agide sir. Cell number 71. K. Murthy for petitioner.
My lord, we have communicated to my party, my lord. So pray for some time, my lord.
My lord, for the cross examination, they have to fix a date.
I
my lord.
will dismiss it if your party is not ready. We can't help it.
No, my lord,
I made it very clear on 2 occasions.
Yes, my lord, I have communicated to my party. He has to get flight ticket and he has to take care of his aged parents.
It has to be this side of the vacation, or else I am going to dismiss it. Only 2 options.
My lord, he won't get tickets, my lord, by this.
I'm not asking him to come this side of the vacation to indicate the date when he is coming. With that, I will dispose of this petition.
My lord, he said he, after operation to his mother, aged about 83 years, father.
Where is she? Where is the mother and father?
With the petitioner, my lord.
Where?
USA. He is 103 his mother. She has to undergo knee operation, my lord, due to her diabetic, my lord.
Whatever it is, you can tell that you will come in the month of January, February.
Lord, he said in the month of March.
We cannot,
after
this order, interim order that is granted is contrary to what I have passed orders earlier.
But somewhere in the month of February, my lord, date may be fixed, I will make. Or my lord.
Yes.
The end of.
The present writ petition is filed. Questioning the order that is passed. Agreed with the order dated, what is the date of the order? 30/10/2025.
Yes, ma'am.
Whereby the court has asked the petitioner husband to come before the court physically and give evidence. When this matter came up before a coordinate bench of this court, the order is stayed till 5/12/2025. When the matter came up before this court on 5/12/2025, this court had directed the matter to be listed on 10/12/2025. By that time, land counsel for the petition shall get specific instructions when the petition will appear before the trial court for cross-examination. And it was again adjourned on 10/12/2025, on 12/12/2025. Today also, the land counsel for the petitioner initially submits that the mother of the petitioner has undergone surgery in the US. It is difficult for the
Father is also with him.
Huh?
Father is also with him, aged father.
Our father is bedridden. It's not.
Only the person
It is
to take.
difficult for him to come to India. The petitioner husband has filed the MC seeking divorce. Having filed the MC, it is not open for him to say that he will sit in US and the evidence has to be.
90% cross-examined. Three occasions substantially cross-examined. Only 10% is remained.
You have cross-examined him virtually.
It is in the order sheet itself, my lord. I have kindly see order, my lord.
How did you do that?
Substantially cross-examined, 90% cross-examined because of, kindly see the order dated, my lord.
Where is your senior?
Page number 21, 22, 23.
I'll just call him, my lord. Kindly
This
pass.
is marked tomorrow. Ask him to come.
Yes, my lord.
Yes.
Interim order, my lord.
Interim order only granted is extended till tomorrow.
Yes.
Yes.
Cell number 72. Sridhara K.
Thank in this matter, my lords. This matter, my lords, prayer A has become infructuous, my lords, since auction has not taken place. And prayer B cannot be considered merely for the reason account had become NPA on 31/1/2020 only, my lords.
31 what?
31st January 2020 only, the account had become
Let's look at
NPA.
the prayers first, then we'll.
They have
Issue a
questioned
writ
the
of,
sale notice, my lord.
Quashing the auction sale notice. So this has become infructuous. To provide petitioner with an opportunity to outstanding dues and restructure the loan account. How can we give such a direction?
We are filing a undertaking. We are ready to clear the amount within
Huh?
4 months. We are ready to clear the entire balance amount within 4 months.
What is the amount?
As per the essential.
23 lakhs.
23 lakhs 66.
Have you
657.
received the copy of this?
Yes, madam.
You want to get instructions on this? We'll take up tomorrow.
Yes.
This is matter tomorrow. A memo of an affidavit of undertaking is filed. Then counsel the petitioner seeks time, the respondent seeks time to get instructions tomorrow. Yes, next.
Cell number 73.
73, I appear for appellant in 73.1, my lord. Well, this is a case where the insurance company on the ground that check issued by the owner of the offending vehicle towards payment of.
Physically, final hearing matter.
Well, it's posted for judgment, please, my lord.
There must be some judgment, some.
Yes, please, my lord. I'm relying upon the Supreme Court judgment of the Honorable Lakshmama case, my lord. It is there in the file, please, my lord.
Then please put the judgment.
It's already there in the file. They've given last occasion.
Yes, please, my lord. Lakshmama case, my lord. Honorable Supreme Court.
No, this is another judgment, Sanjay. Where is my order? She has given, look at the file, there will be there. Ask them. she has given-
Notes. There is no order. Malad has made some notes. There is no order.
Not this, my order in this difference. On this subject, it was already passed on.
I remember. So Malad, Pradeep's matter will appear. Malad, that apart, Malad, Supreme Court judgment is.
No, there is, my order is based on the Supreme Court judgment.
Yes.
Whether this court has considered that judgment of the Honorable Apex Court is not his issue.
And the Supreme Court order is.
Where is that order? Last time, one order which I have passed.
Well, my lord, sorry, my lord, I don't have that, my lord. I'm sorry, my lord.
I think you have passed on last occasion.
Malad, the Supreme Court judgment I have given. Malad's judgment, Malad, I could not lay hands.
What is that judgment of the earlier judgment of the Supreme Court?
Malad, the recent judgment I have given.
This is not this court, there is a judgment of the.
Malad, let me also. I'll think Pradeep is aware of this.
My lord, even on the last occasion, same.
Judgment. Yes, next.
Cell number 74.
Appellant.
Cell number 74. Thomas B. Peter.
I appear for the respondent number 1.
The TCRs, my lord, are awaited. So maybe we have to.
This is matter after the TCR is received.
Cell number 75, 76 urgent. Cell number 77.
Yes, 77.
Cell number 77.
Petitioner.
Appearing for the rest.
For recalling the order with the condemned delay.
You said you will argue the matter.
Yes.
Argue.
Yes.
But where is the impugned order?
Your lordship, appearing for the respondent, your lordship. The client has taken back the file and gone, your lordship, because it was disposed in the last time before recalling. So we have asked the client to come and give back the file. If your lordship can listed post vacations, it will be.
We'll see, what is it? Yes.
The trial court has been
Where is the page number order?
order page number 51 to 59. Trial court is ordered 8th.
This is order is in Kannada.
Yes, ma'am.
The present IA is filed seeking, I know 1/25 is filed to condemn the delay of 79 days in recalling the order dated 12/8/2025. And IA number 2/25 is filed to recall the order dated 12/8/2025. Now, why did this 79 days delay has occurred?
I'm not like the prisoner is admitted in the hospital, not cooperating to me, please.
You don't pursue the matters and you then come up with these kind of applications. So we have to do both the exercises. For the reasons stated, the delay of 79 days is condoned. I number 2/25 is recalled and the expedition is restored to file. The interim order earlier granted shall be enforced. This is matter after vacation. Yes, next.
Cell number 7.
That's what I said. So, yes, next.
Cell number 79.
Before the petition. My lord, husband's special rights of the daughter. Respondent wife has filed a petition seeking divorce. In that petition, my lord, husband has sought for the visitation rights. Your lordship would get the application at page number 65, annexure D.
50?
65, annexure D. I'm so sorry, 68.
I think it is 68.
60.
Interim order is at 29, I think.
No, the order. There is a point about lordship, the application which I have filed.
68.
They don't. To the kindly see the prayer made. For the reasons forth to the accompanying affidavit, it is humbly prayed that this honorable court may please to permit the respondent and his parents to visit the minor child Ira every Sunday between 10 to 3 p.m. at the mediation center. Joshua kindly note at the mediation center, Bangalore under the supervision in the court of justice. I am not
able to see the prayer. Where is it?
Well, this is the page number 16, again number 7. After this passport of the.
No. What is the difficulty in granting a supervised registration before the mediation center with the grandparents and everything is monitored by somebody?
I'll convince your lordship if my learned friend has concluded. I'll convince your lordship if your learned friend has concluded.
Yes.
But the reason.
I understand. Let him.
Very well.
Your lordship will require some context in this case, my lord. Your lordship may kindly turn to the impugned order at page number 29.
Yes.
In this impugned order, my lord, your lordship may kindly turn to page number 30, the internal page number 2. There's a common order on IA number 6 and 7. One of those IAs is for stay of proceedings, pending adjudication of the POXO case filed against him, in which the victim is this very same child, his own daughter. Now, he has sought a stay of these proceedings in the family court. IA number 7 is for visitation. Now, the
Stay of proceedings we are not pressing.
not pressing, now he is not pressing.
No,
Whatever
whether
it is.
it's pressing or not, we will not grant.
My point is that there was no urgency all this time. There is no urgency at all. The idea is to stall all proceedings everywhere so that some mini trial is conducted somewhere.
This is not. No proceedings are stalled by this court till now.
No, Milord. No proceedings have been stalled, but the idea behind all of this is to stall proceedings.
So number one,
Now-
seeking stay We will not
Let me give
grant.
some context, Your Lordship will need the context. Now, this child is his own daughter. She has been abused sexually by the petitioner herein.
What is the age of the child?
The child is now aged 9 years.
When that alleged incident has happened?
That incident has happened in 2022.
Date?
That FIR, my lord, will find at page number, annexure in my paper book, my lord.
You can give the dates.
My lord, the date, one minute. I will pass on to your lordship. May I pass on this dates and events, my lord?
Take that. Yes.
Your lordship will find that the FIR has been registered on page serial number 12, 24/8/2022.
I was under the impression that there are abuse, I mean, he is an accused in a POXO case, not against the child.
Against the child. He is an accused in the POXO case against the very child. And it is now this very same child who is now sought to be handed over to him. What messaging will be sent this child?
Not seeking for handing over.
In any
I
manner.
said at mediation center.
No.
rather than visit.
One minute.
His
No,
bail
no.
modification order has also been
Now the
rejected.
trial is pending.
Yes.
Trial is pending. You
Yes.
are an accused.
Yes.
She is the victim.
Yes.
Alleged victim. So what is the purpose of the accused talking to the child and having an interaction with her pending these proceedings?
But for that. the
She is a
answer
witness in this case.
Let him say. Yes.
Answer is this, merely a person that is accused will not deprive him of his right of child, my lord. Therefore, in fact, in one case, where your lordships.
That is a different case.
No, in that case, I appeared for the very same accused, there was an acquittal, that acquittal was confirmed here. In the meanwhile, my lord, 12 years he was not able to see the child. There is one such case, your lordship, you kindly see the complaint, is very clear, it's a fabricated false complaint. Because the reason that this petitioner, sorry, responded, she was earlier married in US, she did not disclose it, she came here, got married to the petitioner, and once he came to know about this crime committed by the wife.
Complaint is in English or Kannada?
It's in
English, my lord.
Let's read the complaint.
Please, my lord. It is so artificial.
May I
Several
request?
cases, at least as of now, my lord, I'm appearing for the accused in minimum 11 cases.
Yes, but this
Out
is
of
not
which-
in this case. My learned friend has made this submission several times.
One second.
I'm appearing in 14 cases, 15 cases. It is not this case.
Let me complete
It is
the
not,
case.
it is not
Let me
material to
complete.
this case.
In fact, in the criminal case, he also appeared.
Please wait. Let him complete. You
In the
get
criminal
your turn.
case, he also appeared.
For the court, where is the complaint?
And in his objections,
Yes.
Page number
page
73.
73, man, in his objections. May I, my lord?
Don't have to read. I'll read.
There's such an objectionable, insensitive, what is having made.
The tablets are seized by the police.
Yes, my lord, seized. She has, this child has deposed before, has confessed to the psychologist. She has confessed to child welfare committee, to the police, to the magistrate. My learned friend treats her like as if she's a sociopath, she will tell lies 5 times to 5 different authorities.
He's putting words.
No. This is the way the child is treated. She has deposed consistently. I will point out in my objection statement in the annexures that she has deposed consistently before all of these parties. She is not. She is too small to be tutored, to depose, to confess this. She is a victim. She is the victim, and the affidavit in support of the application says that my daughter will forget me, therefore I should have access to her. She will never forget him. She will never forget this man. Kindly turn to page 75, unnumbered paragraph number 4, my lord.
Next, what is that?
Page 75 of the complaint. Yes, my lord. Then kindly turn to, before this, my lord, kindly turn to page number 59. Your lordship will find at page number 59 are the psychologist's notes. Now, what has happened is that we have been seeing a certain change in our daughter's behavior. Therefore, we decide.
Let me look at it.
Yes, my lord. We consult the psychologist. Her notes are very telling, my lord. Page 59, 3rd August, my lord, onwards.
Yes.
My lord, then your lord, may I invite your lordship's attention to page number 161 statement at page number 100, my lord. The translation is at page number 100. Does your lordship have? The last two questions, my lord. Why is he bad?
Yes.
Then, my lord, I draw your lordship's attention to the charge sheet. This case, there's been two charge sheets, original charge sheet and the additional charge sheet, because he tampered with the evidence. Page number 119 is the English translation of the first charge sheet. At page number 121 is the list of witnesses, my lord. 121. Witness number 2 is the subject personality of this writ petition. My lord. He tampers with this charge sheet. I'll come to that in a while. At page number 127, my lord, your lordship will find his bail order. Does my lord have it? 127, his bail order. The conditions of the bail are at page number 135. At the foot of the page, conditions, page number 135. Condition number 1, petitioner has to execute personal bond for rupees 1 lakh and to furnish one solvent surety for the like sum to satisfaction of this court. His solvent surety was his own father, who is now sought to be portrayed as an innocent person to whom the child must now be handed over to in a supervised visitation. Condition number 2, the petitioner shall not tamper with any of the prosecution witnesses, either directly or indirectly. She is a prosecution witness. The prayer is to hand her over to them, either to his father or to the petitioner himself. Kindly turn to page number 137, my lord, annexure number 9. This is the order passed by this honorable court in which the court finds not 1, not 2, but 9 lacunae, my lord.
What is this petition?
My lord,
This petition is for what?
this petition was filed because he tampered with the charge sheet. Therefore, we came up.
I'm sorry.
No, it may be false to him, but this honorable court has given a finding.
It's not the way to
No.
submit. I'm so sorry. We are before the Honorable High Court of
Yes,
Karnataka.
this honorable High Court has passed this order.
Particularly the way to submit. They sought for further investigation.
Yes.
So it is not tampering of the witness. Let him not get into the shoes of his client and try to
No.
submit as the client is submitting.
I know how to submit. I don't need to learn courtcraft from my learned friend.
Let him
Kindly
come on
turn.
record.
Kindly.
Let him file an affidavit, my lord, if there is a tampering of witness.
I will.
I will answer that.
I will.
I will answer that when it proves that there is a tampering of witness. Let him not submit whatever he want to. He sought for a further investigation, and this further investigation in my favor, which I am going to point out to your lordships, which proves his innocence.
Yes. I request your lordship.
Where is charge sheet?
The charge sheet is found at page number 137, Miller. Sorry.
187.
103 is the charge sheet.
103?
Is the first charge sheet.
No, second.
The second charge sheet is found at page number. The lordship will find it page number 171. Typed copy, your lordship will find in page number 179.
$179 is the
Typed copy, my lord. Translation at page number 187. But before we go to the charge sheet, my lord, I request your lordship to turn to page number 147 of the judgment of this honorable court, and the reason for which the additional charge sheet was filed. Page number 147. At paragraph number 10. A statement of the victim. Does my lord have it? A statement of the victim was video recorded as obtaining under section 26(4) of the Act. The statement of the victim clearly named the accused. This very statement, which forms the fulcrum of the allegation, is not part of the charge sheet. The video was recorded on 24/8/2022. This is the first rung of lacuna in the charge sheet. A statement of the child under section 161 CRPC was recorded on 25/8/2022. It contains only a brief account of what was stated by the child. The investigating officer has deliberately ignored incriminating material against the accused as a truncated statement under section 161 CRPC forms part of the charge sheet. This is the second rung of lacuna. The investigating officer, though collects a report of medical examination of the child from St. John's Hospital, it is not made part of the charge sheet. The report was in the nature of questions put by the doctor and answers given by the child. This is where the child tells the doctor what has happened. It is the case of the petitioner that the child has categorically stated before the doctor that her father accused would touch her in the private parts and behaved inappropriately with her. This is not part of the charge sheet. This is the third rung of lacuna. The investigating officer has not recorded or conducted inquiry with the petitioner as to whether there was any proof to substantiate the allegations made in the complaint which became a crime. This ought to have been done, as it was the duty of the petitioner to substantiate the allegations made in the complaint. The further statement of the complainant was not even recorded. This is the fourth rung of lacuna. The investigating officer was made aware that the child pornography and nude videos of the child were in the laptop of the accused, and he was using 2 mobile phones for the said purpose. Neither the laptop nor the mobile phones are even seized by the investigating officer.
What I was asking.
Yes, Mala. They were seized only subsequently, and he comes to the police station in ceremony.
Kindly, your lordship may turn to.
No, let me go through. No, I'm still submitting. He cannot interrupt me like this.
My lord is
The investigating officer was made aware that the child pornography and nude videos, what is inconvenient to him is cannot just be glossed over. No, it's here as a part of the record. I'm not avoiding anything. It's right here. Why would I produce it if it is against me?
So when this electronic devices.
Your lordship can turn to 138 one. Your lordship will get the answer there only.
130?
138 of my petition. It will clearly proves why he is avoiding to point out that and the falsity of this entire case.
Let's.
Please, members. And at their instances, further investigation was conducted. This honorable High Court directed the conduction of
Let's see this 138.
Please, 138. Their allegation is that pornographic materials were found in the electronic devices. Your lordship can be seen. Once your lordship got that 138 page, yes. This is the test report, FSL test report. One sealed paper packet contains iPhone model number so and so, IV number so and so. Your lordship can turn to the results of examination, the next page. Page 139. Page 139.
Yes, 139, it says the keywords.
Not there. And later, it only not that much. Next page 140. It is the laptop of the petitioner. Just can you turn to page 140. And 140 is the result too. There are no web history of artifacts related to porn videos or sex. Will be sorry, there is absolutely nothing.
Yes.
To answer this very specific allegation, I request your lordship to turn to page number 263 of my paper book. Annexure 15. This is found on the iPad that he exposes to our daughter.
260?
263, my lord. It's a fold-out page. This is his web browsing history. This is in the month of 18th of April of 2022. First page, page number 263. Does my lord have it?
3.
Page number 264. Visited family therapy XX. Page number 265.
Professor has said no. He wants the lordships to have a look at this.
No.
When the entire machine
This
was
is
given
a
to the
revision petition from a family court order. We are in the family court, we would be on balance of probabilities. Before a POXO court, he would be on reasonable doubt. And there is a presumption of when the Supreme Court says that when a child has deposed as she has done here, there is a presumption of guilt. He has to cleanse himself of that first. He can't claim as a matter.
Where from you got this?
My lord, this is from the device that he gives to my daughter that is logged in under his name. So what he browses, my daughter sees. He has logged into this device under his name and under his email ID. Which email ID he admits.
No. Just know what is the report that is seen with regard to.
He has given a laptop and he has given a mobile phone months after he has had enough time to cleanse them out. That's number one. This is
That can't be revived.
This is.
It can be revived.
Can't it be revived? Even if somebody may delete it, but the browse history, when it is given to the forensic,
Yes.
can't they remove?
We will make an application. I'm not prosecuting that case. A special PP has been appointed in that case. they will make the application. But right now, my lord, this is the evidence that we have, and this is what we have submitted in the family
This
court
is
also.
No,
This
your-
is from the
your-
iPad
your-
that he gave to the
Your
child.
daughter's iPad was not seized.
My lord, it has been seized. It has.
So what is the report on that?
My lord, I don't have that report, my lord. But this is what we have from the iPad itself.
Please come. You want to submit anything?
Yes, my lord, I have a judgment that I.
No judgments are required in this. You want to submit anything?
Hello?
You want to submit anything?
These members, because he is trying to convert this honorable court as a criminal trial court.
No.
He is doing that because he is squarely pointing out the materials produced in the criminal court. But that is a separate issue altogether, which in the event if I try to get into that, I would be destroying my evidence, rather my defense, which I will not do so. Where, my lord, you should kindly see the complaint itself. It is so improbable. And there is no clear-cut allegation, but for the speculation. All speculation, my lord. There is, in fact, that Pascal case where your lordship is also interfered. Similar typical cases, almost similar allegations, all speculation. Same, I mean, the age of the child was almost the same. And that will be see, he walked out. And then after 10 years, he was able to see the child. Same thing will happen. And the lordship kindly saw the.
May I invite your lordship's attention to the judgment of the FTSC court, order of the FTSC court rejecting his bail modification. So even that.
How is it related?
It is related because he's asking for a witness to be handed over to him, for the child to be handed over to him.
Agreed with orders passed in.
Aparna Bhatt's case is also.
6 and 7. In MC number 3654 of 2020.
My lords are adjourning or passing the orders, my lord?
I'm passing the final order.
My lord, then I have to have a couple of judgments also. Because,
Pass on.
and ultimately, my lord, Dr. may kindly see, initially I pointed out, I am not seeking for the custody, which is trying to say I seek for the custody. Me and my parents, that is what my parents, my lord. They cannot divorce the child from the love of the father and the grandparents, which is trying to do. And he is trying to drag all the criminal materials into this case, my lord, which is not available. And it's a matter which has to be proved beyond all reasonable doubt there. And his own words, probability, my lord. And probably his materials are turned to be false. His main allegation was that electronic media devices, and at least in an instance, the matter was further investigated. Evans has very clearly said that there is absolutely nothing as such. Then his main fulcrum of the allegations is gone by. In such a case, when there is a serious doubt in the case of the prosecution matter, based on that one boxer, my humble submission is, father and the grandparents cannot be denied even to see them. And Lordship can just see the prayer, they are now seeking the custody. In the mediation center, they want to see the child, that's all. Under supervision. And I will want a couple of judgments.
My lord, to answer this, may I answer this?
What is that?
My lord, he says that his parents have not seen the child. May I pass over to your lordship? It is his there is an FIR at page number 195, annexure 11, that has been filed against the petitioner herein for stalking the child and for stalking the respondent.
Your Lordship, I take serious exception on this.
You may take.
Stalking the child.
Yes.
I request this honorable court to kindly record this, and I will initiate whatever procedures has to be initiated.
Yes.
My lord, fast submission has to be made, no doubt about it. But this range.
Kindly turn to page number 203.
I'm sorry, my lord. I'm really sorry.
Kindly turn to page number 203.
Submitted in the High Court.
Kindly turn to page number 203.
My lord, may kindly see.
This is the complaint. An FIR has been filed. A charge sheet has been.
I'm on that stalking the child.
Yes.
Very clearly said.
Please give the judgments which you are relying on, Mr. Counsel.
Please, my
lord. I'm also relying upon this, my lord. This is.
All that not required.
My lord, it is his own father who has engaged a detective agency to stop
My lord, again another false submission.
Yes, it is here.
Blank false submission.
It is right here, my lord.
I'm very sorry.
Kindly have a look at it. No. I will file it. If required, we'll file it on affidavit, but kindly have this. Kindly have a look at it. Just glance at it. Just one glance, your lordship, to see to whom it is addressed. It is the grandfather. It is not just some whimsical thing that we are saying. Kindly have a look at it.
Yes, give the judgments.
Too many false submissions.
No. Kindly have a look at this. It is a.
I will take your submissions for granted. Yes.
Because he wanted to know, husband wanted to know about the child. And Drug abuse is also there, my lord, against the wife. I will not get into that. Like him, I'm not going to make any false submissions. So he had engaged for surveillance.
That is not
That is not
part of
subject
the.
They are
matter.
witnesses.
That
That
Why
is
is he
not the subject
surveilling
matter.
them?
Please give those judgments.
But it seems to have given it on 3-9, not the matter. Hello, this POXO 498A, which was the benefit of the society, might have been grossly misused and abused.
There are no judgments here.
I have another one. And one more submission. He pointed out certain loose sheets saying that it is from a psychological evaluation. That cannot be considered as a loose sheets. Section 34 of the evidence is very clear. A loose sheets cannot be considered.
Yes.
What is Jessica Sabo's case?
Paragraph number.
22, my
Paragraph 22.
please. Madam. Not to get it, madam.
Yes.
A child, especially a child of tender years, require love, affection, custody, protection of both parents. This is not only the requirement of the child, but is his. This is not a requirement of the child, but is his/her basic human right. Just because the parents are at war with each other does not mean the child should be denied of the care, affection, love, or protection of anyone of the parents. A child is not an inanimate object which can be tossed from one parent to the other. Every separation, every individual will have a traumatic and psychosomatic impact on the child. Therefore, it is to be ensured that the court weighs each and every circumstance very carefully before deciding how and in what manner the custody of the child should be shared between both the parents. Even if the custody is given to one parent, the other parent must have sufficient visitation rights to ensure that the child keeps in touch with the other parent and does not lose social, physical, and psychological contact with any of the two parents. I stop it here. And in the next case, my lord.
Yes. Which paragraph you are relying on?
Next case, that is Abhay Manohar Pal, where again is a allegation against the husband was pops up. That is-
Paragraph number?
But paragraph 4.
Yes.
Per contra, this is Sarvate Lawyer case for respondent number 2 submitted the pendency of criminal proceedings under POXO Act dissented the petitioner from paying custody of the daughter, his daughter. He submitted the sessions court as several grounds raised in the appeal and therefore suspend the order of handling the custody of the mother has been passed. So POXO was there. This order was challenged. Now you'll also be kindly turn to page para 13. Para 13, after considering the paragraph which I referred in Yashika Sahu's case number. In para 13, in the light of the aforesaid judgment, in my opinion, mere filing pendency of a case under POXO Act against the petitioner is not sufficient to deny even visitation rights to a natural father. You not got it, madam?
I've seen that.
Yes, madam. And this was taken to Supreme Court. This matter was taken to the Supreme Court, and Supreme Court did not interfere. And ultimately, the father got the visitation rights, not the custody. Now, differentiating between custody and visitation, and your lordship. And the next is as regards the para 10, madam, the case of Chandramohan, para 10. This case has shocked the conscience of this court, and it is unbelievable that the mother, just for the sake of taking custody of her child, can go to the extent of making such serious allegations as well, alleging that he is a physical contact with his own daughter. Yes. And then your lordship was kind enough to interfere and grant the custody of the child. And in that case, your lordship can turn to para 6. This was a highly contested matter, became a national issue. And para 6, last 2 lines. This generally happens in all cases where the children are staying with one of the parents. This is the constant complaint that they are uncomfortable with the father. Meeting the father is not something the child has to do when he has no other one. For physical, psychological well-being and evolve as a good human being, he requires to have the love and affection of both the father and the mother. Unfortunately, in this tough fight between father and mother, the children are facing these kinds of situations, which is the gap between them. in the process of satisfying the parent with whom they are staying, they are coming up with these kinds of answers that they are not comfortable. This court, while assessing parents' marriage, jurisdiction is more concerned with the welfare of the child. But this case is, the present case is similar level. All false allegation leveled. Anyway, before the criminal court, it has to be established who is innocent. I will not get into that. As of now, my humble submission is, he is not asking for the custody. All he is saying is, in the mediation center, let it talk. If there is an objectionable, my lord, then they have every right to object. Let there be a chaperone, let there be one registrar sitting over there. Mere tendency of the criminal case, let it not be deprived, made as a weapon to deprive the father and daughter or grandparents. At least grandparents, for them also he has no, I mean, we should not have any objections. These are making false allegations. The tampering of the witness. My lord, there is no tampering of the witness. They sought for further investigation, and that practical has exonerated him, my lord. Practical is exonerated with that report, my lord. That anyway, a separate aspect in the criminal court. Here, my humble prayer is, Lord, let there be some connectivity between the father and the daughter, grandparents and the granddaughter, and that too with the premises of mediation center.
May I pass over for your lordship's consideration?
Writ petition dismissed, order will follow. Yes, next station.
Cell number 80. Cell number 80. Bharat K. Petitioner Suresh Manjunath BS.
Appearing for petitioner, your lordship. We are withdrawing the petition, your lordship.
Respondent number 2, my lords.
Appearing for respondent number 1, my lords.
The writ petition is filed seeking the following prayer. On 30/10/2025, this court has passed an order. There is no order in this. Just leave it. There is no interim order passed by this court, and the matter came up today. The land counsel the petition had filed a memo seeking to withdraw the writ petition as not pressed. Memo is taken on record and dismissed as not pressed. Yes, completely.
Sorry, madam. Sorry, madam. Last 2 days back, madam, one matter is reserved for the order. We are producing the written argument.
Huh?
Written argument.
No, it's over. Already I've dictated. It's coming tomorrow. Tomorrow it will come. It's coming for pronouncement.
ಮೊನ್ನೆ ಕೊಟ್ಟವಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ 2 ಹಾಕಿದ್ರಲ್ಲ 141 ಇದೆಯಲ್ಲ
Capilla ಮಾಡಿ.
ಹೌದು
So dismissed reasons followed, dismissed as not pressed. Memo filed.
ಎರಡು ರಿಸ್ಟೋರ್ ಮಾಡಿಸ್ಬಿಟ್ರ ಮೇಘನ
Dismissed as not pressed. ಇದೆಲ್ಲ ಡೇಟ್ ಮಾಡಿಸಿದೆ ಸರ್. ಬ್ರಾಂಚ್ ಕಳಿಸ್ಬಿಟ್ಟು ಯಾವುದೇ ರಿಪೀಟ್ ಕೊಡಬೇಡಿ.
ಚೇತನ ನನಕ್ಕೆ ಕೊಟ್ಟವರು ಅವರು ಅವ್ರ ಹೆಸರು ಬರ್ತೀನಿ.
ಯಾರು? ಸ್ಮಿತಾ ಹೌದು. ಮಹೇಶ್ ಮಹೇಶ್ ಏನೋ ಅವರು ಅಡ್ವೊಕೇಟ್. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲ ಅವರು. ಮಹೇಶ್ ಅಂಡ್ ಕಂಪನಿ ಅಂತ ಬರ್ತಿತ್ತಲ್ಲ ಅವರಲ್ವ ಇದು? ಮತ್ತೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲ ಅವರು. ಒಂದು ನಂಬರ್ ಇದೆ, ಕಾಲ್ ಮಾಡಿ. ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಎಲ್ಲ
ಲೊಕೇಶನ್ ಹೋಯ್ತು, ಅದು ಫೈಲ್ ಹೋಯ್ತು ಸರ್ ಅವ್ರಿಗೆ ಟೈಪ್ ಮಾಡಕ್ಕೆ ಚೇಂಬರ್ಗೆ. ಅವರು ಬೇರೆ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಬಂದು ಕಳಿಸ್ಬಿಟ್ಟು 3:45 ಒಬ್ರು ಇರ್ತಾರೆ ಆಳ್ಕೊಂಡವ್ರು.
ಏನಂತ
ಫೈಲ್ ಮಾಡಬೇಕು. ಅದೇ ಇವ್ರು ಲೇಟಾಗಿ ಬಂದ್ರು ಇವರು. ಹೋಗಿ ಯಾರು ಇಲ್ಲಿ ಎತ್ಕೊಂಡು ಹೋಗೋರಲ್ಲ, ಫೈಲ್ ಇಟ್ಟಿದ್ದೇನೆ ಹೋಗ್ತಾ ಇರ್ತದೆ ಅರ್ಧ ಗಂಟೆಗೆ ಒಂದ್ಸರಿ ಟೈಪ್ ಮಾಡ್ಲಿಕ್ಕೆ. ಚೇಂಬರ್ ಇರ್ತದೆ ಅಲ್ಲಿ.
ಚೇಂಬರ್ಗೆ ಅಲೋ ಮಾಡಲ್ಲ ಸರ್. ಏನ್ ನೋಡ್ತೀರಾ ನೀವು? ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ನಿಮ್ಗೆ ಪ್ರೊವೈಡ್ ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದೆ. ರಿಜಿಸ್ಟ್ರಿ ಟು ಪ್ರೊವೈಡ್ ದಿ ರಿಪೋರ್ಟ್ಸ್ ಟು ಬೋತ್ ಆಫ್ ದಿ ಕೌನ್ಸಿಲ್ಸ್. ನಿಮ್ಗೆ ಅವ್ರು ಕೊಡ್ತಾರೆ, ಆಫೀಸ್ನವರೇ ಕೊಡ್ತಾರೆ ಸರ್. ಆರ್ಡರ್ ಆಗಿದೆ.
ಯಾವತ್ತು ನಾಳೆ ತಗೊಳ್ಳೋದು ಮೇಡಮ್? ನಾಳೆ
ಆರ್ಡರ್ ಆಗಿದೆ, ಫೈಲ್ ಆಗಿದೆ, ತಗೊಳ್ಳಿ. ಆರ್ಡರ್ ಶೀಟ್ ಟೈಪ್ ಆಗಿ ಬರ್ಬೇಕಲ್ಲ. There is an order to provide the mediation report to both of the parties.
ಮೇಡಮ್ ಇನ್ನೊಂದು ನಂದು ಮೊನ್ನೆ 4ನೇ ತಾರೀಕಿತ್ತು, 11ನೇ ತಾರೀಕು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ನೀವು ಒಂದು RPFC ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಕೊಟ್ಟಿದ್ರಿ. 11ನೇ ತಾರೀಕು ಮ್ಯಾಟ್ರ್ ಬಂದಿಲ್ಲ ಮೇಡಮ್ ಲಿಸ್ಟ್. ಆಮೇಲೆ ಏನಾಗಿತ್ತು ಮೇಡಮ್? ನಾನು ಹೋಗಿ ಆಫೀಸಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದೆ ಇವಾಗ. ಅಲ್ಲಿ ಅವ್ರನ್ನ ಕೇಳಿದ್ರೆ ಮೇಡಮ್ ಇದ್ರಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ಸರ್, ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ.
ಎಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ಅಂದ್ರು?
ಇದ್ರಲ್ಲಿ ಏನೋ ನಮ್ಮ ಯಾವ ಬ್ರಾಂಚ್ ಅದು ಅಲ್ಲಿ ಇದು ಕೆಳಗಡೆ ಫೈಲ್ಗಳನ್ನ